memos. Any adjournment? List 2, page 4, serial number 15 to 21.
Serial number 11, my lordship. List number 2.
Into 21.
Lord, serial number 21.1, my lord. I filed my NOC Vakalatnama today, my lord. Pray for a short accommodation. 21.1.
Who is for 2021?
For 21,
Yeah.
21, I see better.
You are for the petition.
Yes. I'm for the petitioner in 21.1.
So you are for the. Mr. Suyog,
I filed NOC Vakalat, my lord.
ಹೆಸರು ತಗೊಳ್ಳಿ. So give me your name. So and so submits that he has filed wakalat for the petitioner today. And so this is directed to delete the name of so and so, anything and so and so. And counsel for the petitioner prays for time. This time, next. Yes.
Page 5, serial number.
Interim order may be extended.
Hmm?
There's an interim order in the matter, my lord. It's the same
Matter
matter.
is to extend.
Both matters.
Yes.
21 and 21.
ಎರಡರಲ್ಲೂ 21 and 21.1 ಎಲ್ಲಿದೆಯೋ the next one. Yes.
Page 5, serial number 22 to 29.
Your lord, your ladyship, serial number 22. Your lord, yesterday a memo was moved for this matter to be posted on 12th. However, invariably the matter has been posted today. The arguing counsel has traveled to Mangalore for to attend a funeral, your lordship. Kindly adjourn the matter to 12th.
ಅಲ್ಲ ನಿನ್ನೆ ಮೆಮೊ ಮುಂದಿದ್ದಾರೆ. Already date was given earlier on the previous date of hearing. Why the memo was moved?
Your lordship,
So, serial number 22.
22, 25. My apologies, your lordship, 25. Serial number 25.
ಅವ್ರು 22 ಅಂತ ಇದ್ದಾರಲ್ಲ. Place for time, next.
Page 6, serial number 30 to 31.
Serial number 30, my lords. I am for the respondent in both matters, my lord.
Hmm.
We have filed a memo for posting there. But unfortunately, senior is not well, my lord. He is suffering from viral fever and throat. May kindly have it.
Respondent prays for
May
time.
kindly have it on tomorrow only, madam. The matter may be urgent.
Not be possible, sir. Wait for
The
some.
day after tomorrow, my lords.
Tomorrow,
11,
day after all appeals day. Criminal appeal day.
the matter
Yes.
may be urgent, madam.
They'll give the date ಕೊಡಿ ಅದು. Next.
Serial number is
Madam,
1.
11,
Page 1.
11 or 12.
Lordship, the cause is to serial 16. It is log classified 482, my lords. It's GM police case.
Please.
16.
Cause list to serial number 16.
Ah.
It is log classified 482, my. It's a GM police case, my lords. It is classified as 482. We have not filed it for it. It is GM police case.
GM, Hari. Not 482.
Not 482. GM police.
GM 482.
GM police.
ಪೊಲೀಸ್ ಅದು ಬೇರೆ ರೋಸ್ಟರ್ ಮೇಲೆ ಹೋಗ್ಬೇಕಾ? RAS ನಮಗೆ ಬರುತ್ತಾ? ಬರಲ್ಲವಾ? Counsel for the petitioner submits that the petition is not under section 482 of CRPC. Hence, places before appropriate bench.
Page 1, for non-compliance of office objection for second time, serial number 1.
My lords,
Petitioner-
Number.
this case has been transferred, my lords, to CJM, my lords. By
Transfer
order
to-
dated 2020, my lords.
Transfer to where?
Transferred from senior civil judge to junior division, my lords.
ಆಯ್ತು, ಈಗ ಏನಾಗಿದೆ?
Mandia.
Yes, for the petitioner.
Press time for.
You have no idea.
My lord, kindly pass off.
With a direction to appear before principal
Counsel for
civil
the
judge and
petition,
JMFC
wait
on
for time,
26,
comply with the
2020
office
only, my
observations.
lords.
Then it ASPP submits that the matter is transferred from civil, learned senior civil judge to the senior civil judge to
Junior principal civil judge and JMFC, Mandia.
learned principal civil judge and JMFC, Mandia. The petition is of the year 2020. Till date, the objections are not complied with. And counsel for the petitioner has no idea about the the stage at which the trial court is dealing with the matter. List finally as a last chance. Next.
Serial number 2, Jagan Mohan MD.
Absent, no representation.
Non-compliance for third time, serial number 3, N Kiran.
Absent, no representation. Petition is of the year 2020. Matter is listed for the third time for compliance of subjections till date. No, there is no progress in the matter.
4th,
Finally, as a last chance.
Mohammad Farooq.
Acquitted, my lords, on 28/2024. Accused number 1,
The
2,
petitioner
5,
has
7, and
publicly
8.
submitted the accused in the criminal case are already acquitted by the trial court. Submission is placed on record, petition dismissed as the same is rendered infructuous. Next.
5, Pratik HC.
Absent, no representation. Finally, as a last chance. Allah full court.
Non-compliance for 4th time, serial number 6, Bimbadar HM.
Counsel for petition.
This is also transferred, my lords,
Absent, no representation.
to principal civil judge and JMFs.
This, the matter is listed for the 4th time for compliance of office objections. Order sheet dated 2024 reads as under, in spite of that, there is no progress made in the matter. Petition dismissed.
Serial number 1, for further hearing, Manjunath MV.
It is urgent. Why it is urgent?
What's the total is 6 files are missing. Page 18, my lords, from bottom 6th line, column number 10. Allegations are leveled against the present petitioners, my lord. Page 18, column number 10, bottom 6th line, from 6th line.
Also,
Serial number 2, Venkatesh Somareddy, Swaminathan.
May it please, my lord. My lord, in this case, I am supposed to argue, my lord, that regarding the procedure. Studying it, I require little more time, my lord. The procedure for grant of pardon, my lord. So what is the procedure to be followed? Because
for grant of,
the commutation of sentence, remission, my lords, remission,
ah,
the procedure to be followed, my lords. Because also incidentally challenged the rules framed by the state government, amended rules. I pray my lord to give me some more time, my lords, because I have challenged the constitutional validity of the rule also by way of amendment. What happened, my lords, when we filed initially the petition, we had not challenged any rule. Subsequently, in the objection, they stated that we have framed new rules, prison rules, my lords, that have been amended. And then therefore we had to challenge that in the writ petition, my lords. Now, prayer in the writ petition is A is, annexure A is the impugned order of granting remission. Annexure R1, my lord, the government order wherein convicted,
You have challenged the rules.
annexure R1, my lord, prayer AA in the amended petition, your lords may kindly see, my lord. Second prayer, my lords. This we came to know only after the objections are filed. We have raised this contention. I beg to raise all these grounds and my lords,
And senior counsel pays for time. Yes, next.
great.
Number 3. Asha Devi.
So my yes has been filed, my lords. There is a, the petition came to be dismissed on 4th November 2019. my
Madam,
lords.
Namaste. I'm the party. My advocate is not feeling well. Request you to give me a date, ma'am.
Counsel for the petitioner is absent, no representation. Petitioner is present and prays for time. This term. Next. Yes,
Serial number.
yes, it is adjourned. You can take the date later.
Okay, ma'am. Thank you.
Serial number 4. Mario Newell. Yes, Raghu Prasad.
Well, in this matter, senior counsel has been engaged, he's having some personal inconvenience, my lord. Any date after 2 weeks, he'll appear, my lord. The other side have filed a retirement memo.
My lords, this has been already filed, my lord. FIR has been challenged. And this has been dismissed by Honorable Justice Suraj Govindraj.
No,
my
no.
lords.
After that, it was released.
Then where is the petition? We have not submitted the petition.
Very
Have you challenged charge sheet?
Yes. No, no. So that charge sheet has not been filed.
Learned counsel for respondent number 228. Filed the member seeking permission to retire from the case. He has produced the returned postal envelope with the endorsement addressed to respondent number so and so. Returned with the endorsement, address you left, returned to sender. Memo is accepted. Counsel for the so and so permitted to retire. Office is directed to delete his name and show the name of the respondents 228 in the cause list. Yes, what is your submission?
My lords, my submissions are, they have challenged the FIR, my lords,
Mm.
and charge sheet has been filed long ago.
Hmm.
And that has been dismissed by Honorable Justice Suraj Govindraj also, my
What
lords, on
is
7th of
dismissed?
September. As the FIR was challenged, charge sheet has been filed subsequently.
Yes.
Hence, the same was dismissed, my lords. And the learned counsel for petitioner has to clarify what he has challenged, my lord, because he is
No, no,
telling.
my lord, what happened? The previous lordship, he had thought that the charge sheet was filed in regards with the accused number 1 as well. It's only filed against accused number 2. So he dismissed it. But then after that, we filed a bespoken memo and he resumed the case last year itself. So the case is going on now, my lord. Senior counsel is unable to come today. Any date after 2 weeks, he will come, my lord. Matter has been going on, my lord.
You are enjoying the interim order.
Interim order, yes, my lord.
I will not extend that.
My lord, next week he will come. My lord, he is only having a personal inconvenience.
Maybe.
Tomorrow tomorrow or day after also, my lord.
It cannot be a Tiber inconvenience. Tomorrow is
Yes.
the appeal day, sir. No,
My lord,
Okay.
my lord, humble request, because
you need not have to request. You have to make a representation and there cannot be any justification for 6 years.
no, not 6 years, my lord. Last, your lordship may see, last time also we have argued. Yes, my lord.
18 petition, 6 years argumentation.
No. What happened, my lord? Last time also we had argued. What happened? The lordship had said the other side, nobody has been coming. Only today, one day he's having a personal inconvenience, my lord.
My lords, direction may be issued to furnish copies, my lords.
The petition is of the year 2018.
My lord, one submission, Your
Till
Honor.
date, there is no progress in the matter,
My lord, one submission.
even though the petitioner is enjoying the benefit of
My
the
lord, one
interim
submission,
order
Your Honor.
granted in his favor.
My
We
lord.
do not find any reason to adjourn the matter. However, to afford.
Your
final
lordship may kindly
opportunity-
pass it over, my lord.
Pass over ಮಾಡಿ ಸ್ವಾಮಿ
However,
ದಯವಿಟ್ಟು.
to afford final opportunity.
My lord, kindly pass over.
Extended only till next date of hearing.
My lord, one submission.
Yes,
Submission. One
yes,
submission.
it is adjourned. Finally, as a last chance,
Much obliged. My lord, interim order may be extended.
ದಯವಿಟ್ಟು ಸ್ವಾಮಿ.
subject to that condition.
Yes.
It will never be
Yes,
extended
madam.
further.
Interim order may be extended.
Last chance. ದಯವಿಟ್ಟು.
Lords, a direction may be
Much
issued to
obliged,
furnish
much obliged.
copies, my lords. I have not received the
furnish,
copy.
we'll furnish.
Member Leonard, additional FPP submits that she is not provided with the copies of the petition with annexes. Counsel for the petitioner undertake to furnish the same in advance before next date of hearing. Yes,
My lord, interim order may be extended.
yes, next.
Obliged.
Much obliged.
Serial number 5, Eldara Basha, petitioner.
Issuance of notice for the petitioner. ಏನಾಗಿದೆ? ಆಯ್ತು. ಹೋಗಿಲ್ಲ. Okay. Court notice ಎಲ್ಲಿ ಆಗಿದೆ? It is stated that the counsel representing the petitioner is already elevated as a judge of this court. Issue court notice to the petitioner. Next.
Serial number 6, Zamir.
Yes, same. Next.
Serial number 7, Balaji Raghunathan.
Appearing for petitioner, Your Honor.
Yes.
We have filed a memo for withdrawal, Your Honor. Kindly it may be permitted to withdraw the matter.
Counsel for the petitioner filed a memo seeking permission to withdraw the petition. Memo is placed on record, petition dismissed as withdrawn. Yes.
Much
Dismissed.
obliged, Your Honor.
Ramesha
Counsel
Viket.
for the petitioner filed a memo seeking permission to withdraw. They need then no. Dismissed as withdrawn. Next.
Serial number 9, Ajesh Kumar.
My lord, appearing for the petitioner in this case, my lord, R2 needs to be served, my lords. I may be granted a week's time. I'll take out steps again, my lords.
Why all these days you have not taken steps?
My lords, Counsel Ajesh Kumar has come on record only in 2022, my lords. Thereafter, before that, just a month before we had come on record, my lords, R2, steps in respect of R2 had already been taken.
22 years have lapsed.
My lord, my lords, if I may just submit, on 14/7/2022, in respect of R2, a process memo was taken out, my lords. Thereafter, I have only come on record on 26/8/2022. Thereafter, the matter has never come up, my lords.
You have to pay PF for issuance of notice.
My lords, that has been paid. That has
When-
already been.
When?
19/1/2024 deficit process fee has already been paid, my lord.
That was returned unclaimed.
My lords,
Unclaimed.
a week's time may be granted. I'll carry it out right away, my lords.
ಇಲ್ಲ, unclaimed ಅಂತ ಬಂದ್ರೆ service sufficient ಅಲ್ವಾ? ಯಾಕೆ unclaimed ಅಂದ್ಮೇಲೆ ಮತ್ತೆ unclaimed ಯಾವಾಗ್ಲೂ sufficient ಮತ್ತೆ ಎಲ್ಲಿದೆ source? ಎಲ್ಲಿದೆ unclaimed ಅಂತ? Counsel for the petitioner prays for him. ಅವರಿಗೂ ಗೊತ್ತಿಲ್ಲ, ನಮಗೂ ಗೊತ್ತಿಲ್ಲ, ಹೋಗ್ಲಿ.
A week's time, my lords.
Yes, next,
The interim order may be extended.
next.
Not the interim.
Served as not unclaimed ಅಂತ ಇದೆ. Unclaimed ಅಂದ್ರೆ ಯಾವಾಗ್ಲೂ services. That is the position of law. Next,
My lords, 1 week, my lords.
next.
The interim order may be extended, my lords.
It is extended, ma.
Great.
How many times you are saying?
Serial number 10, V.S. Sachin.
Petitioner, my lords,
Body.
a week's time to issue process.
Counsel for the petitioner prays for time. PF is not yet filed. Finally, as a last chance of doubt. Even though issuance of emergent notice was ordered as per order dated 25/1/2022, counsel for the petitioner has not paid the BF for issuance of notice. Just finally as a last chance. Next.
Achha.
11. C. Anand.
Petitioner, my lord.
Huh.
1 week time, my lordship. Senior was not keeping bail, my lord.
Why?
1 week time, my lord,
For what purpose?
to hear the matter. Senior is
Why
not,
you are seeking time? What is to be done?
senior is not keeping bail, my lordship.
Sir, what is to be done in this matter? Why it is posted today? What is the stage of the case?
Orders, my lord. Stage.
What you are required to do? Pass away.
12. Arnav Balwadi.
For the petitioner, my lords, we'll need to pay the process fees. We'll do it by today.
Counsel for the petitioner prays for time. The petition is of the year 2020. PF for issuance of notice is not at issue, not at paid till date. I do not find any reason to extend the matter, however, to offer final opportunity. ಅದು ಎಲ್ಲದರಲ್ಲೂ ಇದೇ ರೀತಿ ಫೈನಲ್ ಅಂತ. Yes, next.
13. You know this?
Same, ಅದು same, finally, next.
14. Hearing on IA. Jeevan J. Neralgi. Jeevan J. Neralgi.
Counsel for the petitioner is absent, no representation. A1 of 2024 is filed for recalling the order dated 6/8/2024. In spite of that, there is no representation, hence IA1 of 2024 dismissed. Next.
Serial number 15. Pradeep HS.
For the petitioner, Your Honor, the application is to implead the complaint as respondent number 2. At the time of filing, due to oversight, it was
Third learned counsel for the petitioner on IA1 of 2022 filed for impleading the complainant as respondent number 2. For the reasons stated in so and so, IA1 of 2022 is allowed. Complainant is permitted to be impleaded as respondent number 2. Counsel for petitioner is permitted to carry out the amendment in the cause title and to file amended, carry out the amendment today itself. Next, carry out the amendment.
yeah, I will.
Plenary hearing. Adjourned. 17. Rangnath Reddy.
Counsel for the petitioner is absent, no representation. Yes, what is this matter? What is the stage before the trial court? Any interim order is in operation? No. No interim. Please verify the stage and make submission. Pass over. Pass over.
Serial number 18. Tigri Veeranna. Chidambara.
ಆಯ್ತಾ ಅದು ಕರೆಕ್ಷನ್ಸ್ ಆಗಿದೆ. Corrections ಏನೋ ಆಗಿದೆ ಅದು. Carry out necessary corrections in the memorandum of petition. ಆಗಿದೆ. Counsel for the petitioner is absent, no representation. Yes, in this, what is the stage? 2019 matter,
But there is a stay of the proceedings.
stay in extend ಆಗಿಲ್ಲ.
Question is whether the sanction is done by for filing the.
No interim order is in operation, it seems.
21/1/2020, my lord.
Yes, still disposal of the petition. Counsel for the petitioner is absent, no representation. Petition is of the year 2019. The petitioner is enjoying the interim order granted till disposal of the petition. It appears the petitioner is not interested in prosecuting the petition. However, to afford final opportunity, finally. Next.
Serial number 19, Satish K. B.B. Patil.
With your lordships kind leave, my lords, the crisp issue involved here, my lords, is it's a trap proceeding and the petitioners are calling in question in a 482 jurisdiction on hyper-technical ground is my submission. They say that, my lords, as on that day, the office of the Deputy Superintendent of Police was declared as a police station under Section 2(s) of the CRPC. And in view of the same, their interpretation, my lords, is that it is the DSP alone who is entitled to register an FIR. Whereas in this case, it's the inspector. Other than that, other than this ground, my lords, in terms of the merits as such, it's a clear case of trap where entire trap proceedings have been successfully concluded. Now, my lords, they're placing reliance on a decision of the coordinate bench of this honorable court where I have only appeared, my lords, and I have taken a certain set of grounds. My lords, may please permit me to traverse through the judgment. My lords, I'll read from internal running page number 11, if my lords were to permit me.
All these petitions are allowed.
Please, my lords. But my lords, my contention is I want to espouse the same before my lords. To appraise my lords, my only contention is that
Have
once
you challenged this order?
my lords, as of now, they are in the process of challenging is my submission. Now, my lords, my only submission is that if we read section 2(s) and 2(o), 2(s) provides for the definition of police station under CRPC. 2(o) provides for officer in charge of the police station. And if we read section 154 subclause 154, where the FIR registration power is, it is the subjective satisfaction of the officer in charge of the police station. So, my lords, these entire gamut of provisions of these three provisions, 2(s), 2(o), and 154, if conjointly read, it was perceived or it was conceived to cater to a dynamic situation. An officer in charge is not a DSP alone because he is declared. If due to some reason, if the DSP is not in station, then whoever is the next in charge. That is why, my lords, this has been noted in this judgment. My lords may permit me to read out that paragraph.
Yes.
My submissions were noted. My lords may please have paragraph number, running page number 12, paragraph number 4.
Coordinate bench in this case has relied on the another decision of the coordinate bench.
Please, my lords, and I have also cited two other judgments. That is why I want to read out my portion of it to persuade my lord to toe the line.
Yes.
My lords, ink page number 12, paragraph number 4. On the other hand, learned counsel for the respondent, the then ACB, would submit. The police inspector is also an officer in charge of the police station in the absence of DSP as prescribed under section 2(o) of CRPC. This was my first submission, which is even my submission before this court. 2(s) is a designate officer, and in the absence of him, whoever is the officer in charge is required to register. And there is a negative reading in 2(o), if my lords were to permit. It says not below the rank of a constable. My lords may please permit me to read 2(o). It says, my lords, officer in charge of police station includes when the officer in charge of the police station is absent from the station house or unable from illness or otherwise to perform his duty, the police officer present at the station house who is next in rank to such officer and is above the rank of constable. My lords, I want to read this negative reading into the statute. Above the rank of constable. When the state government so directs, any police officer so present Now, my lords, my case is that in all these cases, we filed the copy of the station house diary, and in some of them we showed that the deputy superintendent of police was going out somewhere for some investigation or something. And at that point in time, automatically, if we read all these provisions together, my lords, 154 also I may persuade my lords to read once. It says, my lords, my lords, every information relating to commission of a cognizable offense, if given orally to an officer in charge of the police station, shall be reduced to writing by him or under his direction. It here also it says officer in charge of the station. 154, my lords. Every information relating to commission of a cognizable offense, if given orally to an officer in charge of a police station, shall be reduced to writing by him or under his direction and be read over to the informant, and every such information, whether given in writing or reduced to writing as aforesaid, shall be signed by the person giving it, and the substance thereof shall be entered in a book to be kept by such officer in such form as the state government may prescribe in this behalf.
Yes.
Now, my lords, my entire crux of my argument is, my lords, in all these batch of cases also, we had filed a copy of the station house diary. In some of them it was available, in some of them it was not available. I should concede, my lords, very rightfully.
Yes.
Here in this case also, my lords, I want a 2 days accommodation to secure, because, my lords, it is the station house diary, the register FIR is registered in 2016. So that 18, my lords, I stand corrected. But the notification prescribing the deputy superintendent as the police station was given under in 2016 when the ACB came in. Now, my lords, once the ACB has left, again it is the inspector, because under Loka Ekta 2S is declared as inspector. Now, my lords, I have also relied on 2 more. My lords, may please permit me to further read this judgment after page number 12.
You are arguing the matter, you are concluding the argument today?
No, my lords, I just want to file one
Don't,
station house diary copy on that day. Of that day, to show that the
What about
DSP
you?
was not available. 2 days.
You are addressing the argument or
My senior will.
then
Any day.
why you are keeping quiet?
That's my senior is held up in court on 3 hours of the
Maybe
opinion.
you should make the submission.
I was of the opinion minutes before my senior finishes minutes.
Counsel for the petitioner and the respondent paper time. Yes, produce it and address argument.
Please take. Deeply obliged.
20, Prasanna Kumar S. Nilesh Krishnan.
Here for the respondent. No, notice was not served on us, but we filed wakalat after coming to know that the writ petition is filed. I don't have the copy of the petition.
Is for the petitioner, Prasanna Kumar.
B report file agide. B report file agide, we have filed protest.
Counsel for the petitioner is absent, no representation. Then counsel for respondent. They have to challenge that. You know, you do Nilesh Krishnan
Yes, my lord, Leela.
submits that he has filed wakalat for respondent number 2. And also submits that he is not served with the copy of the petition.
My lord, B report has been filed in this case, it seems.
Huh?
B report
has
file
been-
agide, we have filed
They have
protest
challenged the
petition.
crime, my lord.
B report is.
B report is filed.
So
The
infractuous.
respondent is challenged, there it becomes infractuous.
So I'll dismiss this.
Yes.
ಅದೆಲ್ಲ ಏನು ಬೇಡ ಬಿಡಿ. Then counsel for the petitioner is absent, no representation. Then at HCGP submits that the investigating officer has already filed B report before the jurisdictional magistrate. Same is accepted.
Yes, madam. No, my lord, they have challenged that. B report.
Protest petition ಹಾಕಿದ್ದೇವೆ.
Okay, they are the complainant.
Yes.
Yes, yeah.
ಅದು ಬೇಡ ಬಿಡಿ. Counsel for the petitioner is absent, no representation. Then counsel Shri Nilesh Krishnan submits that he has filed wakalat for respondent number 2, but has not received the copy of the Petition, counsel for the petitioner is directed to furnish the copy of the petition to the learned counsel for respondent number 2 this time. Yes. Next.
Number 21, Arjun. 22, Deepakar Livingston, Varun Sharma.
Kindly pass on, Miss. Advocate Sandra, on the way, my lord, sir.
Huh?
He's on the way, he's coming. Kindly pass on.
Lordship, I'm seeking a passover on behalf of Varun Sharma, my lord.
Passover.
Please, I'm grateful.
23.
Serial number 21, my lords. We appear for the petitioner.
I think that is already agenda. No? Somebody sought for time.
Please.
Yes.
My lords, I have filed a memo for retirement, my lords. I may be permitted to retire.
Yes. Next.
23, HN Venkatesh.
I appear for the petitioner.
Lord, this matter, my lord, on last occasion, my lord, it was urgent. For the reason that, my lord, ground that, my lord, the powers of the BMTF was not continued. And they had no power on that in the year 2018 to register the crime, my lord. I've got the,
It is
yes,
extended.
my lord, it was extended, my lord. From 2015 to 2019, my lord, it was extended. I have all the notifications, my lord, it's been extended, my lord.
You produce it along with the memo.
Yes, ma'am, I'll produce.
Last time your submission was noted.
So therefore, the judgment clearly applies, my lord. It is of the year 2018. Now she is saying that.
Let her produce it. You
From
along with
2013, my lord, it was
the
extended.
passover, you along
Please,
with
my
the
lord,
memo,
I'll
you
file
produce.
along with the memo.
It may kindly be posted next week. I will verify. I will have a copy of that.
I will take it as you have filed.
I'm told that other co-accused have got quashed the order on the basis of the very same government officials.
Learned HCP filed a memo along with notifications, order.
My lord,
Along with
for extending the powers, along with
the
the
notification issued by the government of, state government, extending the power of so and so. Counsel for petitioner plays for time to look into the notifications and to make submissions on the next date of hearing. This term. Yes.
Serial number 24, Chandrasekhar Rayan.
My lord, in this case, I am told that counsel is not well. He seeks 1 week's time.
Counsel for petitioner, proxy counsel for petitioner prays for time. Next.
Told that there is an interim order in the, maybe
Extended.
extended.
Next.
Number 25, Arjun. 26.
Serial
Vivek
number
Gowda.
24. 24 even. No, it's in serial number 24, respondent number 2 has passed away. Notes. Filing a memo for that.
Counsel for who passed away? Respondent number 2.
2, my lords.
Original complainant.
So Ms. that the respondent number 2 has passed away. Counsel for petitioner prays for time to take steps. Next. Yes, 26.
25, Arjun. 26, Vivek Gowda.
26 for the petitioner.
Shekhar.
Not on the last occasion, the respondent had mentioned that R2 was deceased. We are led by Mr. Holla in the matter, my lord. On the last occasion, Mr. Holla had placed his arguments. The R2 was supposed to report the death of R2.
Yes. Where is the death certificate? Where is the memo? Where is the death certificate? Yaru. Yaru, who is for respondent number 2?
Last occasion, my lord, the respondent had made that submission.
Yes, respondent number 2. Who is representing respondent number 2? Somsekhar.
A.M. Somashekara.
Counsel for respondent number 2 is absent, no representation. Even though the order sheet dated 3/9/2024 reads as under. In spite of that, no memo is filed reporting the death of respondent number 2, nor a death certificate is produced. It appears respondent number 2 is still alive. Yes.
Interim
Just to
order.
address the argument now.
Mr. Holla, Senior Counsel, Mr. Uday Holla is leading us in the matter, my lord. So he'll be addressing the arguments.
He's ready today.
Yes, my lord, I request. My lord is,
I think he has already
he
addressed the
he's already
argument.
addressed his arguments.
Addressed the argument.
Yes, ma'am.
Respondent side. Yes.
It also place a few judgments, my lord.
ಆಯ್ತು ಅದು ಮಾಡಿ ಯಾರು now you have to. Yes, ma'am. Ready? Ready. Yes. ಇದೇನು ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲ ಇಲ್ಲಲ್ಲ. That is insurance policy, is it?
Yes, my lords. Aviva Young
Yes,
Scholar
yes.
Scheme Policy, my lords. It is accused number 3, my lords, who met with CW1 and she told that if the students are going to, instead of taking awards, they are going to invest in a policy. It would be better for their future, my lords, and thereby she is successfully obtained the ID cards, photos, and address proofs of their guardians, my lords. And as the complainant has got so many policies, she has assured, accused number 3 had assured that they will give 3 free policies, my lords. And the charge sheet contents are, my lord, they have neither given the 3 free policies.
No, will it amount to 406 or 420?
My lords, thereby again 36,89,567 rupees they have taken, my lords, that too by way of check, my lords. All the checks.
Was any contract? There was an agreement between the parties?
There was no agreement.
Huh?
There was no agreement, my lords.
No agreement.
Only promise was made to give 3 free checks. Again, that amount of 30 lakhs has been returned.
The promise is breached. The remedy is elsewhere.
Breach of contract.
Yes, there is the question of invoking 406 and 420. Free
But-
policies, can you enforce that?
But by promising at page number,
No, even if
Number
we have
42,
to
my lords.
admit your contention that there was a promise,
please, my lords.
breach of promise, go before the civil court,
Please, my lords.
enforce it. But 406 L ಬರುತ್ತೆ, 420 L ಬರುತ್ತೆ.
But the thing is, my lords, by taking the name of the institute, the accused number 3 has cheated. But as they were giving policies to the students and all, my lords,
That
in order to
that
advertise.
will not amount to cheating. It may amount to breach of, ನಿಮ್ಮ ಪ್ರಕಾರನೇ 406.
406.
How can it be?
The amount that has been transferred, my lords, that has been not repaid, my lords, so 36
Okay,
lakhs 89,000.
Even according to, there was a oral agreement between the parties.
Please, my lord.
If the policies were not issued after receiving the premium amount,
Please, my lords.
the remedy is elsewhere.
Please, my lords.
That is the only allegation, it seems.
That is the only allegation.
Then how can you invoke 406?
That there was a promise and they have not given the policies, my lords, that too 3 policies, my lords. At the first instance, they have received 30 lakhs and repaid it. And on the second occasion, they have received 36 lakhs 89,567 rupees via checks, my lords.
You have evidence of payment, paying the premium amount,
My
enforce
lords,
it.
there is an evidence, checks, my lords. It is in the IVO papers, my lords. All the checks that has been recovered, my lords. And all the guardians of those children who are there, so many checks has been recovered, my lords.
You can proceed before the civil court, not before invoking the penal provisions.
My lords, in this case, not
How
one
can
or
you
two,
apply
my lords.
405?
There are hundreds of students and their guardians that
Maybe
has
there
been
may be
involved, my lords.
thousands, even then. How you can apply 405 of IPC? Criminal breach of trust.
There is
It is a contract, even according to you.
Please, my lords.
Then where is the question of trust?
There is a breach of promise by the
It is
accused number.
Civil court.
3, my lords.
Here it is not a breach of promise. you have invoked. It is not a criminal case. According to you, it is the breach of trust. When there is a contract, there is the question of trust. It is purely bound by terms of contract. Is it not?
Please, members.
Yes. I'll proceed.
Please, members.
Per contra, learned additional SPT. Opposing the petition submitted, right? Serious allegations are made against the petitioner for having committed the offense. The petitioner who are the other two accused? This petitioner is accused number three.
Three, my lord.
Who are the accused number 1 and 2?
1 and 2, my lord. One is the company.
And 2?
My lord, the others are, my lord, one Ramachandra, Utkarsh, my lord, they are officers of the first.
Company.
There are totally 8 accused persons are there. members.
All are officers, employees. Right?
Yes,
Then I think against accused number 1, which is a company. All other accused, either officers or employees working under accused number 1. The accused number 1, to its employees, officers and employees, collected huge sums of amount as a premium, but failed to issue the insurance policy as agreed. Thereby, they have committed criminal breach of trust by cheating. After investigation, charge sheet is filed. Under such circumstances, the petitioner is not entitled for grant of the relief claim in the matter. They use the materials, point for consideration. Respondent number 2 filed the first information as per annexure A, where there is reference to proposal to award insurance policies to the winners of the competition in lieu of cash prize. And it is the contention of respondent number 2 that the accused have collected huge sums of amount in installment as premium towards the insurance policies that are to be issued. In spite of collecting such amounts, the accused have not issued the insurance policy, nor they have given the free policies as agreed. Thereby, they have committed the offense punishable under section 406 and 420 of IPC. The first information produced as per annexure A makes it clear that there was a simple contract between respondent number 2 and the accused number 1 company, represented by its officers, for issuance of the insurance policy for the benefit of the students who have won the awards and identified as the winners of Aviva Young Scholar Secure Policy Scheme under the so-and-so scheme. It is the contention of respondent number 2. The sum of rupees 36,89,567 was paid to the accused in 3 installments, And in spite of that, no insurance was issued.
Insurance policy was issued, thereafter cancelled, payment, my lord, money, everything returned to them.
Yes, anything to say?
My lord, in last year date, my lord, we told that respondent number 2 is deceased, my lord. So filing memo for that, my lord. I was held up in another case, my lord, so I came running. My apologies, my lord.
Where is the death certificate?
But we did not.
Other day you asked to file the memo along with the death certificate. Where is the certificate?
We didn't acquire the death certificate, my lord.
I'll proceed to dispose of.
Yes.
Dispose of it, yes.
On merits, it will be disposed of.
Yes.
Then I. In spite of that, the insurance policy is not issued. Then a senior advocate for the petitioner has drawn my attention to the email dated 11th November 2016, addressed to respondent number 2. Where there is reference to refund of the premium of rupees 3,568,536, 35 lakhs, 68,536 received towards 35 policies along with interest to the tune of rupees 8,17,523, calculated at 9.75% from the date of receipt of premium till 3rd November 2016. The email also refers to difference amount of rupees 22,337 which is already cleared in the year 2014. And therefore it is stated that a total sum of rupees 43,86,059 was remitted through NEFT in the account of Dream World India towards the full and final redressal of the grievance raised by the complainant. A reply is also received for the said.
Yes. My lords, get that on page 3, my lord, next page.
Yes. A mail in reply dated 2nd December 2016 forwarded by respondent number 2 to the accused is also produced for perusal of the court, according to which respondent number 2 had not accepted the settlement as they never demanded back the amount that is already paid. And suggested that they have suffered loss of about rupees 10 crores. And the accused is called upon to make good the loss. Make good the loss. Under such, when the repayment of the premium by respondent number 2 to the accused and refund of the same along with interest up to date is admitted, and when it is the contention of respondent number 2 that he has suffered some loss in view of termination of the contract as agreed between the parties, the remedy for respondent number 2 lies elsewhere, but it will not give rise to in lieu of the penal provisions either under section 406 or under section 420 of IPC. Therefore, I am of the opinion that the institution of the criminal case against the accused is in clear abuse of process of law, and hence the criminal proceedings is liable to be quashed. It is to be quashed against all the accused.
I have no information, my lords. I have,
Huh?
I have to verify about that.
Some of the accused, my lord, they've already filed and then, my lord, it has been quashed.
No, accused number 1 is the company.
Yes,
All others are he's claiming under accused number 1,
accused 1 is already quashed, my lord.
already quashed.
Yes, therefore the company itself quashed, therefore nothing survives, sir.
They are claiming their right under accused number 1.
Correct.
First, criminal is quashed against the petitioner Santa Beda, against her. Hence petition is allowed.
Great.
Now where it is pending,
In the magistrate's court, my lord.
CC number ಏನು ಹಾಕಿದ್ದೀರಾ?
ಬಂದಿದೆ. CC number, my lord, 20686 of 2018, my lord.
It is there in the prayer.
My lord,
Page 40.
please come to, my lord, page 28, my lord.
0686.
Yes, great.
Serial number 27, Pawan Chandra Shetty, Nishit Kumar Shetty.
For the petitioner.
Hmm.
My lord, I have filed one IA before this honorable court, my lord, dated 15/12/2023.
Hmm.
Though my IA 1 was allowed with respect to the, my lord, absolute interim order pleased to granted by this honorable court. The investigation officer, by violating the court order, deliberately filed charge sheet, my lord. That is what I have filed IA, my lord, before this honorable court.
Yes, have you filed objection?
No, that is my like
State-
oral objection one. That
Huh?
has to be,
State
regard
has
to the
to- state
investigation
has to-
officer, my lord, and,
Yes.
Please, my lords.
I will, I'll explain, my lord.
16/10/2020, my lord.
Do you have any objection to this application?
No, my lord, that application, my lord, stay was granted on 16th, my lord. He has filed the charge sheet on 17th, but he has to explain whether he has intimated on 16th with regard to the interim order.
My lord,
My lord,
they
kindly see the application, my lord, charge sheet annexure R7, page number 6, my lord.
Whatever the objections, you file in black and white, since the application is already filed.
Please.
Short accommodation may be given, my lord.
Then
We'll
it-
file objections.
ASPP seeks time to file objections to IA.
Yes.
1 of 2023. Yes, next.
Obliged.
State ಗೆ copy serve ಮಾಡಿಲ್ಲ ನೋಡಿ,
We
IS.
have served, my lord.
Please
This
serve.
It is not in the file.
This is,
ASPP.
my
Kindly
lord,
serve the
I
copy.
have served on dated, my lord, before this honorable court
You
on
furnish
22.
one more copy too.
Please.
ಇಲ್ಲ ಇದ್ರೆ ಯಾಕೆ ಕೇಳಲ್ಲ?
Petitioner is so lucky, man.
Other
Offense
than-
under section 409, 420.
1 minute. Then it ASPP submits that she is not having the copy of IAS so and so. Then counsel for the petitioner undertakes to furnish the copy of the same. So and so pays for that. Yes. ಯಾವ್ದ್ರಲ್ಲಿ? Explain ಮಾಡ್ತಾರೆ. Yes. Yes, what is this?
Malaysia. Offense under section 409, 420, Malaysia. So lucky, Malaysia.
Hmm.
Date of occurrence, Malaysia, 26/4/2016, Malaysia. Date of complaint, 38/2017, Malaysia. Petitioner is working as a postal assistant, Malaysia. They are working in a amount, some amount is.
9/4/20 ಇದೆಯಲ್ಲ.
Please. Temporary,
Delay is not a ground, sir.
temporary misappropriation, Malaysia. That is
Hmm.
allegation.
Even then it is an offense.
He has misappropriated the amount of general public, my lords. He ought to
Al-
have mentioned it in RD ಖಾತೆಗಳನ್ನ misuse.
Say, only one accused,
Only one, I receive, I refund the entire amount, FIR before entire amount. I
not
refund.
exonerate you, sir.
Malaysia.
2,11,000 he
You
has
are working
taken.
as
Working is a postal assistant, Malaysia.
postal
Is a
staff.
Rocky National.
In postal department staff, he was working as.
postal
a staff.
assistant. What is the amount?
2,11,000, my lords.
2 lakh?
11,000.
ಏನ್ ಬರಲ್ಲ, ಅದೇ ಹೇಗ್ ಬರುತ್ತೆ, ಕ್ವಾಶಿಂಗ್ ಹೇಗ್ ಬರುತ್ತೆ?
ಮಲೇಶ್ ರಾಕಿ ಪ್ಲೇಯರ್ ಮೇಲೆ ನ್ಯಾಷನಲ್ ಪ್ಲೇಯರ್ ಮಲೇಶ್ ರಾಕಿ ನ್ಯಾಷನಲ್ ಪ್ಲೇಯರ್ಸ್
ಅವು ಏನು ಬರಲ್ಲ. ಏನು ಬರಲ್ಲ. ಅವೆಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಸಿಂಪತಿಗೆ ಅಷ್ಟೇ. ನೋ, ತಗೊಳ್ಳಿ.
withdraw the petition. Withdraw the petition.
Counsel for the petitioner, after addressing the argument for some time, seeks permission to withdraw the petition as not pressed. Submission is placed on record, petition is dismissed as withdrawn, as not pressed. Yes. Pending a disposal.
Somareddy, Dinesh Kumar ke.
My lord, it's a petition by accused number
Yes.
2. Praying for quashing the FIR, my lord. May I beg to take the honorable court to the
No, who is the
FIR?
petitioner?
Accused number 2, my lord. There are 2 accused persons.
Who accused, huh?
How? 2 accused persons, my lord. Accused number 2 is before the honorable court. My lord, FIR is page number 15. Registered for 468, 420, 506, read with 34 of IPC. Moodbidri police station. My lord, page 19 is the complaint. May I read the complaint with permission?
Yes.
ಅದರೊಳಗೆ accused number 2 is the petitioner. Para number 2. ಜಾಕಿಮ್ ಕೊರೆಯಾ, that's accused number 2. ಅವರು ಕಲ್ಲಮುಡುಕೂರು ವ್ಯವಸಾಯ ಸೇವಾ ಸಹಕಾರ ಬ್ಯಾಂಕಿನ ಅಧ್ಯಕ್ಷರಾಗಿದ್ದಾರೆ. Previous para says this complainant was ಮಾಜಿ ಉಪಾಧ್ಯಕ್ಷ and ಪ್ರಸ್ತುತ director of the management of that society, agricultural cooperative society. Then para 3, that there was ill will between the two on account of certain affairs.
Complainant was the earlier chairperson.
Earlier vice chairman, my lord, and also present director. Present, the accused number 2 is the present president.
Yes. What about A1?
Lordship, I am representing respondent number 2. I may be permitted to read a complaint, my lordship. I may be permitted to read a complaint, my lordship.
1 minute, he is reading it.
Please.
1 minute, who is the?
Accused number 1, my lord, allegation is accused number 1 wrote anonymous letter making.
What is his designation? He
ಏನಿಲ್ಲ.
is not,
ಏನಿಲ್ಲ.
he is not related to the
Not-
cooperative
not
society.
Manager of petitioner number 1, petitioner. The Arun Bhatt is the manager of.
Manager of the society.
No, 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 he's the manager of the petitioner. Because that is in the complaint.
Not connected to the bank.
Manager of accused number 2.
My lord, para 3 says there is enmity. I will not read it for the present, my lords. Para 3, there is enmity between accused number 2 and himself, complainant. Para 4 is the relevant portion. 6/9/2021 ಒಂದು ನೋಂದಾಯಿತ ಅಂಚೆ ಜಾರಿಯಾಗದೆ ನನಗೆ ವಾಪಸ್ ಬಂದಿದ್ದು, ಸದ್ರಿ ಅಂಚೆ ಹಿಂಬದಿಯಲ್ಲಿ ರಿಂದ ಎಂದು ನನ್ನ ಶಂಕರಿ ಬಿಲ್ಡಿಂಗ್ ವಾಣಿಜ್ಯ ಸಂಕೀರ್ಣದ ವಿಳಾಸ ಬರೆದಿರುತ್ತದೆ. ರಿಗೆ ಎಂದು ಮಾನ್ಯ ಮುಖ್ಯಾಧಿಕಾರಿಯವರು PWD ಮಂಗಳೂರು ಎಂದು ಬರೆದಿದ್ದು ನೋಡಿ ನನಗೆ ಆಶ್ಚರ್ಯವಾಗಿ ಅಂಚೆ ಕವರನ್ನು ತೆಗೆದು ಪತ್ರವನ್ನು ಓದಿದಾಗ ಸದ್ರಿ ಪತ್ರದಲ್ಲಿ ಮೂಡುಬಿದಿರೆ ಬಳಿಯ ಸಂಪಿಗೆ ಶಂಕರಿ ಬಿಲ್ಡಿಂಗ್ ಎಂಬಲ್ಲಿ ನಾನು ವಾಸ್ತವ್ಯವಿದ್ದು ನನ್ನ ಮನೆಯ ಬಳಿ 100 ಮೀಟರ್ ಅಂತರದಲ್ಲಿ ಪೆಟ್ರೋಲ್ ಬಂಪ್ ಇದ್ದು ಇದರ ಹಿಂದುಗಡೆ ಒಂದು ರಿಸಾರ್ಟ್ ಪ್ರಾರಂಭ ಮಾಡಲು ಹೊರಟಿದ್ದಾರೆ. ಪೆಟ್ರೋಲ್ ಬಂಪ್ ಮಾಲಕರು ಮತ್ತು ಮಹಾರಾಷ್ಟ್ರದ ಪುಣೆಯ ಭೂಗತ ದೊರೆ ಪ್ರವೀಣ್ ಶೆಟ್ಟಿ ಇವರು ರಿಸಾರ್ಟ್ ಮಾಲೀಕರು. ಈ ರಿಸಾರ್ಟ್ ನಲ್ಲಿ ಎಲ್ಲಾ ತರಹದ ಚಟುವಟಿಕೆ ನಡೆಸುವುದು ಮೇಲ್ನೋಟಕ್ಕೆ ತಿಳಿದಿದೆ. ಮುಂಬೈ ತರ ಅದರಲ್ಲಿ ಸ್ಪಾ ಡ್ರಿಂಕ್ಸ್ ಎಲ್ಲಾ ತರದ ಸಮಾಜಕ್ಕೆ ಬೇಡವಾದುದು ಅದರಲ್ಲಿ ಪ್ರಾರಂಭವಾದರೆ ಈ ಪರಿಸರ ನಮ್ಮ ಮನೆ ಮತ್ತು ಸುತ್ತಮುತ್ತ ಇರುವ ಅನೇಕ ಮನೆಗಳ ಜನರಿಗೆ ಜೀವಿಸಲು ಅಸಾಧ್ಯವಾಗುತ್ತದೆ. ಗೂಂಡಾಪಡೆಗಳು ಸೇರಿದರೆ ನಮ್ಮ ಮನೆಯ ಹೆಂಗಸರ ಸ್ವಾತಂತ್ರ್ಯ ಹೀನವಾಗಬಹುದು. ಮೊದಲೇ ಈ ಮಾಲೀಕ ಪುಣೆಯಲ್ಲಿ ಭೂಗತ ದೊರೆ, ಇನ್ನೂ ನಮ್ಮ ಸುಸಂಸ್ಕೃತ ಪ್ರದೇಶಕ್ಕೆ ಎಂಥವರು ಬಂದರೆ ನಮ್ಮ ಪ್ರದೇಶ ನರಕವಾಗಬಹುದು. ದಯವಿಟ್ಟು ನಮ್ಮ ಸಮೀಪದಲ್ಲಿ ಇಂತಹ ಕೆಟ್ಟ ರಿಸಾರ್ಟ್ ಪ್ರಾರಂಭ ಮಾಡಬಾರದು, ಅದಕ್ಕೆ ನಾನು ಆಕ್ಷೇಪವನ್ನು ಸಲ್ಲಿಸುತ್ತೇನೆ ಎಂದು ಪತ್ರದಲ್ಲಿ ಬರೆದು ನನ್ನ ಸಹಿಯನ್ನು ಫೋರ್ಜರಿ ಮಾಡಿರುತ್ತಾರೆ. ಈ ಬಗ್ಗೆ ನಾನು ಸಂಶಯಗೊಂಡು ಯಾರೋ ಕೆಲವರು ನನ್ನ ತೇಜೋವಧೆ ಮಾಡುವ ಉದ್ದೇಶಕ್ಕೆ ಮತ್ತು ನನ್ನ ಪ್ರಾಣವನ್ನು ಅಪಾಯಕ್ಕೆ ಒಡ್ಡುವ ಉದ್ದೇಶದಿಂದ ನನ್ನ ಸಹಿಯನ್ನು ಫೋರ್ಜರಿ ಮಾಡಿ ನನ್ನ ಹೆಸರು ಸುಳ್ಳು ಅರ್ಜಿಗಳನ್ನು ಹಾಕಿದ್ದಾರೆ ಎಂದು ಪರಿಶೀಲನೆ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಸದರಿ ಅಂಚೆ ಲಕೋಟೆಯನ್ನು ಪರಿಶೀಲಿಸಿದಾಗ ಕಿನ್ನಿಕಂಬಳೆ ಅಂಚೆ ಕಚೇರಿಯಲ್ಲಿ ಪೋಸ್ಟ್ ಮಾಡಿರುವುದು ನನ್ನ ಗಮನಕ್ಕೆ ಬಂದು ನಾನು ಅಂಚೆ ಕಚೇರಿಗೆ ಹೋಗಿ ನನ್ನ ಹೆಸರಿನಲ್ಲಿ ಯಾರೋ ದುಷ್ಟರು ನನ್ನ ಹೆಸರಿನಲ್ಲಿ ಮತ್ತು ಸಹಿಯನ್ನು ಫೋರ್ಜರಿ ಮಾಡಿ ಸುಳ್ಳು ಪತ್ರವನ್ನು ಬರೆದು ಪೋಸ್ಟ್ ಮಾಡಿರುತ್ತಾರೆ. ಸಿಸಿ ಕ್ಯಾಮೆರಾ ಪರಿಶೀಲಿಸುವಂತೆ ವಿನಂತಿಸಿದಾಗ ಅಂಚೆ ಕಚೇರಿಯವರು ಸಿಸಿ ಕ್ಯಾಮೆರಾ ಪರಿಶೀಲಿಸಿದಾಗ ದಿನಾಂಕ 3/9/2021 4:51 ಸಮಯಕ್ಕೆ ಅರುಣ್ ಭಟ್ ಕಿನ್ನಿಕಂಬಳ, ದಟ್ ಇಸ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1, ಕಚೇರಿಗೆ ಬಂದು 4 ಪತ್ರವನ್ನು ಪೋಸ್ಟ್ ಮಾಡಿರುವುದು ಸಿಸಿ ಕ್ಯಾಮೆರಾದಲ್ಲಿ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಸದರಿ ಅಂಚೆ ಲಕೋಟೆಯ ಮತ್ತು ಪತ್ರದ ಪ್ರತಿಯನ್ನು ಈ ಫಿರ್ಯಾದಿಯ ಜೊತೆಗೆ ಲಗತ್ತಿಕರಿಸಲಾಗಿದೆ. This is about A1. So he entertains doubt that he must be the person who has posted it because CCTV shows his images. That's for 3/9/2021. Para 5 says Arun Bhat Joachim Korea ಅವರ ಮ್ಯಾನೇಜರ್ ಆಗಿದ್ದು. ಆತನ ಎಲ್ಲಾ ಕೆಲಸದ ಉಸ್ತುವಾರಿ ಅರುಣ್ ಭಟ್ ನೋಡುತ್ತಿದ್ದು. ಜಾಕಿಮ್ ಕೊರೆಯ ನಮ್ಮ ಬ್ಯಾಂಕಿನಿಂದ ಪಡೆದುಕೊಂಡ ಸಾಲಕ್ಕೆ ಜಾಮೀನು ನಿಂತಿರುತ್ತಾನೆ. ಪ್ಯಾರಾ 6, ನನ್ನ ಹೆಸರಿನಲ್ಲಿ ನನ್ನ ಸಹಿಯನ್ನು ಫೋರ್ಜರಿ ಮಾಡಿ ಪ್ರತಿಷ್ಠಿತ ವ್ಯಕ್ತಿಗಳ ವಿರುದ್ಧ ಸುಳ್ಳು ದೂರನ್ನು ಬರೆದು ಅದರಿಂದ ನನ್ನ ವಿರುದ್ಧ ದ್ವೇಷ ಮೂಡುವಂತೆ ಹಾಗೂ ಇದರಿಂದ ನನ್ನ ಪ್ರಾಣಕ್ಕೆ ಅಪಾಯ ಉಂಟು ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಅರುಣ್ ಭಟ್ ಮತ್ತು ಜಾಕಿಮ್ ಕೊರೆಯ ಸೇರಿಕೊಂಡು, ದಿಸ್ ಇಸ್ ಎಲಿಗೇಷನ್, ಸೇರಿಕೊಂಡು ಪ್ರವೀಣ್ ಶೆಟ್ಟಿ ಅವರು ನಡೆಸಲು ಉದ್ದೇಶಿಸಿರುವ ರೆಸಾರ್ಟ್ನ ವಿರುದ್ಧವಾಗಿ ಸರ್ಕಾರದ ನಾನಾ ಇಲಾಖೆಗಳಿಗೆ ನನ್ನ ಸಹಿಯನ್ನು ಫೋರ್ಜರಿ ಮಾಡಿ ಸುಳ್ಳು ದೂರನ್ನು ಕಳಿಸಿರುತ್ತಾರೆ. ಜಾಕಿಮ್ ಕೊರೆಯ ಅವರ ಬ್ಯಾಂಕಿನಲ್ಲಿ ವ್ಯವಹಾರ ಮಾಡಲು ನಾನು ಅಡ್ಡಿ ಮಾಡುತ್ತಿದ್ದ ಕಾರಣಕ್ಕೆ ಜಾಕಿಮ್ ಕೊರೆಯ ಅವರು ನನ್ನ ಹೆಸರಿನಲ್ಲಿ ನನ್ನ ಸಹಿಯನ್ನು ಫೋರ್ಜರಿ ಮಾಡಿ ಸರ್ಕಾರದ ನಾನಾ ಇಲಾಖೆಗಳಿಗೆ ದೂರು ನೀಡಿರುತ್ತಾರೆ.
Yes.
So he entertains doubt that A1 might have done it because his video is found. Now he further entertains doubt. A1 is the manager of A2, therefore A2 should have also been there. Now my lord, based on this,
Investigation is undertaken?
no, not taken, not
Not yet.
taken, my lord. Investigation is no, that's it, not stay there, not filed.
A1 has not approached this court?
No, none. I am appealing for it.
No, I'm
Illa. A1 has approached, my lord.
What do you say?
My lordship, I may be permitted to read a complaint.
He has read it.
My lordship, page number 18, same.
Page number?
18, my lordship.
Page number of complaint.
18 is the
19,
FIR.
19 now.
9,
19 is 20.
20. Okay.
You go to the
19 is the first page of a
The complaint, my lord.
complaint.
From starting 1990.
19, okay. My lordship, 19. I apologize, my lordship. Paragraph 3, my lordship.
That is the ill will between you and accused
Please, my
number
lordship,
2.
but I'll read out, my lordship.
Yes.
Point out. ಜಾಕಿಮ್ ಕೊರೆಯ ಅವರು ಮತ್ತು ಅವರ ಕುಟುಂಬದವರು ಸುಮಾರು 1 ಕೋಟಿಯಷ್ಟು ಹಣವನ್ನು ನಮ್ಮ ಕಲ್ಕ ಮುಂಡ್ಕೂರು ವ್ಯವಸಾಯ ಸೇವಾ ಸಹಕಾರಿ ಬ್ಯಾಂಕಿನಿಂದ ಸಲುವಾಗಿ ಪಡೆದುಕೊಂಡಿರುತ್ತಾರೆ. ನಾನು ಕಲ್ಮುಂಡ್ಕರ ವ್ಯವಸಾಯ ಸೇವಾ ಸಹಕಾರಿ ಬ್ಯಾಂಕಿನಲ್ಲಿ ಆಡಳಿತ ನಿರ್ದೇಶಕನಾಗಿರುವುದರಿಂದ ನಮ್ಮ ಸೇವಾ ಸರ್ಕಾರಿ ಬ್ಯಾಂಕಿನಿಂದ ಪಡೆದ ಸಾಲದ ಬಗ್ಗೆ ನನಗೆ ಸಂಶಯ ಉಂಟಾಗಿದ್ದು ಮತ್ತು ಅವರು ಕ್ಲಪ್ತ ಸಮಯದಲ್ಲಿ ಸಾಲವನ್ನು ಮರುಪಾವತಿಸದೇ ಇರುವ ಬಗ್ಗೆ ನಾನು ಬ್ಯಾಂಕಿನ ಸಿಬ್ಬಂದಿಯ ಬಳಿ ಪ್ರಶ್ನೆಯನ್ನು ಮಾಡಿರುತ್ತೇನೆ. ಜಾಕಿಮ್ ಕೊರೆಯ ಅವರಿಗೆ ಈ ವಿಚಾರದ ಬಗ್ಗೆ ನನ್ನ ಮೇಲೆ ದ್ವೇಷ ಇದ್ದು ನಾನು ಅವರ ಅವ್ಯವಹಾರಗಳಿಗೆ ಅಡ್ಡಿ ಉಂಟು ಮಾಡುತ್ತೇನೆ ಎಂಬ ಭಯ ಅವರನ್ನು ಕಾಡಲು ಪ್ರಾರಂಭಿಸಿರುತ್ತದೆ. ನನ್ನ ಮೇಲೆ ಹೇಗಾದರೂ ಆದೇಶ ಮಾಡಬೇಕೆಂದು. So my lord, the petitioner was the loan defaulter. He has taken a loan of 1 crore plus more, my lord, including his family members. With regard to that, my lord, I have a document to show that the petitioner along with his relative, they have taken the loan.
Yes.
Now, my lord, the paragraph number 4. ದಿನಾಂಕ 6/9/2021 ರಂದು ನೋಂದಾಯಿತ ಅಂಚೆ ಕಚೇರಿ ಜಾರಿಯಾಗಿದೆ. ನನಗೆ ವಾಪಸ್ಸು ಬಂದಿದ್ದು ಸದ್ರಿ ಅಂಚೆ ಹಿಮ್ಮದಿಯಲ್ಲಿ ಎಂದು ನನ್ನ ಶಂಕರಿ ಬಿಲ್ಡಿಂಗ್ ವಾಣಿಜ್ಯ ಸಂಕೀರ್ಣದ ವಿಳಾಸ ಬಂದಿರುತ್ತದೆ ಮತ್ತು ರಿಗೆ ಎಂದು ಮಾನ್ಯ ಮುಖ್ಯಾಧಿಕಾರಿಯವರು PWD ಮಂಗಳೂರು ಎಂದು ಬರೆದಿದ್ದು ಇದನ್ನು ನೋಡಿ ನನಗೆ ಆಶ್ಚರ್ಯವಾಗಿರುತ್ತದೆ. ನಾನು ನನ್ನ ಅಂಚೆ ಕವರನ್ನು ತೆಗೆದು ಪತ್ರವನ್ನು ಓದಿದಾಗ ಸದ್ರಿ ಪತ್ರದಲ್ಲಿ ಮೂಡಬಿದಿರೆ ಬಳಿಯ ಸಂಪಿಗೆ ಶಂಕರಿ ಬಿಲ್ಡಿಂಗ್ ಎಂಬಲ್ಲಿ ನಾನು ವಾಸವಾಗಿದ್ದು ನನ್ನ ಮನೆಯ ಬಳಿ 100 ಮೀಟರ್ ಅಂತರದಲ್ಲಿ ಪೆಟ್ರೋಲ್ ಪಂಪ್ ಇದ್ದು ಅದರ ಹಿಂದುಗಡೆ ಒಂದು ರೆಸಾರ್ಟ್ ಪ್ರಾರಂಭ ಮಾಡಲು ಹೊರಟಿದ್ದಾರೆ. ಈ ಪೆಟ್ರೋಲ್ ಪಂಪ್ ಮಾಲೀಕರು ಹಾಗೂ ಮಹಾರಾಷ್ಟ್ರದ ಪುಣೆಯ ದೊಗತ.
Yes, he has already read it. Why
Please,
you
my
want
lordship,
to read it again?
my lordship, I'll convince the lordship, but my lordship, I may be
You
permitted to
convince
read.
me, but again reading would.
No, my lordship.
For what
Complaint
purpose?
amendments. They literally attract the offenses, my lordship. My lordship, I would agree that 420 may not agree, but I mean, if 420 offense may not attract my lordship, but 468, 506 and 34 would attract my lordship. Because ಏನ್ ಮಾಡಿದಾರೆ ಅಂತಂದ್ರೆ, the petitioner and the manager, Arun Bhatt, he has forged the signature of respondent number 2.
Who forged the signature?
Manager and the petitioner.
One must forge.
Petitioner, my lordship. Petitioner has forged the signature
I will
of
state it so
complainant.
in the petition.
Please, my lordship, ಅಲ್ಲಿ
Where it is.
Respondent.
ಅವ್ರ petitioner, ಅವ್ರು ಮಾಡಿದ್ದು. I beg your pardon?
Have you stated specifically that it is the petitioner accused number 2 who forged the signature?
Please, my lordship, and also
Where?
there are CCTV footage, my lordship.
CCTV footage showed accused
he-
number 1
Accused number 1.
posting the letter.
Please, my lordship.
Yes.
I'll read. ನನ್ನ ಹೆಸರಿನ ಪ್ಯಾರಾಗ್ರಾಫ್ 6 ಅಲ್ಲಿ ನನ್ನ ಹೆಸರಿನಲ್ಲಿ ನನ್ನ ಸಹಿಯನ್ನು ಫೋರ್ಜರಿ ಮಾಡಿ ಪ್ರತಿಷ್ಠಿತ ವ್ಯಕ್ತಿಗಳ ವಿರುದ್ಧ ಬಗ್ಗೆ ಸುಳ್ಳನ್ನು ದೂರು ಬರೆದು ಅವರಿಂದ ನನ್ನ ವಿರುದ್ಧ ದ್ವೇಷ ಮಾಡುವಂತೆ ಇದರಿಂದ ನನ್ನ ಪ್ರಾಣಕ್ಕೆ ಅಪಾಯ ಮಾಡುವುದರಿಂದ ಅರುಣ್ ಭಟ್ ಮತ್ತು ಜೋಕಿಮ್ ಕೊರಿಯಾ ಅವರು ಸೇರಿಕೊಂಡು ಮಾಡಿದ್ದು. So here in Milord, what they have done is specifically, they literally petitioner has forged my signature and then he has sent the letters to the various government departments. ಸುಮ್ನೆ ಒಂದು ಫಾಲ್ಸ್ ಅಲಿಗೇಷನ್ ಅಲ್ಲಿ ಲೆಟರ್ ಬರ್ದಿದ್ದು ಅಂದ್ರೆ ನಾನೇ ಬರ್ದೆ. I have represented showing that respondent number 2 has written the complaint, wherein I have not written any complaint to the any government offices.
See, I understood the facts. The question is, how can you connect this petitioner to the offense in question? Because the main link between the commission of the offense is accused number 1 posting the letter for which you have a CC camera footage. That is there. What is there to connect accused number 2 except this defaulter is a loan defaulter? And you initiated proceedings for recovery of the loan. That is there in your capacity as the chairperson or president of the cooperative society. That is there. That is the only point to be considered now.
My lordship, I'll convince the lordship, my lordship, kindly pass over. I'll convince. I'll convince my pass over, my lord.
Yes, proceed. Why pass over?
I'll please. My lordship, I'll be permitted to read paragraph number 4.
Yes, read it again. From top to bottom, you read it.
Please.
Any number of times you want, you read it. If it can convince me, well and good.
ಈ ಬಗ್ಗೆ ನಾನು ಸಂಶಯಗೊಂಡು ಯಾರೋ ಕೆಲವರು ನನ್ನ ತೇಜೋದೆ ಮಾಡುವ ಉದ್ದೇಶಕ್ಕೆ ಮತ್ತು ನನ್ನ ಪ್ರಾಣವನ್ನು ಅಪಾಯಕ್ಕೆ ಒಡ್ಡುವ ಉದ್ದೇಶದಿಂದ ನನ್ನ ಸಹಿಯನ್ನು ಫೋರ್ಜರಿ ಮಾಡಿ ನನ್ನ ಹೆಸರಿನಲ್ಲಿ ಸುಳ್ಳು ಅರ್ಜಿಗಳನ್ನು ಯಾರೋ ಹಾಕಿದ್ದಾರೆ ಎಂದು ಪರಿಶೀಲನೆ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಸದ್ರಿ ಅಂಚೆ ಲಕೋಟೆಯ ನನ್ನನ್ನು ಪರಿಶೀಲಿಸಿದಾಗ ಕಿನ್ನಕಂಬಳಿಯ ಅಂಚೆ ಕಚೇರಿಯಲ್ಲಿ ಪೋಸ್ಟ್ ಮಾಡಿರುವುದು ನನ್ನ ಗಮನಕ್ಕೆ ಬಂದು ನಾನು ಅಂಚೆ ಕಚೇರಿಗೆ ಹೋಗಿ ನನ್ನ ಹೆಸರಿನಲ್ಲಿ ಯಾರೋ ದುಷ್ಟರು ನನ್ನ ಹೆಸರಿನಲ್ಲಿ ಮತ್ತು ನನ್ನ ಸಹಿಯನ್ನು ಫೋರ್ಜರಿ ಮಾಡಿ ಸುಳ್ಳು ಪತ್ರವನ್ನು ಬರೆದು ಪೋಸ್ಟ್ ಮಾಡಿರುತ್ತಾರೆ. ಸಿಸಿ ಕ್ಯಾಮೆರಾ ಪರಿಶೀಲಿಸುವಂತೆ ವಿನಂತಿಸಿದಾಗ ಅಂಚೆ ಕಚೇರಿಯವರು ಸಿಸಿ ಕ್ಯಾಮೆರಾ ಪರಿಶೀಲಿಸಿದಾಗ ದಿನಾಂಕ 3/9/2021 so and so ನಿಮಿಷಕ್ಕೆ ಅರುಣ್ ಭಟ್ ದಿ ಮ್ಯಾನೇಜರ್ ಕಿನ್ನಕಂಬಳ ಅಂಚೆ ಕಚೇರಿಗೆ ಬಂದು 4 ಪತ್ರವನ್ನು ಪೋಸ್ಟ್ ಮಾಡಿರುವುದು ಸಿಸಿ ಕ್ಯಾಮೆರಾದಲ್ಲಿ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಈ ಸದರಿಯಲ್ಲ ಕೊಟ್ಟೆಯನ್ನು ಲಗತ್ತಿಸಲಾಗುತ್ತದೆ. ಅರುಣ್ ಭಟ್ ಜೋಕಿಮ್ ಕೊರೆ ಅವರ ಮ್ಯಾನೇಜರ್ ಆಗಿದ್ದು ಆತನ ಎಲ್ಲಾ ಕೆಲಸದ ಉಸ್ತುವಾರಿಯನ್ನು ಅರುಣ್ ಭಟ್ ನೋಡಿಕೊಂಡು ಬರುತ್ತಿದ್ದು ಜೋಕಿಮ್ ಕೊರಿಯಾ ನಮ್ಮ ಬ್ಯಾಂಕಿನಿಂದ ಸಾಲ ಪಡೆದುಕೊಂಡು ಸಾಲಕ್ಕೆ ಜಾಮೀನು ನಿಂತಿರುತ್ತಾರೆ. ನನ್ನ ಹೆಸರಿನಲ್ಲಿ ನನ್ನ ಸಹಿಯನ್ನು ಫೋರ್ಜರಿ ಮಾಡಿ ಪ್ರತಿಷ್ಠಿತ ವ್ಯಕ್ತಿಗಳ ವಿರುದ್ಧ ಸುಳ್ಳು ದೂರನ್ನು ಬರೆದು ಅವರಿಂದ ನನ್ನ ವಿರುದ್ಧ ದ್ವೇಷ ಉಂಟು ಮಾಡುವಂತೆ ಇದರಿಂದ ನನ್ನ ಪ್ರಾಣಕ್ಕೆ ಅಪಾಯ ಉಂಟು ಮಾಡುವ ದುರುದ್ದೇಶದಿಂದ ಅರುಣ್ ಭಟ್ ಮತ್ತು ಜೋಕಿಮ್ ಕೊರೆ ಅವರು ಸೇರಿಕೊಂಡು ಪ್ರವೀಣ್ ಶೆಟ್ಟಿ ಅವರು ನಡೆಸಲು ಉದ್ದೇಶಿಸಿರುವ ರೆಸಾರ್ಟಿನ ವಿರುದ್ಧವಾಗಿ ಸರ್ಕಾರದ ನಾನಾ ಇಲಾಖೆಗಳಿಗೆ ನನ್ನ ಸಹಿಯನ್ನು ಫೋರ್ಜರಿ ಮಾಡಿ ಸುಳ್ಳು ದಾಖಲೆ ಮಾಡಿ ಕಳಿಸಿರುತ್ತಾರೆ. ಜೋಕಿಮ್ ಕೊರಿಯಾ ಅವರ ಬ್ಯಾಂಕಿನಲ್ಲಿ ಅವ್ಯವಹಾರ ಮಾಡಲು ನಾನು ಅಡ್ಡಿ ಮಾಡುತ್ತೇನೆಂಬ ಕಾರಣಕ್ಕೆ ಜೋಕಿಮ್ ಕೊರಿಯಾ ಅವರು ನನ್ನ ಹೆಸರಿನಲ್ಲಿ ನನ್ನ ಸಹಿಯ ಫೋರ್ಜರಿ ಮಾಡಿ ದ ಲಾಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಮೈ ಲಾರ್ಡ್ಶಿಪ್ ನನ್ನ ಸಹಿಯನ್ನು ಫೋರ್ಜರಿ ಮಾಡಿ ಸರ್ಕಾರದ ನಾನಾ ಇಲಾಖೆಗಳನ್ನು ದೂರನ್ನು ನೀಡಿರುತ್ತಾರೆ. So here this my lord, there specifically I have mentioned.
Yes.
This clearly shows that my lord, the alleged offenses attract my lordship. ಇಲ್ಲಿ ಇವರೇ ಫೋರ್ಸ್ ಮಾಡಿದ್ದಾರೆ. I have mentioned my lordship as per the complaint amendments.
Then why you said ಯಾರೋ ಕೆಲವರು ತೇಜೋದಯ ಮಾಡುವ ಸಲುವಾಗಿ ಯಾರೋ ಸಹಿ ಮಾಡಿದ್ದಾರೆ,
My lordship,
ಫೋರ್ಜರಿ
my
ಮಾಡಿದ್ದಾರೆ?
lordship, As petitioner counsel has admitted, there was illegal, my lord. So therefore, my lord, there are a lot of people were against me. In this between, my lord, the petitioner, wherein he is targeting me, and also he has issued a letter by the Nyamita Sangha itself when he was the president. That is page number 20, wherein Joachim Correa Adyaksharu, Kalka Mudkar Vyavasaya Sahakari Sangha, ಇವರಿಗೆ ವಿಷಯ ನಮ್ಮ ಸಹಕಾರ ಸಂಘದ ಇಬ್ಬರು ನಿರ್ದೇಶಕರು ಜಾಮೀನುದಾರರಾಗಿ ಅವರ ಮೇಲೆ ಅಮಲ್ ಜಾರಿ
That is not in dispute and we are not concerned about that. If he is a defaulter, you proceed against
My
him.
lordship, even he is the defaulter, my
Nobody-
lordship. Petitioner himself is the defaulter.
Maybe
But he says that
we
even
are
I am
not
the
concerned
defaulter.
about that in this petition. If they are defaulters, you proceed against them. Who prevents you?
But my lordship, here my name, my signatures has been posted, my lordship. And they have been linking to the underworld, wherein underworld people will target me. I am threatened, my lordship.
Yes, yes, what do you say?
Please, my lords, in support of her contention, I'd like to place reliance on the letter that has been posted by accused number 1 that has been recovered by during the course of investigation. During the course of investigation, my lords.
That was recovered from whom?
It was recovered, it has not specifically stated from whom it has recovered, my lords, but it has been placed on record with the IO papers, my lords.
Where
That
is-
is
have you
there, the
produced it?
signature,
Have you produced it?
no, my lords, it is in IO papers only, my lords. No, not investigation, before investigation.
Yes, what do you say?
No, my lord, complainant himself produces along with the complaint, my lord, that letter. Because page number one, that's page number 19, para 4, my lord, last page ಒಳಗೆ PW ಮಂಗಳೂರು ಎಂದು ಬರೆದಿದ್ದು. ಇದನ್ನು ನೋಡಿ ನನಗೆ ಆಶ್ಚರ್ಯವಾಗಿ ಅಂಚೆ ಕವರನ್ನು ತೆಗೆದು ಪತ್ರವನ್ನು ಓದಿದಾಗ and para 4 last line, my lords.
No, whether that letter is produced before the court.
Para 4 last line, my lords. ಸದ್ರಿ ಅಂಚೆ ಲಕೋಟೆಯ ಮತ್ತು ಪತ್ರದ ಪ್ರತಿಯನ್ನು ಫಿರ್ಯಾದಿ ಜೊತೆ ಲಗ್ತಿಸ್.
Whether
I am
it is
sorry.
produced
I
before
am
this
not produced.
court.
I am not. I am sorry.
That is the question.
I am not produced. Because ಇದರೊಳಗೆ ಅವರು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಕೊಡೋದು ನಮಗೆ is not produced to the court along with the FIR.
If at all, this is to be sent to FSL.
FSL, my lords.
And
For
getting
that
expert.
purpose, thorough investigation that has to
There is
be.
nothing to connect accused number 2 as of now.
My lords, this case is based upon by taking the name of this
Yes.
complainant, they are filing
Yes,
this
what do
kind
you
of
say?
letters, my
My
lords.
lord, as on today to register FIR, my lords, that there should be some material, my lords, stating that I enmity.
There are materials against accused number 1.
Now they say I have enmity with the,
Suppose the investigation is stayed now.
please,
So the disputed signature will be forwarded to handwriting expert.
Please,
The
madam.
report is called for.
no, my lord, now specific cases A1 has done it, he has posted it, etc. is his case, my lords.
Whose case?
Complainant's case. A1 has posted it on 3/9/2021, 14:51 hours.
Has posted the.
Please, my
letter.
lords, that's he is the author. Then, my lord, I do consider as far as,
He-
please.
Can't say.
On the instructions of
But-
petitioner only.
No, my lord,
Not certain
nah,
as
this,
to who has written it.
if I have understood the question of the honorable court correctly, my lords, if in the course of investigation something comes, I do concede, my lord, anything can come out, nobody can stop it, my lord.
Yes.
But for registering FIR, my lords, there should be concrete materials. They cannot be named now. But in the course of investigation or in the course of 319, my lords, these are the stages wherein the honorable court or the police also can.
Yes, at this stage, I'll quash with liberty to the investigating officer to proceed with the investigation. If it is found that it is the disputed signature is done by the petitioner, he will be at liberty.
Yes, ma'am.
Yes. So. Petitioner being accused number 2 has approached this court seeking the quashing of the criminal proceedings initiated against him by registering crime number 288/21 of Mudugidri Station for the offence punishable under section 468, 420, 506, read with section 34 of IPC. Pending before the learned civil judge and JMSC Mudugidri. Or so and so. Peruse the material, point for consideration. My answer to the above point is in the affirmative for the following reason. That is the contention of respondent number 2 being the informant that he had received a returned envelope addressed to the Chief Officer, PWD, Mangaluru, and the from address being with the complainant's name as by mentioning the name of the complainant who sent the letter. When the same was opened, the complainant found a letter addressed to the chief officer in his name, raising objections for setting up a resort within 100 meters from Shankari building where he resides in Mudbidre by one Praveen Shetty, who is said to be having underworld link. The informant stated that accused number 2, the petitioner hearing, had obtained loan from Kallamodpuru Vyavasaya Seva Sahakara Sangha, Sahakari Bank, and he was a defaulter. The informant being the chairman of the said bank initiated proceedings for recovery of the amount that was due. Therefore, accused number 2 was having an ill will against respondent number 2. And he suspects that the letter must have been sent at the instance of accused number 2 by forging his signature. On preliminary inquiry with the post office, it was found that the CC camera footage dated 13/9/2021 revealed that it was accused number 1 who posted the letter in the post box. It is stated that accused number 1 is the manager of accused number 2, and therefore it is suspected that both accused number 1 and 2, colluding with one another, have forged the signature of the informant and sent the letter. Next one. Admittedly, the informant is placing reliance on the CCTV camera footage, wherein accused number 1 said to have posted, accused number 1 found to have posted the letter in the post box. To that extent, there are prima facie materials against accused number 1. But as of now, there is no prima facie materials to connect the petitioner to the offense in question. Under such circumstances, registration of the FIR against the petitioner is in abuse of process of the court, and the same is liable to be questioned. Next one. Learned Counsel, Learned ASPP and Learned Counsel for respondent number 2 expressed their apprehension that if during course of investigation it is found that the disputed signature found on the letter referred to in the first information was made by the petitioner hearing, quashing of the criminal proceedings at this stage may cause hardship to the informant. If during investigation, some prima facie materials are found against the petitioner for having involved in the case in any manner, definitely the investigating officer can proceed against him in accordance. But Since at this stage, there are no prima facie materials to connect the petitioner to the offence in question. Only on the basis of the suspicion, the FIR against the petitioner cannot be permitted to be enforced. Hence, I am of the opinion that the petition is liable to be allowed. Accordingly, I answer the above point in the affirmative and proceed to pass the following. Petition is allowed. Criminal proceedings initiated against the petitioner in kind number so and so, so and so. Yes. Petition is allowed.
Most grateful.
Serial number 30 adjourned, 31 Mayawala, BB Patil, Ramesh Chandra.
Pending IA disposed of.
My lord, I represent in the connected matters.
Plus, in serial number 30, please do not sign for the petitioner. There is an interim order of stay, please do not. It may have to be extended, please do not.
Which one?
With 30, please do not. Without intimation to me, time has been taken.
30.1 you are referring to.
30 and 30.1 are together, please do not.
Interim order is extended, sir.
Please do not.
Yes, 31.
Lord, in 31, I appear for the petitioners in the connected matters. May I just pray for a short passover, my lord?
Avattinde. Why Passover, sir?
Lord, I
You are
am.
very much present. Please go ahead with the matter.
I will reach, my lord, the honorable court as soon as possible, my lord.
Yes, Passover.
Pleasure.
These three matters. On compliance of office objection for first time. Serial number 1, Latif B.
Lordship, there's one submission.
Yes.
So grateful, my lord.
The miscellaneous number in the reject copy is shown as 656 in the heading, my lordship, page number 12. In the rest of the page, it is shown as 586. There we are sought for 656, madam.
There is only one objection.
Please, my lordship.
Of that. You know. What is the objection?
In the reject copy in the page number 12, it is mentioned as criminal miscellaneous 656 of 2024, my lordship. In the rest of the page, it is wrongly shown as 586.
That was a mistake committed by the court.
Please, madam.
Third learned counsel for the petitioner on office objection, serial number 1. The mistake referred to is by the sessions court and not by the petitioner. Hence, the office objection is ignored. There are no other objections.
No.
Thus, it is stated that all the office objections are complied with the office to verify. List for next. Serial
Number 2, Abhay RS.
Counsel for the petitioner is absent, no representation. List on.
Serial number 3, for non-compliant second time, Vikram Raj.
Absent, no representation. List on.
Orders first time matter, serial number 4 to 6.
Appearing for the petitioner in the serial number 4.
To take notice for respondent, privately raised
One
notice.
submission in serial number. One submission in serial number 4. Lordship have already granted a bail for accused number 5.
Yes, now at the stage of issuance of notice. You can bring it to the notice of the court when the matter is heard on merits.
What date may be given in this?
Yes.
Serial number 5 on.
Issue notice.
Serial
You are
number
for?
5. A1 and A3 has granted bail.
Right, sir, that will be considered at the time of merits.
12th minute.
12, even
Yes,
same.
next. Next.
For further argument, serial number 7, Krishna Kumar KK.
Kindly pass on, sir. Senior.
Pass over.
8, A.B. Nagendra, Amar Kori.
For petitioner, my lord.
Who is the petitioner?
For petitioner number one, my lord.
Who is the petitioner?
Accused number one, my lord.
Accused number one.
Yes, my lord.
In all, how many accused?
Totally three accused, my lord.
What about A2? A2?
Two is some other.
No, whether he is apprehended, whether he is in judicial custody, whether he is granted bail.
Judicial custody, my lord. One and two is. Accused number three is got bail, my lord.
Lord,
A2 is in
A2,
KC.
A1
Yes, my
and
lord.
2 are before this honorable court, my lord. 8 and 8.1. Both the accused are before this honorable court and A3 is on bail.
When A1 was arrested? When he was arrested?
13/2/2024, my lord.
Yes.
Investigation is completed and charge sheet was filed, my lord.
What is the allegation?
Recovered from the accused number 1 to 0.140, my lord.
Where is the charge sheet?
Page number 57, my lord. Column number 17.
It is
43, my lord.
47. This is page number 48. Yes, what is the allegation?
From accused number 1, 0.140 grams of LSD strip, my lord.
All the three were together.
Yes, my lord. The recovery is only from accused number 1 and 2, my lord.
1 and 2.
Yes, ma'am.
This LSD, commercial quantity is 2 minimum.
Commercial quantity is 0.1 gram is commercial quantity, my lord. 0.002 is the small quantity, my lord. The
Then
recovery is
MDMA, MDMA,
MDMA, my lord. My lord, according to this, my lord.
MDMA is 0.5 grams is small quantity and 10 grams is the commercial quantity, my lord. It is not a MDMA, my lord.
And
As per the
methamphetamine
FSL report, my lord.
is the commercial quantity. Lord, in this case, my lord, 11 grams MDMA was seized, my lord, but the FSL says that, my lord, MDMA, only methamphetamine was found, which is a stimulant drug, my lord. That is 50 grams is the commercial quantity. That has been seized from the accused number 2, my lord. From this petitioner, my lord, the LSD strips weighing 0.14 grams.
that is commercial.
That is commercial quantity.
Any criminal antecedent?
No criminal antecedents.
I will allow this.
It's a commercial quantity, my lord. 37 of NDPS.
But in this case, my lord,
There is no other grounds also, my lord. Followed the mandatory procedures, my lord.
ಅದೆಲ್ಲ ಇದೆ, of course.
section 50 also
For
clear
accused
violation.
number
ಇದೆ.
1, my lord. Accused number 2, my lord, I can say. Only for accused number 1, my lord, it is commercial quantity.
No, what is the use in keeping in? There is no, he has no criminal antecedents.
Still, my lord.
0.14.
Prima facie
0.1
materials are there.
is the commercial quantity.
Yes, my lord,
Was in
prime,
possession of 0.14.
pardon, my lord.
0.1 is the commercial quantity.
Yes, my lord,
He was in possession of 0.14.
140.
Good. So. The learned counsel for the petitioner, we have had 7954 of 2024 is absent. No representation. He has not presented. Argument is taken as nil. The FIR is came to be registered against accused numbers 1 to 3 for the opposite offences. It is stated that accused number 1 to 3 were found together. And accused number 1 was found in possession of 0.140 grams of LSD, whereas accused number 2 was found in possession of 11 grams of MDMA. Cash of ₹500 was seized from the custody of accused number 3. Investigation was undertaken and the charge sheet came to be filed. For having Next. As per FSL report, the contraband that was seized from the custody of accused number 2 was found to be methamphetamine, a stimulant drug, and not MDMA. Therefore, the contraband which was found in possession of accused number 2 was not of commercial quantity. Completed. Detention of accused number 2 in custody may not be required. Under such circumstances, he is entitled for grant of bail. Next one. Petitioner in criminal petition number 7879 of 2024, being accused number 1, was found in possession of commercial quantity of LSD, according to the FSL report. It was a commercial, use of commercial quantity. However, it is not the contention of the prosecution that the petitioner is having any criminal antecedents. When accused number 2 and 3, who were along with accused number 1, are admitted for bail, I do not find any reason to reject the claim of the petitioner, accused number 1, for grant of bail. However, if the petitioner, however, such grant of bail will be subject to conditions which will take care of so and so. Accordingly, answer the above point in the affirmative in the first.
In the connected petition, lords.
Petition against ಒಬ್ಬರಿಗೆ ಮಾತ್ರ dismiss ಆಗಿದ್ದು.
Lords, in the connected petition, lords, I appeal for the petition.
Yes. Petition. ಅಲ್ಲ petition. Petition number 2 and petition number 2 in sorry. 79. ಮುಂದೆ ಏನಾಗಿದೆ? Petitioner ಒಬ್ರೇ ಇರ್ತಿದ್ರಲ್ವಾ? ಇದರಲ್ಲಿ ಏನ್ ಬೇರೆ? ಇದು number one. ಸರಿ, ಇಲ್ಲಿ ಇಬ್ರು ಇದ್ರು. ಇದ್ರಲ್ಲಿ ಆಯ್ತು. ಇನ್ನೊಂದ್ರೆ ಸೂರಜ್ alone is the petitioner. Recalling what? ಇದರಲ್ಲಿ 7954 ಅದರ ಆರ್ಡರ್ ಶೀಟ್ ನಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. ಆರ್ಡರ್ ಡೇಟೆಡ್ 13/8/2024 is recalled. ಅದಕ್ಕೆ ಏನ್ ರಿಕಾಲಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾರ? Accordingly, IA1 of 2024 is allowed. Yes.
Corrected matter, my lords, in the previous one, I'm appearing.
Nine.
Kindly be passed over. Senior is held up in order.
Pass over.
Serial number 10, MR Manjunath.
439 petitioner, my lord. Present petitioner is accused number 6, my lord.
Accused number?
Accused number 6, my lord.
In all, how many accused?
There are 9 accused. Offense, my lord, section 302, 143, 144, 47, 148, 120B and 149. The gist of the charge sheet is, my lord, page number 50, my lord. Column number 7, please.
Charge sheet?
Charge sheet, my lord. Page number 21. Column number 7 is page number 50, my lord.
50.
50. Allegation on road tax is page number 50 on the present petitioner is
You have stabbed with a dagger.
dragger towards the chest and back of the deceased man. But as per the eyewitness statement, my lord, they have not seen the who are the assailant in the charge sheet, my lord. As per the eyewitness statement, my lord, they have ran away from the place of the incident.
Allah, that is to be appreciated by the trial court.
Yes,
Who are the eyewitnesses? CW2, 2?
2 to 4.
2 and 3, my
2
lord.
and 3.
3. Where is their statement?
Statement is in their page number 61. 164 statement also recorded.
Page number?
Page number 61, please. Madam.
This is CW?
CW2, madam.
2, my lord.
2. There is no specific overtax as per the statement of the witnesses. Page number 62, last paragraph for a moment, please, madam. The eyewitness who has stated they have taken treatment before the hospital. In the hospital, they have stated that they self taken treatment, my lord. Make it page number 63. Apartment ನಿಂದ ರಾಡ್ ನಿಂದ ತಲೆಗೆದ್ದು ಬಿಟ್ಟಿರ್ತಿದ್ದು 7 ಎಂದು they have taken treatment.
How many injured are there?
Only 2 injured, sir.
2 injured.
2 injured. Deceased one and other the second expired CW2, my lord. he has taken treatment in the hospital, ಅಪಾರ್ಟ್ಮೆಂಟ್ ಇಂದ ತಲೆಗೆ ರಾಡ್ ಬಿದ್ದು ಪೆಟ್ಟಾಗಿರ್ತಿದೆ ಅಂತ ಹೇಳು ದೇವಬಿಟ್ಟು ಚಿಕಿತ್ಸೆ ಪಡೆದಿರ್ತೇನೆ.
Yes, what do you say?
My lord, 164 statement of the eyewitness was recorded, my lord. In that, my
Early
lord,
there's a self-fall.
there are 6 people.
1 minute.
Please.
Where is it, the self-fall anta?
In 164 statement, page number 61, my lord, of CW2, in this statement, 63, please, my lord. ನಾನು ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಅದೇ ರೀತಿ ಹೇಳಿರುತ್ತೇನೆ. ಪೇಜ್ ನಂಬರ್ 63 ಮೇ ಪ್ಲೀಸ್ ಮೇಡಮ್. ಅಪಾರ್ಟ್ಮೆಂಟ್ ಇಂದ ರಾಡ್ ಬಿದ್ದು ತಲೆಗೆ ಪೆಟ್ಟಾಗಿರ್ತಿದೆ ಎಂದು ಹೇಳಿರುತ್ತೇನೆ. ನಾನು ಆಸ್ಪತ್ರೆ ಅದೇ ರೀತಿ CW2 and 3 ಆಲ್ಸೋ ಟೇಕನ್ ಟ್ರೀಟ್ಮೆಂಟ್ ಸಚ್.
ಆಯ್ತು, ಅದು ಹೇಳಿದಾರಲ್ಲಿ ಮತ್ತೆ ಹೇಳಿ.
ನನಗೆ ಹೇಳಬೇಡ ಅಂತ ಹೇಳಿದ್ರು ಅಂತಾನು ಹೇಳಿ.
Please,
That will not inure to your benefit.
please.
Hmm.
But there is no specific
Yes,
court
the
act
eyewitness
made
report-
against this petitioner, madam. Further, my lord,
Identified the accused in test identification period, my
That
lord.
was held.
It was.
only on voluntary.
Yes, identified, ಮುಗಿಸ್ಬಿಡಿ ಇಲ್ಲ ಬಿಡಿ.
Both the injured have, both the injured.
The
These
CW2
eyewitnesses-
has identified, my lord.
CW2 and 3 are the eyewitnesses.
Yes, my lord.
They are the injured eyewitnesses.
CW2 only is the injured. And they have identified the accused persons, my lord.
Both CW2 and 3
Yes, my lord.
identified.
Yes, my lord. And my lord, the bloodstained clothes of the accused, this particular accused, my lord, was recovered, and the blood stains matches with the blood group of the deceased, my lord. And petitioner is a habitual offender, my lord. He is also involved in another crime, crime number 71 of 21. For the
71
offense,
now?
21, my lord, for the offenses under section 20 of the NDPS Act, my lord.
71 of, 21 of which police station?
Ramnagar Town Police Station, my lord.
The bloodstained clothes of accused number 6 was recovered.
Yes, my lord. It matches the FSL, my lord, it matches with the blood group of the deceased. Yes, ma'am.
My lord,
There is
even though
specific overt act against this.
deceased himself is a restricted seater, my lord.
Hmm?
He deceased himself is
Maybe
restricted.
that will not give you the right to cause his death.
No, ma'am.
No.
I
not
may be
at that.
permitted to withdraw after the liberty to file after examination of material witness,
Then,
please, my lord.
You are withdrawing it.
Please, please.
Counsel for the petitioner after addressing
Liberty,
the
please.
argument at length seeks permission to withdraw the petition. With liberty to file similar petition before the trial court after examination of material witnesses. Filed a memo hakidre memo anta. Placed on record. Petition is dismissed as withdrawn with liberty as paid for. As paid for ಅಲ್ಲ. So ಏನ್ ಹಾಕಿರ್ತಾರೋ ಅದಲ್ಲ. Only after examination of material witness. Yes.
Serial number 11,
ಇದನ್ನೇ
Hariprasad.
Hearing for petitioner.
ತೋರ್ಸಿ, doubt ಇದ್ರೆ ತೋರ್ಸಿ. Ten.
Earlier, the petitioner moved for bail in criminal petition 1490 of 2024.
Yes.
Same has been withdrawn. I produced at page number 36. As the petitioner is the sole accused. The offense is under section 302. As the FIR
When
is
he was arrested?
2/1/2024.
2/1?
2024.
20?
24. But the FIR date, the time and date of the FIR is 1/1/2024 at about 3 AM in the early morning. But now the investigation is, a charge sheet is filed. Thus may kindly turn to page number 33. The overt act after investigation. Page number 33. Second paragraph. ನಂತರ ದಿನಾಂಕ 31/12/2023 ಮಧ್ಯರಾತ್ರಿ ಸುಮಾರು 12:30 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಬೆಂಗಳೂರು ನಗರ ಹನುಮಂತನಗರ ಪೊಲೀಸ್ ಠಾಣಾ ಸರಹದ್ದಿಗೆ ಸೇರಿದ ಶ್ರೀನಿವಾಸ ನಗರ 80 ಅಡಿ ರಸ್ತೆ ಶ್ರೀನಿವಾಸ ನಗರ ಬಸ್ ಸ್ಟಾಪ್ ಎದುರು ನಂಬರ್ 7 ಗಣಪತಿ ಕಾಂಪ್ಲೆಕ್ಸ್ ಮುಂಭಾಗದ ರಸ್ತೆಯಲ್ಲಿ ಪ್ರತ್ಯಕ್ಷ ಸಾಕ್ಷಿದಾರರಾದ CW2, 3, 4 ನ್ಯೂ ಇಯರ್ ಪಾರ್ಟಿ ಮುಗಿಸಿಕೊಂಡು ಮನೆಗೆ ಹೋಗಲು ಬರುತ್ತಿದ್ದು ಅದೇ ರಸ್ತೆಯಲ್ಲಿ ಬರುತ್ತಿದ್ದ ಮೃತ ವಿಜಯ್ ಅಲಿಯಾಸ್ ವಿಜಯ್ ಎಂಬನು ಸಾಕ್ಷಿ 2, 3 ಮತ್ತು 4 ಅವರನ್ನು ನೋಡಿ ಮಾತನಾಡಲು ಬಂದು ಸಾಕ್ಷಿ 2 ಶ್ರೀನಿವಾಸ್ ಅಲಿಯಾಸ್ ಸೀನರ್ ಅವರೊಂದಿಗೆ ಮಾತನಾಡುತ್ತಿರುವಾಗ ಆರೋಪಿಯು ಠಾಣಾ ಮಾಲುಪಟ್ಟಿ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಕ್ರಮ ಸಂಖ್ಯೆ 2ರಲ್ಲಿ ನಮೂದಿಸಿರುವ ಪ್ಯಾಸೆಂಜರ್ ಆಟೋ ರಿಕ್ಷಾ ನೋಂದಣಿ ಸಂಖ್ಯೆ ಸೋನ್ಸೋರಲ್ಲಿ ಬಂದು ಆಟೋದಿಂದ ಚಾಕುವಿನ ಸಮೇತ ಕೆಳಗೆ ಇಳಿದು ಮೃತ ವಿಜಯ್ ಅಲಿಯಾಸ್ ವಿಜಿರ್ ಅವರಿಗೆ ಯಾಕೋ ನಿನಗೆ ಸೋನ್ಸೋ ಮರ್ಯಾದೆ ಕೊಟ್ಟರೆ ನೀನು ಏನು ದೊಡ್ಡ ಇದಾರ್ದಂಗೆ ಆಡ್ತೀಯ ಎಂದು ಠಾಣಾ ಮಾಲುಪಟ್ಟಿ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಕ್ರಮ ಸಂಖ್ಯೆ 1ರಲ್ಲಿ ನಮೂದಿ ಚಾಕುವಿನಿಂದ ಹೊಡೆಯಲು ಬೀಸಿದ್ದು ಮೃತ ವಿಜಯ್ ಅಲಿಯಾಸ್ ವಿಜಿ ಆ ಏಟಿನಿಂದ ತಪ್ಪಿಸಿಕೊಂಡಿದ್ದು ಅಷ್ಟರಲ್ಲಿ ಸಾಕ್ಷಿ 2 ಶ್ರೀನಿವಾಸ ಅಲಿಯಾಸ್ ಸೀನನ್ನು ಆರೋಪಿಯನ್ನು ಹಿಡಿದುಕೊಂಡು ಸ್ವಲ್ಪ ದೂರ ಕರೆದುಕೊಂಡು ಹೋಗಿದ್ದು ಆದರೆ ಆರೋಪಿಯು ಮತ್ತೆ ಸಾಕ್ಷಿ 2 ಶ್ರೀನಿವಾಸ್ ಅಲಿಯಾಸ್ ಸೀನನ್ನು ತಪ್ಪಿಸಿಕೊಂಡು ಓಡಿ ಬಂದು ಮೃತ ವಿಜಯ್ ಅಲಿಯಾಸ್ ವಿಜಿ ಬಲಭಾಗದ ಎದೆಗೆ ಚಾಕುವಿನಿಂದ ಚುಚ್ಚಿ ಕೊಲೆ ಮಾಡಿರ್ತಾನೆ. ಆರೋಪಿಯು ಸಾಕ್ಷಿ 1ರವರ ಮಗನಾದ ಮೃತ ವಿಜಯ್ ಎಂ ಅಲಿಯಾಸ್ ವಿಜಯ್ 21 ವರ್ಷರವರನ್ನು ಹಳೆ ದ್ವೇಷದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಕೊಲೆ ಮಾಡಬೇಕೆಂದು ತೀರ್ಮಾನಿಸಿಕೊಂಡು ದಿನಾಂಕ 31/12/2023 ಮಧ್ಯರಾತ್ರಿ ಸುಮಾರು 12:30ರಿಂದ 12:45 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಮೃತ ವಿಜಯ್ ಅಲಿಯಾಸ್ ವಿಜಯ್ ಬಲಭಾಗದ ಎದೆಗೆ ಚಾಕುನಿಂದ ಚುಚ್ಚಿ ಕೊಲೆ ಮಾಡಿರುವುದು ತನಿಖಾ ಸಮಯದಲ್ಲಿ ಲಭ್ಯವಾದ ಸಾಕ್ಷ್ಯಾಧಾರಗಳಿಂದ ದೃಢಪಟ್ಟಿರುತ್ತದೆ. As per the charge sheet, the incident is between 12:30 to 12:45. It was in the third para. 12:30 to 12:45. I am placing the entire charge sheet. The CW19 is the technician who retrieved the CCTV camera. It is in the page number, ink page number 135. 135. The Kiran is the CW19. Second para runners ಆ ಹುಡುಗ 4-5 ಹೆಜ್ಜೆ ಮುಂದೆ ಬಂದು ಫುಟ್ಪಾತ್ ನಿಂದ ಕೆಳಗೆ ಮಕಡೆ ಬಿದ್ದಿರುವ ವಿಡಿಯೋ ಇರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ದಿನಾಂಕ 31/12/2023 4:40ರಿಂದ 4:45 ಗಂಟೆವರೆಗಿನ CCTV ಫುಟೇಜ್ಗಳನ್ನು ಬೇರೆ ಬೇರೆಯಾಗಿ 32 GB ಮತ್ತು 16 GB 2 ಸ್ಯಾಂಡಿಕ್ಸ್ ಕಂಪನಿಯ ಪೆನ್ ಡ್ರೈವ್ಗಳಿಗೆ ವರ್ಗಾಯಿಸಿ ಕೊಟ್ಟಿರುತ್ತಾರೆ. As per the charge sheet, the CCTV camera. My presence is recorded at about 4:40 to 4:45 AM. The incident
There
is
are eyewitnesses, sir.
there are
CW2
eyewitnesses, Your Honor.
said to have caught hold of you and
Yes,
later
madam.
you escaped
Lord,
and ran away.
Lord, these CW2, 3 are the habitual offender of the same police station.
Their evidence cannot be discarded saying that they have also accused in some case. No, that is not the law.
Lord, but Your Honor,
If a murderer is cited as a witness, he is to be honored.
Lord, the entire case is based on Your Honor CCTV footage.
No, no.
CCTV
The
footage.
version of the eyewitnesses.
Your Honor,
As per the charge sheet, it based on the version of the eyewitnesses.
Lord, after the FIR registering, Your Honor.
3 and 4 are the eyewitnesses.
Yes,
Is
my
it?
lord.
Yes.
Yes, my lord. It has shown as they are the eyewitnesses. My lord, after registering the FIR, Your Honor, the investigation officer goes to the spot by 3:40 to
Let him
4:40.
recover the
My lord,
CCTV
my lord,
cameras.
he
Does
found
not
that
mean-
there was a CCTV camera. Then only, Your Honor,
No, sir,
IO came to know.
See, it is always the importance is to be given to the version of the eyewitnesses.
Lord, they are shown as the eyewitnesses.
Yes.
Lord, but they are not eyewitnesses.
Start
Lord,
with
he's
doubting the version of the
Lord,
eyewitness.
he's 20. Lord,
All these defense you can take before the trial court.
yes, my lord, but let him,
Be
Lord, he is 22 years of
No,
age.
no. What to do? You have already taken.
Lord, I don't have any antecedents.
Nothing.
The eyewitnesses are the
302,
habitual
sir,
offenders.
302.
Yes, my
No,
lord.
You have already taken away the life of one person. So you have no right.
I withdraw my petition.
Withdrawing, counsel for petitioner after addressing the argument at length, seeks permission to withdraw the petition. Dismissed as withdrawn. Next.
Serial number 12, B Latif.
Today's time for 1 week.
Raise for time. Finally ಏನಾಗಿಲ್ಲ. Raise for time, yes. Yes. Stay in the current. List 1 ನಲ್ಲಿ ಯಾವುದು ಪಾಸ್ ಓವರ್ ಇಲ್ಲ. List 2 ಕರೆಕ್ಟ್. First in the correct.
Passed over matters. Serial number 1, Manjunath MV.
Respondent statement.
Yes, what do you say?
Lords, page number 18, my lords, from bottom sixth line, they have broken Tanti Valley and they have abused the complainant, my lords.
Yes,
The allegations has been made out against these present petitioners, my lord.
so petitioners being accused number 8, 9, and 11
Please, my lords.
are seeking to quash the criminal proceedings registered in crime number 339 of 2019 of Suryanagara Police Station for the offences punishment under sections so and so, so and so. Or so and so. Learned counsel for the petitioners contended that there was a dispute and ill will between the petitioners and the complainant. Even a civil case in suit in OS number 204 of 2019 filed by petition number 2 is pending consideration where he has sought for grant of perpetual injunction. Therefore, the dispute between the parties is purely of civil nature. It was given the color of a criminal offense. And therefore, he pays for allowing the petition by quashing the criminal proceedings. At contra, learned ASPP opposing the petition submitted that the offense alleged by the informant is purely of criminal nature. After investigation, charge sheet is came to be filed. Even as per charge sheet, the petitioners, along with the co-accused, criminally trespassed into the site belonging to the informant on 8/9/2019, destroyed the wire fence and the compound wall, destroyed the barbed wire fence, abused the informant in filthy language, criminally intimidated to cause his death by burying him under the ground. Under such circumstances, the offense in question cannot be termed as a civil dispute. Since serious allegations are made against the petitioners and the co-accused for having committed the offense, the petition is liable to be dismissed. Accordingly, she pays for dismissal of the petition. Review the materials, point for consideration. My answer to the above point is in the negative for the following reasons. The informant has lodged first information making specific allegations that the accused have criminally trespassed into his site using criminal force, demolished the barbed wire fence by using JCB, and criminally intimidated him to bury him under the ground. After investigation, charge sheet was came to be filed, even as per column number. Charge sheet is filed.
No, my lords, charge sheet has not been filed. They have challenged FIR, my lords.
Okay. Even as better, charge sheet is filed better. When such a specific allegations are made against the accused, including the petitioners, who are arrayed as accused number 7, 8, and 11, it cannot be said that the offense in question is of civil nature. Offense in question, but allegations in question are of civil nature. Next paragraph. Even though it is contended by the learned counsel for the petitioner that petition number 2 had filed the suit OS 204 of 2019, seeking for perpetual injunction against respondent number 2. It is noticed that the suit was filed on 24/12/2019, whereas the first information by respondent number 2 was came to be filed on 9/9/2019. That is much prior to filing of the suit. Under such circumstances, the contention taken by the learned counsel for the petition that the allegations are of civil nature cannot be accepted. Hence, I do not find any reason to so dismissed.
My lords, list 2, serial number 5, my lords. Accused are acquitted, my lords, on 1/6/2021. Court notice was issued, my lords.
In view of dismissal of criminal. Yes, yes. The main reason criminally charge sheet is filed under the charge sheet is not filed under. Yes.
Serial number 5, my lords, list 2. Acquitted on 1/6/2022, my lords. In the morning session, court notice was issued to the petitioner, my lords. It has become
is the-
infructuous, my lords.
Very. Adral togoli, 5. Then ASPP submits that
Acquitted on 1/6/2022, my
Is, uh,
lords.
petitioner is acquitted by the trial court with a judgment dated
1/6/2022, my lords.
2022. Submission is placed.
CC
that the
1/15.
petition is dismissed as become rendered infructuous. Yes.
Serial number 11, V. Anand. Case submitted.
ಏನದು? Compliance of office objections. ಏನದು I1? ಅದು amendment ಏನದು? ಮತ್ತೇನು amendment ಏಕ್ ಬರುತ್ತೆ? ಮತ್ತೆ? ಆಗಲ್ಲ ರೀ. ಆಫೀಸ್ ನೋಟ್ ಹಾಕಿದ್ದು ನಾನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಆಫ್ ಕಾಸ್ಟ್ ಟೈಟಲ್ ಇನ್ ಮೇನ್ ಪಿಟಿಷನ್. ಏನು? ಮಾಡಿದೆ. ಮತ್ತೆ ಅಲ್ಲಿ ಮಾಡಿಲ್ಲ ನಾನ್ ಅಮೆಂಡ್ಮೆಂಟ್. Amendment carried over. Learned counsel for the petitioner submits that the amendment in the cost title is already carried out. Office to verify. ಆಮೇಲೆ 1/21 ಏನು? A1 of 2021 is filed. What is A1? A1. 1 of 2021 is filed. To include proposed respondent number 8 and 9 on record. The amended petition discloses that they are already brought on record. But ಯಾವ್ದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಆಗುತ್ತಾ? ಮತ್ತೆ ಅವ್ರನ್ನ ಎಲ್ಲಿಂದ ತಗೊಂಡು? ಅಮೆಂಡ್ಮೆಂಟ್ ಯಾವ ನೋಡಿ ಅದೊಂಚೂರು ಅಮೆಂಡ್ಮೆಂಟ್ ಹೆಂಗಿಲ್ಲ. ನೆಕ್ಸ್ಟ್.
For 17, Rangnath Reddy R.
My lord, this case, my lord, the accused are acquitted, my case is closed.
ಯಾವುದು 17?
17, my lord.
Acquitted.
Yes, my lord.
Learned HCGP submits that the petitioner, the accused are already acquitted by the trial court with a judgment dated.
22/1/2024.
Hence, the petition is dismissed, as the same is rendered infructuous. Yes, next.
Serial number 22.
Really, counsel for the petitioner is absent. ಮೇಲಿಂದ್ರಲ್ಲೂ ಹಾಗೆ. ಮೇಲೆ ಒಂದು infructuous ಮಾಡಿದ್ರಲ್ಲ ಅದರಲ್ಲೂ dismissed. ಅಲ್ಲ, absent.
Highly obliged, my lord. I am appearing for in item number 222 for the respondent.
I am appearing on behalf of the petitioner.
Yes.
Basically, there are two.
In both the petitions, you are present.
Two connected matters.
In one, there is a issuance of process which is being challenged. And in
Petitioner in both the cases are one and the same,
yes, it is.
same petitioner
Yes, Your Honor.
in both the cases.
Yes, Your
In 324, what you are challenging,
Honor. Issuance of process.
that is of the year 2018.
Yes, Your Honor.
What you are seeking in 6750?
In that, an application was filed by the respondent to implead accused number 4 as a party to the complaint, which is the company. In that, distribution agreement was made between the petitioner and the respondent for its product Peter England from year 21 of May 2008 till 11th of 7
So
2007.
that application was came to be allowed? Application was came to be allowed?
Yes, my lord. Yes, sir.
Who was impleaded?
Accused number 4, company, Isha Distribution.
As accused number 4. Yes.
There was a distribution agreement which was carried out between the petitioner and the respondent, to which blank checks were issued by the petitioner to the respondent.
What is the offense alleged?
138.
In all, how many accused now?
Total 4 accused are there.
Yes.
Blank checks were issued for an amount of
Now, you have to say what is the contention of the complainant. At this stage, I am not concerned about your defense. First, let me understand what is the contention taken before the trial court by the complainant. Start with that.
My trial court has impleaded accused number 4 as the party to the suit, which cannot be done here as per the.
Sir, what is the facts of the case? What is the contention of the complainant before the trial court? Initially, complaint was filed against accused number 1 to 3.
Yes, Your Honor.
What is his contention?
Blank checks were given by the petitioner to the respondent.
That is the
which were
contention
dishonored.
taken by the complainant?
Yes, sir.
That is the contention of the complainant?
Yes, Your Honor.
Where is it?
No, my lord. Para number C.
Page number?
Page number 2. Your Honor.
Para number?
Para number C.
C na?
Yes, sir. CC.
You are referring to your petition?
Yes, Your Honor. Synopsis.
Can you understand what I am saying?
My lord,
Sir, I am asking you what is the contention taken by the complainant in the complaint, private complaint?
that's what I was referring. Blank checks were given by the petitioner, complainant, to the respondent, which were dishonored, Your Honor.
Blank checks were issued by?
That's what I was referring to. It was mentioned in para number C. Your Honor.
There is no para C, unfortunately, in page number 2 of the complaint.
Your Honor, I was referring in synopsis.
I am referring to the complaint itself. PCR
Lord, may
814,
Lord.
CC number 51958 of 2016.
516.
Yes, you are for the complainant.
Yes, my lord, I am of the complainant. My lord, may see the page number. My lord, on the basis of the material supplied to the accused person, the checks was issued by the accused person on the behalf of the company, my lord.
Yes.
Yes, the notice has been issued to the company as well as to all the directors of the company.
Complainant is the supplier of?
Complainant is the supplier of the garments, my lord. This is Aditya Birla Fashion and Retail. They have supplied the garments of the brand name Peter England to the accused person, my lord. Same has been stated at page number 13, para number 9 of my complaint, my lord. On the basis of that, the accused person, Sangeeta Bhuvna, who is the petitioner in this, on the behalf of the company, issued a check of rupees 1 crore 29 lakhs, 1 crore 29 lakhs. The check was dishonored, my lord. Thereafter, I filed a
Which
complaint.
accused issued the check?
Sangeeta Bhuvna, my lord. The petitioner.
Accused number 1.
Yes, my lord. And thereafter, there are the certain email has been exchanged, which has been stated in para number 11 of my complaint, my lord, wherein they have admitted the liability to clear the dues in respect of these checks. However, despite of that, they are unable to clear the check, and these checks were dishonored due to insufficient of fund, my lord. So the total recovery against the accused person, against the company and the accused person is 4 crore 31 lakhs of the complainant. However, they have issued a check.
Check is for rupees 1.29 crores.
Just a moment, Lord, I will just confirm the check amount.
There were two checks.
There were two checks, my lord. 1 crore 29 and another check is 2 crore 77 lakhs.
2 crores.
77 lakhs.
Both were dishonored as insufficiency of fund.
Yes, my lord.
What is account closure?
Account close.
What was the endorsement?
Account closure.
Unfortunately, both of you do not know the basic facts.
My lord,
And both of you are ready to address the argument.
my lord, the remark was account closed. I was made to.
Sir, you do not know which is the complaint, which is your petition. You don't know the difference between the two. Very, very unfortunate. Okay, adjournment. Please for that. Next.
Serial number 31. Kevala B.D. Patil.
Lord, I appeared, my lord, in the connected matters 31.1 and 30.1.2. Lord, sir, kindly have
1 minute.
General clauses actually. Explaining the law for two.
Yes, you are appearing in which case?
I am appearing in my lord 31.1 and 31.2.
Who are the petitioners?
My lord, these petitioners are not named accused persons. But my lord, the reason why this petition was filed is that during the course of investigation, repeatedly these petitioners were summoned under notices, my lord, on several occasions. And my lord, constant harassment was meted out. My learned friend Patil may not take exception to that because it was his predecessor department, my lord, who called us.
No, ma'am. We have still the same department because we have
ACB.
inherited everything from that.
No, what is your prayer then?
Our prayer, my lord, we are, in fact, my lord, there is one, my lord, basic submission is when we applied for anticipatory bail was granted to us, but the objection statement, the state, my lord, clearly spelled out their mind of implicating us, which is, my lord, I have produced the statement of objection.
What is your prayer now? What is
Our
what is
prayer,
that
my
you
lord,
want?
is quashment of these proceedings.
You are not an accused.
I am not an accused.
Then
If
why
your
it
lord-
has to be quashed?
Otherwise, my lord, my prayer, if your lordships would kindly have, my lord, the prayer which I have extracted, page.
When you are granted, when you are armed with anticipatory bail, what else you can see? How can you seek quashing of FIR?
Otherwise, my lord, in fact, my lord, my prayer is, prayer B, my lord, is for quashing. And my lord, prayer C, issue a writ of certiorari or any other writ, other order or direction as may be deemed necessary in the facts and circumstances of the case. Quashing the report dated so and so. My lord, the report is what we are aggrieved of.
What is that report?
If your lordships could kindly have, my lord, the report which is on
Sir,
page number
please
9.
tell me the facts.
I'll, my
Don't ask me to refer the page number.
my lord,
Stop that.
yes, I'll, my lord, sum it up, my lord, in 5 or 6
that.
sentences. So grateful, my lord, so grateful. My lord, the government, the PWD, had granted certain extent of land.
I understood. The
Yes.
facts of the case, learned senior advocate, on the other hand,
Yes,
argued that.
yes.
Now,
Our
what
role
is that
comes in.
report you are aggrieved by?
Our role, my lord, the report is on page number 96. This is the report in which allegations are made against us as if we were, my lord, party accused persons in the entire, my lord, alleged, my lord, acts of corruption, etc. This is
Now,
what
final report is filed.
based on this report, my lord, FIR comes to be registered. Based on this report, investigation takes off. There is no final report, my lord. The matter was stayed because of the writ
Been
petition.
stayed, my lords. There is no final report.
There is no final report. Investigation did
is
not
stayed.
proceed.
In fact, my lords, in the 3 petitions here, only to interject, I'll provide. There is no one named by person in the FIR. I'll read out the FIR. Between this year to this year, who was the managing director? And during that period, whoever was the officer in PWD is what the FIR says.
Where is the FIR? Page
FIR, my lord, should kindly find on page number, my lord, 28. Typed copy, my lord, page number 28. ಅದರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 29 ಅಲ್ಲಿ ಐಟಮ್ ನಂಬರ್ 6 ಮೇಲೆ ಗೊತ್ತಾದ ಅಥವಾ ಅನುಮಾನಿತ ಗೊತ್ತಿಲ್ಲದ ಅಪರಾಧಿಯ ಪೂರ್ಣ ವಿವರ ಅಂತಿದೆ. 2007 ಮತ್ತು 2008ರಲ್ಲಿನ ಕೆಎಂಎಫ್ ಆಡಳಿತ ಮಂಡಳಿ ಹಾಗೂ ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರು ಹಾಗೂ ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆಯ ಅಂದಿನ ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರು, ಕಟ್ಟಡ ವಿಭಾಗ ಹಾಗೂ ಇತರೆ ಅಧಿಕಾರಿಗಳು.
And from the Millards, the FIR is of the year 2017. From there to this day, there is a stay. Investigation has been stalled at a very nascent stage is also one of our submissions. Nothing has fluctuated out of it.
ಒಂದು ನಿಮಿಷ ಹೇಳ್ಬಿಡ್ತೀನಿ. My lords may kindly have this report, my lord, which I humbly request your lordships to kindly have page number 96.
Report dated?
A report, my lord, is dated, my lord, 3 report dated 9th August 2017.
Submitted by?
Submitted by, my lord, one Mr. Police Inspector ACB to the SP ACB. My lord, the name of the officer is on page number, my lord, his name Mirza Ali. Mr. Mirza Ali, police inspector, conducts certain conducts certain, my lord, inquiry. I would rather call it as, my lord, investigation. On page number 109, my
What is the
lord,
basis for such investigation?
the basis for such investigation is a complaint allegedly filed by one Mr. Sai Datta, a social activist, lord, who is no more. My lord, he files a complaint dated 19/5/2017. And based on certain media reports.
I'll only interject for
ಒಂದ್ ನಿಮಿಷ ಪಾಟೀಲ್ ಹೇಳ್ಬಿಡ್ತೀನಿ ರೀ.
ಅವ್ರು ತೋರ್ಸಾ ಇರೋ ರಿಪೋರ್ಟ್ ಬಹಳ ಕ್ರಿಪ್ಟಿಕ್ ಇದೆ. ಒಂದು ಆಫೀಸ್ ನೋಟಿಂಗ್ ತೋರಿಸ್ತಾ ಇದ್ದಾರೆ. ಡೀಟೇಲ್ ರಿಪೋರ್ಟ್ ನನ್ನ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲಿ 20 ಪೇಜ್
ಇದೇ ಇಂಪಾರ್ಟೆಂಟ್. I will in fact you will not disown this report. This is your report on the basis of which FIR is registered.
After that, this is the report, final report.
ಬೇಡ ಇರಿ, ಇದ್ರ FIR ರಿಜಿಸ್ಟರ್ ಆಗಿರೋ ರಿಪೋರ್ಟ್ ಇಲ್ಲೇ ಇದೆ, ಪ್ರಿಲಿಮಿನರಿ ಎನ್ಕ್ವೈರಿ ರಿಪೋರ್ಟ್ ಇದೆ. The complaint, my lord, complainant said only so much, my lord. If I may, my lord, read only 4 or 5, my lord, lines. Page number, my lord, this is on page number 88.
First petition, sir.
First.
5253, sir.
My lord, ಮಾನ್ಯ SP ರವರಿಗೆ so and so, ACB.
1 minute.
Page number 88, my lord.
ಎಲ್ಲಾನು 88. It is complaint. Complaint, right?
Complaint, ಹೌದು.
ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ
ಅದಾದ್ಮೇಲೆ
90.
You are referring to annexure C,
Annexure C, my lord, page number 88.
but there is, you are not seeking to quash the said report.
I am seeking to quash, my lord, the report which is this complaint, my lord, alleges against me.
You are referring to the report dated 9/8/2017.
Yes, my lord, which
Annexure
is,
C is dated 19/5/2017.
yes, the report, my lord, is dated 9/8/2017.
That is in my statement of objection at annexure R1, 9823.
Let him show. Please wait.
96, my lord, page number 96. In my petition. It is based on this report, my lord. The report starts annexure F on 96. My lord, it is based on this report. If your lordships would kindly see page number, my lord. 1110, page number, my lord, 109. The FIR comes to be registered. Page number 109, my lord, it is on the basis of this report. Sai Datta gives a complaint. Based on Sai Datta's complaint, a report, my lord, is drawn by the police inspector. On Sai Datta's complaint, no FIR was registered. Police inspector, on the basis of Sai Datta's complaint, my lord, draws a preliminary inquiry report. And on the basis of this report, my lord, FIR comes to be registered. And this report of Inspector Mr. Mirza Ali and the FIR, they are on the same date. And Mirza Ali, my lord, inspector in his report vividly mentions about Sai Datta's complaint as the beginning. My lord, so practically, my lord, my humble submission is de facto complainant, official complainant, and the FIR.
Yes, what is the allegation against you?
Allegation against me, if your lordships would kindly have, my lord, this report of Mr. Mirza Ali, which starts on page number, my lord, 1096. A detailed, my lord, background is culled out, which was, my lord, apprised to this honorable court by my my learned senior. And if your lordships would kindly have, my lord, page number 99, ಪ್ಯಾರಿಗ್ರಾಫ್ ನಂಬರ್ 9 ಇಂದ ಅಲ್ಲಿ ತನಕ ಸರ್ಕಾರ KMF ಗೆ ಹೆಂಗ್ ಜಮೀನ್ ಕೊಡ್ತು ಅಂತ ಕವರ್ ಆಗಿದೆ. ಪ್ಯಾರಿಗ್ರಾಫ್ ನಂಬರ್ 8 ತನಕ 9 ಇಂದ ಇಂಪಾರ್ಟೆಂಟ್ ಮೈ ಲಾರ್ಡ್, ಇಟ್ ಟೇಕ್ಸ್ ರೆಫರೆನ್ಸ್ ಟು ಮೈ ಲಾರ್ಡ್ ಆಲ್ ಆಫ್ ಅಸ್. ಪ್ಯಾರಿಗ್ರಾಫ್ ನಂಬರ್ 9 ಇಂದ ಓದ್ಬಿಡ್ತೀನಿ, ವಿಚ್ ಇಸ್ ಆನ್ ಪೇಜ್ ನಂಬರ್ ಮೈ ಲಾರ್ಡ್ 99. KMF ನ ಕೋರಮಂಗಲ ನಿವೇಶನದಲ್ಲಿ DBOT ಆಧಾರದ ಮೇಲೆ ಜಮೀನನ್ನು ಅಭಿವೃದ್ಧಿಪಡಿಸಲು ದಿನಾಂಕ 19/12/2017 ದಿನಪತ್ರಿಕೆಗಳಲ್ಲಿ ಪ್ರಕಟಣೆ ನೀಡುವುದರೊಂದಿಗೆ ಈ ಮಾಹಿತಿಯನ್ನು ದಿನಾಂಕ 12/12/2017 ಟೆಂಡರ್ ಬುಲೆಟಿನ್ ಅಧಿಕಾರಿಗಳು ಸಹ ಕಳಿಸಿಕೊಟ್ಟಿರುತ್ತಾರೆ. KMF ನವರು ಕರೆದಿರುವ ಟೆಂಡರ್ಗೆ 7 ಜನ ಗುತ್ತಿಗೆದಾರರು ಟೆಂಡರ್ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. KMF ಸಂಸ್ಥೆಯವರು ತಾವು ನೇಮಿಸಿಕೊಂಡಿದ್ದ ಮೇಸರ್ಸ್ ವಿಲ್ಟರ್ ಸ್ಮಿತ್ ಅಸೋಸಿಯೇಟ್ಸ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ಎಂಬ ತಜ್ಞರ ಕಂಪನಿಯ ಸಹಾಯದಿಂದ 4 ಜನ ಗುತ್ತಿಗೆದಾರರ ಟೆಂಡರ್ಗಳನ್ನು ತಾಂತ್ರಿಕವಾಗಿ ಪರಿಗಣನೆಗೆ ತೆಗೆದುಕೊಂಡು ಅತಿ ಹೆಚ್ಚು ಬಾಡಿಗೆ ನಮೂದಿಸಿದ್ದ PVK ಕಂಪನಿಗೆ ಟೆಂಡರ್ ನೀಡಬಹುದೆಂದು ಅಭಿಪ್ರಾಯಪಟ್ಟಿದ್ದು 17/3/2008 ನಡೆದ KMF ನ 17/3/2008 ನಡೆದ KMF ನ 192ನೇ ಆಡಳಿತ ಮಂಡಳಿ ಸಭೆಯಲ್ಲಿ ಟೆಂಡರ್ ಪ್ರಕ್ರಿಯೆಯ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಒಪ್ಪಿಗೆಗಾಗಿ ಮಂಡಿಸಿದ್ದು ಪ್ರಸ್ತುತ ಕೈಗೊಳ್ಳಲಾದ ಟೆಂಡರ್ ಪ್ರಕ್ರಿಯೆ ವಿವರಗಳನ್ನು ಪರಿಶೀಲಿಸಿರುತ್ತದೆ. ಈ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಅಂದಿನ ಆಡಳಿತ ಮಂಡಳಿ ಕೋರಮಂಗಲ ನಿವೇಶನದ ಖಾಲಿ ಪ್ರದೇಶವನ್ನು ತ್ರೈಮಾಸಿಕ ಬಾಡಿಗೆ 40 ಲಕ್ಷ ರೂಪಾಯಿಗಳು ಆಧಾರದ ಮೇಲೆ 30 ವರ್ಷಗಳ ಅವಧಿಗೆ ಲೀಸ್ ಆಧಾರದ ಮೇಲೆ ನೀಡಲು ಹಾಗೂ ಲೀಸ್ ಅವಧಿ ಮುಗಿದ ನಂತರ ಅರ್ಹ ಬಿಡ್ಡುದಾರರು ಪ್ರಸ್ತಾವಿತ ಜಮೀನು ಹಾಗೂ ಅದರ ಮೇಲೆ ನಿರ್ಮಿಸಿರುವ ಸಂಪೂರ್ಣ ಕಟ್ಟಡವನ್ನು.
What is the designation of these petitioners? Working as?
My lord, I was working as the director of Hindustan Engineering.
Both are directors?
Both are directors. Hindustan Engineering, and one is the shareholder, that is, my lord, in the connected
private
division.
entities, my lords.
Private entities.
Private entities. Though they are directors, they are private entities of companies. They are
Well,
not even public servants.
Allala, one ನಿಮಿಷ. I'll, my lord, just, my lord, in one line tell the relationship. KMF gives it to PVK consortium on lease. PVK consortium, for the purpose of building, my lord, this entire building on, my lord, 30 years lease basis, forms a special purpose vehicle, SPV, which is, my lord, in the name and style of PVK Koramangala Private Limited. This special purpose vehicle, my lord, would float. There will be another entity called PVK.
Not a public servant.
No, I am not a public servant. I am not a public servant. Both of us are not public servants.
No public servants have approached this court.
There is one minute. First petition. Only what the learned senior counsel Shri Udayawalla appeared, that is only one public servant.
There is something, my lord, which is seriously wrong here, my lord. I'll just point out.
He was also not named in the FIR.
No. No, not named in the FIR. Not named in the FIR.
What is his designation?
He was managing that. Managing director KMF
At the relevant time.
at the relevant time.
ಆಗ್ಬೋದು, ಏನ್ ತೊಂದರೆ ಇಲ್ಲ ಅದು.
You are the directors of which company?
I am the director, my lord, in this petitioner. I am the director of Hindustan Engineering. And in the connected petition, one Mr. Vijay Kumar, my lord. Matepalli Shivaram ಇದೆ. Is
Vijay Kumar ಎಲ್ಲಿದ್ದಾರೆ?
I'm sorry, my lord, Matepalli Shivaram, sorry, my lord, not Vijay Kumar. Matepalli Shivaram is the petitioner in this. Another is Venkatarame Gowda in the connected petition.
Yes.
He is a shareholder in PVK Realtors.
Who is the shareholder?
The petitioner in the connected petition, my lord, Venkatarame Gowda.
Venkatarame Gowda.
Venkatarame Gowda. He is a shareholder in the connected petition, my lord, in a company called PVK Realtors. PVK Shelters. PVK Shelters India Private Limited. And they are just 1% shareholders.
How many shareholders are there?
There, my lord, two shareholders. If your lordships could kindly have, my lord, they have dilated this at paragraph number 20, my lord. If this gives the entire background, small paragraph, page number 11, my lord, of the petition.
Page number 11?
Page number 11, my lord. I'll just, my lord, read for the completion, my lord, paragraph number 18, my lord, small paragraph, 3 paragraphs, page number 11 of my petition. During this paragraph 18, my lord, during this period, members of PVK consortium, the main bidder, approached Hindustan Engineering to seek funding for the project to be developed at the scheduled property, as Hindustan Engineering has invested in wide variety of infrastructure projects ranging from hospitality sector, etc., etc. Paragraph number 19. After negotiation between parties and upon ascertaining the terms of consortium concession agreement, lease deed permitted the consortium and subsequently SPV to change the shareholding pattern of special purpose vehicle and further enter into agreements for developing the scheduled property with participation of third parties. Hindustan Engineering decided to invest in the project. In furtherance of the decision of Hindustan Engineering to invest in PVK shelters, it was decided that P. Vijay Kumar and Mrs. Manjula, who between then held 100%, my lord, only two shareholders who held all the 100% of, my lord, this company, PVK Shelters, my lord, SPV, of the share capital of PVK Shelters, would divest their entire shareholding. Accordingly, 9,990 shares of PVK Shelters held by P. Vijay Kumar were transferred to Hindustan Engineering. The share transfer...
A company with only two shareholders?
Yes. Hindustan Engineering, my lord, was transferred, complete 99%.
Can there be a company with only two shareholders?
Yes. The number of directors. These are all, my lord, permitted. In fact, all these documents were filed with the ROC. I have produced even ROC documents.
Not a company.
I have produced even the ROC document. Two shareholders.
Companies there.
And my lord, the 10 shareholders were left out. Those 10 shares were, my lord, transferred to.
So there were other shareholders.
ಹೌದು ವೆಂಕಟರಾಮೇಗೌಡ.
Then
Yes.
only two shareholders.
ಅಲ್ಲ ಇವ್ ಮೊದ್ಲು ಇಬ್ರೇ ಇದ್ರು, ಮಂಜುಳಾ ಮತ್ತೆ ವಿಜಯ್ ಕುಮಾರ್ ಇಬ್ರೇ ಇದ್ರು. ಮಂಜುಳಾ ಮತ್ತೆ ವಿಜಯ್ ಕುಮಾರ್ ಇಬ್ರುನು ಅವ್ರ ಹತ್ರ ಇದ್ದಿದ್ದು 9,990 shares ನ ಇವ್ರಿಗೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ತಾರೆ ಹಿಂದೂಸ್ತಾನ್ ಎಂಜಿನಿಯರಿಂಗ್ ಗೆ. 10 ಶೇರ್ 10 shares ನ ವೆಂಕಟರಾಮೇಗೌಡ್ರಿಗೆ ಮಾರ್ತಾರೆ ಅಷ್ಟೇ. ಅದು ಸೆಕೆಂಡ್ ಪಿಟಿಷನ್.
That is the basic thing. Two shareholders ಅಂದ್ರೆ it is a partnership firm, not a company.
ಹೌದು.
Yes.
ಅದು ಟೈ ಆಗುತ್ತೆ. As my lord sir rightly said, my lord, two shareholders earlier transferred it to company. ಆ ಕಂಪನಿನಲ್ಲಿ ಬೇಕಾದಷ್ಟು ಜನ shareholders ಇದ್ರು ಅಂತ ಕಾಣುತ್ತೆ. Then left over 10 shares were transferred to Venkatramegowda. This company, after my lord coming in as a funding company, Hindustan Engineering, would, my lord, SPV fund ಮಾಡುತ್ತೆ. SPV will enter into a joint development agreement with another, my lord, company called Mantri Habitat ಅನ್ನೋ ಒಂದು ಕಂಪನಿ. ಅವ್ರ ಮಧ್ಯದಲ್ಲಿ ಡೆವಲಪ್ಮೆಂಟ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು ಆ ಮಂತ್ರಿ ಹ್ಯಾಬಿಟಾಟ್ ನವರು ಡೆವಲಪ್ ಮಾಡ್ತಾರೆ. ಡೆವಲಪ್ ಮಾಡಿದ್ರಲ್ಲಿ 56% ಅವ್ರಿಗೆ, 46% ಅವ್ರಿಗೆ ಅಂತ ಹೇಳಿ ಮಾಡಿದ್ರೆ ಡೆವಲಪ್ಮೆಂಟ್ ಮಾಡಿ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ತಾರೆ. 56% of the proceeds will go to, my lord, SPV, and remaining went to, my lord, the builder. At the end of the day, the KMF, my lord, got its lease rentals. So nobody lost here. My lord, one astounding detail which I wanted to, my lord, say, which may be, my lord, according to, my lord, my humble submission, very important, is that kindly see, my lord, in entire case, the allegations are some institutions took these calls and some institutions, particularly KMF as an institution, committed this entire bamboozlement. An institution, my lord, is allegedly have the only, my lord, now I see the affidavit filed by the government. They say government to KMF ಇದನ್ನ ಈ ಪ್ರಾಪರ್ಟಿನ ಡೈವೆಸ್ಟ್ ಮಾಡೋದಕ್ಕೆ ಕನ್ಕರ್ ಮಾಡಿರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿ ಗವರ್ಮೆಂಟ್ ನವರು ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದಾರೆ. So at the end of the day, my lord, an institution has committed an irregularity. Kindly, my lord, now see section 13, my lord. What is, my lord, alleged?
Which institution? KMF?
KMF.
You are not concerned about that.
I am not concerned, but in the, my lord, lead, they are roping us. My lord, the report says, this report of Mr. Mirza Ali, my lord, brings allegations against us. My lord, that being as it
What is
may,
the allegation? Let
kindly,
us
my
see
lord,
this.
have the investigation report, my lord, which starts at page number 96. I just, my lord, was reading that. Page number 100 ನಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೆ. ಅಲ್ಲಿ ಕೊನೆಯಲ್ಲಿ ಎಲ್ಲ ಸ್ಕಿಪ್ ಮಾಡ್ಬಿಡ್ತೀನಿ. If I may, my lord, very humbly take your lordships. On page number 103, my lord. Paragraph number 15 ಇಂದ ಎಲ್ಲರ ಹೆಸರುಗಳು ತಗೊಳಕ್ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತಾರೆ. Paragraph number 15 ಅಲ್ಲಿ page number 103. KMF ಕೋರಮಂಗಲದ ಜಮೀನನ್ನು DBOT ಅಡಿಯಲ್ಲಿ ಗುತ್ತಿಗೆದಾರರಿಂದ ಟೆಂಡರ್ ಕರೆದು ಅತಿ ಹೆಚ್ಚು ಬಾಡಿಗೆ ನಮೂದು ಮಾಡಿದ್ದ ಪಿ ವಿಜಯ್ ಕುಮಾರ್, ದಟ್ ಈಸ್ ಮೈ ಲಾರ್ಡ್ PVK ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಪ್ರೈವೇಟ್ ಲಿಮಿಟೆಡ್ ಮತ್ತು ಹ್ಯಾಸ್ಕೋ ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಪ್ರೈವೇಟ್ ಸಂಸ್ಥೆಗಳ ಒಕ್ಕೂಟಕ್ಕೆ ವಾಣಿಜ್ಯ ಸಂಕೀರ್ಣ ಅಭಿವೃದ್ಧಿಪಡಿಸಲು ಮಂಡಳಿಯ 192ನೇ ಸಭೆಯಲ್ಲಿ ಅನುಮೋದನೆಯನ್ನು ನೀಡಲಾಗಿತ್ತು.
That is only a fact here.
ಹೌದು,
They have
ಫ್ಯಾಕ್ಟ್.
stated,
ಕೊನೆಯಲ್ಲಿ
not the allegation.
ಹೌದು, ಕೊನೆಯಲ್ಲಿ ಇದರಲ್ಲಿ ಲಾಸ್ಟ್ ನಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಮೈ ಲಾರ್ಡ್ 106 ಇಂದ ವಿಚಾರಣಾಧಿಕಾರಿಗಳ ಅಭಿಪ್ರಾಯ ಅಲ್ಲ, ವಿಚಾರಣಾಧಿಕಾರಿಯ ಅಭಿಪ್ರಾಯ. ಅದರಲ್ಲಿ ಫಸ್ಟ್ ಒಂದ್ 2-3 ಪ್ಯಾರಾಗ್ರಾಫ್ ಸ್ಕಿಪ್ ಮಾಡಾದ್ಮೇಲೆ ಪೇಜ್ ನಂಬರ್ 107 ನಲ್ಲಿ ಥರ್ಡ್ ಬುಲೆಟ್ ಮೇಲೆ ಥರ್ಡ್ ಬುಲೆಟ್ ಇಂದ ಮೇಲ್ಕಂಡ ಎಲ್ಲಾ ಅಂಶಗಳ ಪರಿಶೀಲನೆಯಿಂದ KMF ರವರು ಒಂದು ನಾನ್ ಪ್ರಾಫಿಟ್ ಆರ್ಗನೈಸೇಷನ್ ಆಗಿದ್ದು ರಾಜ್ಯದ ಸಾರ್ವಜನಿಕರಿಗೆ ಮತ್ತು ರೈತರಿಗೆ ಅನುಕೂಲ ಮಾಡಿಕೊಡುವ ಉದ್ದೇಶದಿಂದ ಸರ್ಕಾರದ ನೆರವಿನೊಂದಿಗೆ ನಡೆಯುತ್ತಿರುವ ಸಂಸ್ಥೆ ಆಗಿರ್ತದೆ. ಈ ಕಾರಣಕ್ಕಾಗಿ ಸರ್ಕಾರವು KMF ಸಂಸ್ಥೆಯ ಕಚೇರಿ ಕಟ್ಟಡ ನಿರ್ಮಿಸಲು ಜಮೀನನ್ನು ಹಂಚಿಕೆ ಮಾಡಿದ್ದು, ಸದರಿ ಜಮೀನನ್ನು ಯಾವ ಉದ್ದೇಶಕ್ಕೆ ಸರ್ಕಾರ ನೀಡಿತ್ತೋ ಆ ಉದ್ದೇಶವನ್ನು ಬಿಟ್ಟು ಸರ್ಕಾರ ಸುತ್ತೋಲೆ ನಂಬರ್ ಸೋನ್ಸೋರಲ್ಲಿನ ಆದೇಶವನ್ನು ಉಲ್ಲಂಘಿಸಿ ಸದರಿ ಜಮೀನನ್ನು ಸರ್ಕಾರಕ್ಕೆ ಮರಳಿಸದೆ KMF ದಿನಾಂಕ ಸೋನ್ಸೋರಂದು ನಡೆದ ಮಹಾಮಂಡಳದ 189ನೇ ಆಡಳಿತ ಮಂಡಳಿಯ ಸಭೆ ನಿರ್ದೇಶನದಂತೆ ವಾಣಿಜ್ಯ ಉದ್ದೇಶಕ್ಕಾಗಿ ಸದರಿ ಜಮೀನನ್ನು ಬಳಸಿಕೊಂಡಿರುವುದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಈ ಸಂಸ್ಥೆಯ ಕಾನೂನು ಬಾಹಿರವಾಗಿ PVK ಸಂಸ್ಥೆಗೆ ಲಾಭ ಮಾಡಿಕೊಡುವ ಉದ್ದೇಶದಿಂದ 1998ರಲ್ಲಿ ಹಂಚಿಕೆಯಾಗಿದ್ದ ಜಮೀನಿಗೆ PVK ಸಂಸ್ಥೆಗೆ ಲಾಭ ಮಾಡಿಕೊಡುವ ಉದ್ದೇಶದಿಂದ ಅಂತ ನಮ್ಮನ್ನೆಲ್ಲ ಓಪನ್ ಮಾಡಿಕೊಂಡ್ರು. ಇಲಾಖೆಯ ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರರು ಕಟ್ಟಡದಿಂದ ಕನ್ವೇಯನ್ಸ್ ಡೀಡ್ ಮಾಡಿಕೊಂಡು ಸರ್ಕಾರ ಕಡಿಮೆ ದರದಲ್ಲಿ ನೀಡಲಾಗಿದ್ದ ಜಮೀನನ್ನು PVK ಸಂಸ್ಥೆಗೆ ಪ್ರತಿ ತಿಂಗಳಿಗೆ 40 ಲಕ್ಷ ರೂಪಾಯಿ ಬಾಡಿಗೆಯಂತೆ 30 ವರ್ಷಗಳಿಗೆ ಲೀಸ್ ನೀಡಿದ್ದು, ಲೀಸ್ ಡೀಡ್ ನಲ್ಲಿ PVK ಸಂಸ್ಥೆಯು ಬೇರೆ ಕಂಪನಿಗಳಿಗೆ ಸಬ್ಲೀಸ್ ನೀಡಲು ಅವಕಾಶ ಮಾಡಿಕೊಟ್ಟಿದ್ದು, PVK ಸಂಸ್ಥೆಯವರು ಮಂತ್ರಿ ಹ್ಯಾಬಿಟಾಟ್ ಸಂಸ್ಥೆಗೆ ಸದರಿ ಜಮೀನಲ್ಲಿ ಜಾಯಿಂಟ್ ವೆಂಚರ್ ಮುಖಾಂತರ ವಾಣಿಜ್ಯ ಉದ್ದೇಶದ ಮಾಲ್ ಅನ್ನು ನಿರ್ಮಿಸಿರುತ್ತಾರೆ. 2008ರಲ್ಲಿ ಮೇಲಿನ ನಿರ್ಣಯ ಕೈಗೊಂಡ ಸಮಯದಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದ ಅಂದಿನ ಅಧ್ಯಕ್ಷರು ಮತ್ತು ನಿರ್ದೇಶಕರು ಸಾರ್ವಜನಿಕ ನೌಕರರಾಗಿದ್ದು ತಮ್ಮ ಅಧಿಕಾರವನ್ನು ದುರುಪಯೋಗಪಡಿಸಿಕೊಂಡು PVK ಕಂಪನಿಗೆ ಲಾಭ ಮಾಡಿಕೊಡುವ ಉದ್ದೇಶದಿಂದ ಕಾನೂನು ಬಾಹಿರವಾಗಿ ಸರ್ಕಾರದಿಂದ ರಿಯಾಯಿತಿ ದರದಲ್ಲಿ ಕಟ್ಟಡ ನಿರ್ಮಿಸಲು ನೀಡಿದ್ದ ಜಮೀನಿಗೆ ಕನ್ವೇಯನ್ಸ್ ಡೀಡ್ ಮಾಡಿಕೊಂಡು ಸದರಿ ಜಮೀನನ್ನು PVK ಕಂಪನಿಗೆ ಲೀಸ್ ನೀಡಿದ್ದು, ಲೀಸ್ ಷರತ್ತಿನಲ್ಲಿ PVK ಕಂಪನಿಯ ಸದರಿ ಜಮೀನನ್ನು ಸಬ್ಲೀಸ್ ನೀಡಲು ಅವಕಾಶ ಮಾಡಿಕೊಟ್ಟಿದ್ದು, ಈ ಷರತ್ತನ್ನು ಬಳಸಿಕೊಂಡು ಜಮೀನಿನಲ್ಲಿ PVK ರವರು ಮಂತ್ರಿ ಹ್ಯಾಬಿಟೇಟ್ ಸಂಸ್ಥೆಗೆ ಜಾಯಿಂಟ್ ವೆಂಚರ್ ಮುಖಾಂತರ ವಾಣಿಜ್ಯ ಉದ್ದೇಶದ ಮಾಲ್ ನಿರ್ಮಿಸಿದ್ದು, ಇದರಿಂದ PVK ಕಂಪನಿಯವರು ಮಂತ್ರಿ ಹ್ಯಾಬಿಟೇಟ್ ರವರು ಆರ್ಥಿಕವಾಗಿ ಲಾಭ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ ಮತ್ತು KMF ಸಂಸ್ಥೆಗೆ ಆರ್ಥಿಕವಾಗಿ ನಷ್ಟ ಉಂಟಾಗಿರ್ತದೆ. ಮೇಲ್ಕಂಡ ಖಾಸಗಿ ಸಂಸ್ಥೆಗಳಿಗೆ ಆರ್ಥಿಕವಾಗಿ ಲಾಭ ಮಾಡಿಕೊಡಲು ಕಾರಣರಾದ KMF ನ ಅಂದಿನ ಆಡಳಿತ ಮಂಡಳಿಯ ಸರ್ಕಾರದಿಂದ ಅನುಮತಿಯನ್ನು ಪಡೆದ ಕನ್ವೇಯನ್ಸ್ ಡೀಡ್ ಮಾಡಿಕೊಟ್ಟಿರುವ ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆಯ ಕಾರ್ಯಪಾಲಕ ಇಂಜಿನಿಯರ್ ಅವರಾದ ಸತ್ಯನಾರಾಯಣ MD ಮತ್ತು KMF ನ ಅಂದಿನ ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರಾಗಿದ್ದ ಶ್ರೀ R ರಾಮಲಿಂಗೇಗೌಡರವರುಗಳು ಕಲಂ ಸೋನ್ಸೋರಲ್ಲಿ ಪ್ರಕಾರ ಅಪರಾಧ ಎಸಗಿದ್ದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡು ಬಂದಿರುವುದರಿಂದ ಸದರಿಯವರ ವಿರುದ್ಧ ಪ್ರಕರಣ ದಾಖಲು ಮಾಡಿ ಕ್ರಮ ಕೈಗೊಳ್ಳಬಹುದಾಗಿರುತ್ತದೆ. ಸರ್ಕಾರದ ಆದೇಶದಲ್ಲಿ ಸೋನ್ಸೋರಲ್ಲಿ ಸಾರ್ವಜನಿಕ ನೌಕರನು ತನ್ನ ಅಧಿಕೃತ ಕಾರ್ಯನಿರ್ವಹಣೆಯಲ್ಲಿ ಕೈಗೊಳ್ಳುವ ನಿರ್ಧಾರ ಅಥವಾ ಶಿಫಾರಸುಗಳ ವಿರುದ್ಧ ಭ್ರಷ್ಟಾಚಾರ ನಿಗ್ರಹ ದಳವು ನೇಮಕಾತಿ ಪ್ರಾಧಿಕಾರದಿಂದ ಪೂರ್ವಾನುಮತಿ ಇಲ್ಲದೆ ತನಿಖೆ ಪ್ರಾರಂಭಿಸಲು ಅವಕಾಶವಿಲ್ಲವೆಂದು ಆದೇಶಿಸಿರುತ್ತದೆ. ಪ್ರಾಥಮಿಕ ವಿಚಾರಣಾ ಕಾರ್ಯದಲ್ಲಿ ದೂರುದಾರರು ಮಾಡಿರುವ ಆರೋಪಗಳ ಬಗ್ಗೆ ವಿಚಾರಣೆ ನಡೆಸಿದ್ದು, ಸದರಿ ಜಮೀನನ್ನು ನಿಯಮಗಳನ್ನು ಉಲ್ಲಂಘಿಸಿ ಕಾನೂನು ಬಾಹಿರವಾಗಿ ಖಾಸಗಿಯವರಿಗೆ ಲೀಸ್ ನೀಡಿ ಖಾಸಗಿಯವರಿಗೆ ಲಾಭ ಮಾಡಿಕೊಟ್ಟು ಕೆಎಂಎಫ್ಗೆ ಮತ್ತು ಸರ್ಕಾರಕ್ಕೆ ನಷ್ಟವನ್ನು ಉಂಟು ಮಾಡಿರುವುದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಪ್ರಕರಣ ನಡೆದ ಕಾಲಕ್ಕೆ ಕೆಎಂಎಫ್ನ ಅಧಿಕಾರಿಗಳು, ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆ ಅಧಿಕಾರಿಗಳು ಹಾಗೂ ಸರ್ಕಾರಿ ಅಧಿಕಾರಿಗಳು ಖಾಸಗಿ ಬಿಲ್ಡರ್ಗಳೊಂದಿಗೆ ಸೇರಿ ಸರ್ಕಾರಕ್ಕೆ 200 ಕೋಟಿ ಭ್ರಷ್ಟಾಚಾರ ಎಸಗಿರುವುದು ದೂರುದಾರರಾದ ಸೋನ್ಸೋರ್ ಅವರು ತಮ್ಮ ದೂರದಲ್ಲಿ ತಿಳಿಸಿಕೊಂಡಿರ್ತಾರೆ. ಆದ್ದರಿಂದ ಪೇಜ್ ನಂಬರ್ 109 ಆದ್ದರಿಂದ ಪ್ರಕರಣದಲ್ಲಿ ಅಂದಿನ ಕೆಎಂಎಫ್ನ ಆಡಳಿತ ಮಂಡಳಿ ಹಾಗೂ ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರು ಹಾಗೂ ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆ ಅಂದಿನ ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರರು ಸೋನ್ಸೋ ಇವರ ಮೇಲೆ ಪ್ರಕರಣ ದಾಖಲಿಸಿ ತನಿಖೆ ಕೈಗೊಳ್ಳಬಹುದಾಗಿದೆ ಅಂತ ಇವರು ಹೇಳಿದ ತಕ್ಷಣ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಅವತ್ತೇ FIR. So though not, my lord, FIR does not reflect the name. So much is said under the complaint to implicate everybody. My lord, my humble submission is this. In the teeth of, my lord, first, my lord, only one legal submission. No, my lord, the allegation is KMF took the land from the government.
Yes.
And on a particular board meeting, 189th board meeting, KMF, my lord, in its board meeting decided that ಇದನ್ನ ಸುಮ್ಮನೆ ಇಟ್ಕೊಳ್ಳೋದು ಬೇಡ, ವೇಸ್ಟ್ ಆಗ್ತಾ ಇದೆ ಜಮೀನು. ಯಾಕೆಂದ್ರೆ ನಮಗೆ ಹೆಡ್ ಆಫೀಸ್ ಕಟ್ಕೊಳ್ಳೋದಕ್ಕೆ ಅವರು ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ನವ್ರು ಟೈಮ್ ಮಾಡ್ಕೊಡ್ಲಿಲ್ಲ. ಯಾರಿಗಾದ್ರೂ ಲೀಸ್ಗಾದ್ರೂ ಕೊಟ್ಟು ಇದರಿಂದ ಬರೋ ಇದನ್ನ KMF ಯೂಸ್ ಮಾಡ್ಕೊಳ್ಳೋಣ ಅಂತ ದಿಸ್ ವಾಸ್ ಅ ಬೋರ್ಡ್ ಡಿಸಿಷನ್ ಟೇಕನ್. My lord, there is no individualization of this decision. This is the board decision by an institution. Now, my lords, may kindly allow me to, my lord, just impress upon your lordship, section 13, my lord, how it read previously.
In this report, there is reference to PVK company,
PVK company.
not to any individual officers or directors.
ಇಲ್ಲ, PVK company.
To PVK company.
PVK company ಏನ್ ಮಾಡುತ್ತೆ ಅಂದ್ರೆ, my lord, incidentally what happens, PVK company, we were all, my lord, the later entrants. PVK company wanted funding. Then PVK company had floated an SPV. SPV now funding ಮಾಡಿದ್ದು by buying shares, my lord. We are all part and parcel of, my lord, that consortium. In so far as there is no allegation, my lord, against Mantri Builders, because Mantri Builder was only a developer. ಅವ್ರಿಗೊಬ್ಬರು ಕರೆದಿಲ್ಲ. ನೀವು ನೆಕ್ಸ್ಟ್ ಏನೇನ್ ಮಾಡ್ತೀರಾ? ನಮಗೆಲ್ಲ ನೋಟಿಸ್ಗಳು ಕೊಟ್ರು, ನೀವೆಲ್ಲ ಈ ತರ ಮಾಡಿ ಒಂದಲ್ಲ 10 ನೋಟಿಸ್ ಕೊಟ್ಟು ಆ ನೋಟಿಸ್ಗಳೆಲ್ಲ ಇದನ್ನೇ ಹೇಳಿದ್ರು, ಏನಂತ ನೀವೆಲ್ಲ ಸೇರ್ಕೊಂಡು ಈ ಕೆಲಸ ಮಾಡಿದೀರಂತ. ನಾವು ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದಾಗ ದ ಮ್ಯಾಟರ್ ವೆಂಟ್ ಟು ನೆಕ್ಸ್ಟ್ ಲೆವೆಲ್. ಅದರಲ್ಲಂತೂ ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ನಲ್ಲಿ they came and made direct allegations. You are all part and parcel of the partners of crime.
You are now armed with that anticipatory bail.
Anticipatory.
But the anxiety to approach this court under 482.
My lord, now there is a case against us, my lord. Now the corporate entities, my lord, our value will come down.
Let them file the charge sheet, final report.
I'll, my lord, satisfy 2 things on the legal grounds, my lord. My lords, may kindly allow me to, my lord, make these short submissions, my lord.
Even though I heard you patiently for all these times. No.
I understand. My lord, I'll plead it and I'll leave it to your lordship's discretion.
So many things behind the screen.
Please.
I'll plead it and I'll leave it to your lordship's discretion. My lord, only 2 submissions. Red submission ಮಾಡ್ಬಿಡ್ತೀನಿ. Kindly, my lord, have section 13, my lord, how it read earlier. May I continue in the afternoon, my lord? I am conscious of the time.
No.
Another 10 minutes, my lord, I'll complete.
PCA.
ಕೆಳಗಡೆ ಇರುತ್ತೆ ಅಲ್ಲಿ ಫುಟ್ನೋಟ್.
PC Act, my lord. My lord, before I go to section 13, may just me, my lord, read the definition of, my lord, public servant, which is forthcoming from section 2C.
Why? You are not a public servant.
I'm not a public servant. But, my lord, what happens is, entire section 13(1)C, 13(1)C and 113(1)D are, my lord, they are on the bedrock of a particular public servant, individual, my lord. Person which is, my lord, repeatedly used will never, my lord, institutionalize.
All these arguments are premature in nature.
Please,
ನಾನು ಒಂದೇ ಒಂದು ಸಬ್ಮಿಷನ್ ಏನಂದ್ರೆ ಇಷ್ಟೇ ನನ್ನ
ಅವ್ರ
ಸಬ್ಮಿಷನ್.
ಅಬೇಟ್ಮೆಂಟ್ ಸೆಕ್ಷನ್ ಆಡ್ ಮಾಡಬಹುದು, ಅವಾಗ ಬರ್ತಾರೆ.
What would happen is,
The anticipation is
ಮುಂದೆ
that
ಅಲ್ಲ ಅದನ್ನ ಆಲ್ರೆಡಿ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. They have
ಎಲ್ಲಿ
given us, my lord, much hints. They have given us much hints.
Premature.
My lords, if he has committed an offense, then we will hold him.
These arguments at a later stage.
On legal
Not at-
submission, my lord, on legal submissions, my lord, my only one submission is this. Sai Datta files a complaint, and my lord, Mr. Mirza Ali, my lord, gets into all these. All that Mirza Ali, my lord, says is there is an irregular
Yes,
transfer.
yes.
Can, my lord, I ask myself this, my lord, and I leave it to your lordships. Can an irregularity under any stretch of imagination amount to a crime? It is, my lord, at the most an irregularity. Now, you lodge this, you come to know, you wake up to this after 9 years.
Sir, you don't hold the brief for KMF.
I'm not holding.
And why you are justifying the acts of KMF?
In fact, I am not, my lord. But what?
Private entity.
My lord,
Their allegation is.
then, my lord, I have only 2 submissions, my lord. I have only 2 submissions. I am not named in the FIR, but they repeatedly called me and harassed.
For that, you have obtained anticipatory bail.
Yes. And, my lord, giving me liberty to approach this honorable court if I be added. My lords may kindly, my lord, reserve.
When this petition was filed,
17,
15.
17.
the petitioners are successful in their attacks.
Frustrating the whole process. And
7
4
years.
times it is heard, my lords, and 4 times it is now coming before definitive.
Public money. It is our tax-paid money. Then
At the end of the day, my lord, there is no loss to anybody.
No, my lords.
KMF, my lord, has got its lease land rentals. It is not that, my lord, KMF gave it off
we
to
do
somebody,
not
my
know,
lord.
sir, whether, see, we do not know whether there is any truth in the allegations or not. If there is no truth, we will be more than happy. But if there is a truth,
It has to
what
come
should
out.
happen?
It should come out.
At the threshold, we squeeze the neck.
Judgment.
Very unfortunate this is. 4 plus 3, 7 years.
7 years.
7 years, 2017.
Unfounded anxiety shown by the private persons.
My lords,
to quash the FIR.
2023 Supreme Court has observed that in
Sir,
corruption.
citation ಯಾಕ್ಬೇಕು sir?
ಅಲ್ಲ.
Sheer common sense.
Please, my lords, even otherwise, the Supreme Court says in corruption cases, there should be a hands-off approach by the High Court. Even if it is regular penal offense, we can understand is what they say. That 2023, now more importantly, my lords, what my bedrock of my submission would be, it is premature. There is, my lords, KMF originally seeks for a certain land aspect.
ಏನು ಮುಗೀತ ಕೇಳಿ. Yes.
Nandinneniಲ್ಲ, my lord, I leave
See, it is a premature.
I leave it to your lordship's discretion, my lord. In fact, my lords have heard me, my lord, patiently. I am patiently, my lord. I am grateful, my lord. I would only, my lord, these are my closing submissions. These 2 petitioners, my lord, we are, of course, my lord, we were a bit early, hurried in coming before the court, as your lordships rightly said. We were a bit hurried. My lord, my humble submission is, we are nowhere, my lord, either a part of that KMF's decision. Even if, my lord, such a decision is found to be, my lord, incorrect or whatsoever irregular, we are nowhere a part of that. We come, my lord, at a later stage. And, my lord, we could not have been arrested.
Why
like
you
this.
had that anxiety to approach this court?
Because, my lord, we were repeatedly harassed by them.
You cannot say same thing again and again when you
That's
are
all, my
armed
lord.
with anticipatory bail.
That's all, my lord, my humble submission. I leave it to you.
If it is your argument for anticipatory bail, definitely you are entitled, not for quashing. What is your locus?
Of course, my lord. In fact, my lord, our locus is this, my lord.
It goes to the basic.
We were repeatedly, and when we filed for anticipatory bail petition, they clearly hinted that we are going to be roped in. That's all, my lord. I humble submission. If my lord, in fact, I have placed, my lord, that objection statement, which was filed by them during my objection, my lord, anticipatory bail, my lord, hearing. That objection statement, my lord, is vividly clear that, my lord, what was going to be, my lord, against us. What was brewing against us. Now, if your lordship would kindly permit, my lord, I'll, my lord, take your lordships to that objection statement for a, lord, short moment.
Anticipatory bail file ಆಗಿರೋ objection.
That will, he will highlight his objections.
No, my lord, see, the learned senior counsel is pointing out objections filed in his anticipatory bail petition, not these proceedings.
ಇದ್ರಲ್ಲ
ಆಂಟಿಸಿಪೇಟರಿ ಬೇಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್
ನಾವು
ಏನೋ
anticipate-
ಹೇಳಿದ್ದಾರೆ, ಅದಕ್ಕೆ ಇದ್ರ ಇಲ್ಲಿ ಹೇಳಿದ್ರೆ 482 ಅಲ್ಲಿ ಹೇಳಿದ್ರೆ.
Nothing.
My objections in these petitions are not being pointed out.
Yes.
Allah, that was the reason we came to court. Why we came to court, my lord, that was the precise
Some
reason.
justification for approaching the court. I do not see any justification.
My lord, I bow down, my lord, I leave to your lordship's discretion on that.
Yes, anything?
My lords, there is the facts of the case, my lords, I'll put it in a nutshell. As way back as 1984, KMF seeks for a certain land. Please,
Yes,
please.
yes.
Well,
One minute. Facts, I think, Leonard Senior.
I'll only
has
put it,
already
that's why I'm putting it only in a nutshell. If not, my lords, I will,
Continue at 2:30.
please.
Evidence appreciation. Judgment.
Oblations.
ನೆನ್ನೆದ್ರದ್ದಾ? ಮಹೇಂದ್ರದಿದೆ, ಹೇಳ್ತೀನಿ. ಹೌದು. ಹ್ಮ್ ಹ್ಮ್.
ಅದರಲ್ಲಿ ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಅದರಲ್ಲಿ ಅದು ಡಿಕ್ಟೇಷನ್ ಕೂಡ ಹೋಗಿ ಬಂದ್ರು ಸೀನಿಯರ್. ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಮ್ಯಾಟ್ರ್ 17 ಅಲ್ಲೂ ರೀಚ್ ಆಗೋದು. ಗೊತ್ತಿಲ್ಲ ನಮ್ಗೆ ಹೊಸ ಕಾಲೇಜ್. ಅದು ಐఏ ರೀಕಾಲ್ ಆಯ್ತಾ ಮೇಡಮ್? ಐఏ ರೀಕಾಲ್ ಆಯ್ತು.
ಇಲ್ಲೇ ಇದ್ದಾರೆ, ಕಳಿಸ್ಲಾ ಮೇಲೆ? ಇಲ್ಲೇ ಇದ್ದಾರೆ, 22 ಅಲ್ಲಿ. ಐ ಡೋಂಟ್ ವಾಂಟ್ ಮಹೇಂದ್ರ ಇಲ್ಲಿಗೆ ಬರಕ್ ಹೇಳ. ಅವ್ರದ್ದು 1 ನಿಮಿಷ ಫೈಂಡ್ ಔಟ್ ಮಾಡ್ತೀನಿ ಮೇಡಮ್, ಅವ್ರ ನಂಬರ್ ಇಲ್ಲ. ಮಹೇಂದ್ರ ಸರ್ ಎಲ್ಲಿದ್ದೀರಾ?
ಮೆಮೋ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್. ಇಲ್ಲ ವೇಟ್ after the element of
sir.
Element of
Court of sir. Court of sir.
ಮೇಡಮ್ ಅವ್ರು ಇಲ್ವಂತೆ, ನಂಬರ್ ತಗೊಂಡ್ರಿ. 776
ಬೇಡ ಬರ್ಕೊಟ್ಬಿಡಿ.
Court of sir.
if I mention
Court of sir.
ಹೇಳಿ ಹೇಳಿ ಸರ್, ಹೇಳಿ.
ಸರ್ ಧಾರವಾಡ ಹೈಕೋರ್ಟಿಂದ ಮೇಡಮ್ ಎಜಿ ಅಶೋಕ್ ಕಟ್ಟಿಮನಿ ಅಂತ ಹೇಳಿ.
ಎಜಿ ಏನಾ ಸರ್?
ಎಜಿ.
ಓಕೆ ಸರ್, ಒಂದು ಡೌಟ್ ಇತ್ತು.
ಹೇಳ್ರಿ ಮೇಡಮ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 2 to 4 ಒಂದೇ ಕ್ರೈಮ್ ಇದೆಯಲ್ಲ, ಒಬ್ಬರೇ ಅಕ್ಯೂಸ್ಡ್ ಇದಾರಲ್ಲ?
ಒಬ್ರೇ ಅಕ್ಯೂಸ್ಡ್ ಅಂದ್ರ ಅವು ಪೆಟ್ಷನ್ ಸೇಮ್ ಸಿಮಿಲರ್ ಮ್ಯಾಟರ್ ಕಾಣ್ತೈತ್ರಿ ಮೇಡಮ್. ಅವು
ಒಂದೇ ಕ್ರೈಮ್ ನಂಬರ್ ಇದೆ.
ಹೌದು, ಸಪ್ರೇಟ್ ಕ್ರೈಮ್
ಅಬ್ದುಲ್ ರಜಾಕ್ ಮನೆಯವರೇ, ಎಲ್ಲರೂ ಅವರೇ
ನಂಬರ್ ಏನೇ ಇದಾವ. ನಾನು ಅದ್ರ ನೋಡಿದೆ ಮೇಡಮ್,
ನೋಡಿ ಸರ್.
ಕ್ರಿಮಿನಲ್ ಪೆಟಿಷನ್
ಅವಾಗ ಒಂದಷ್ಟೇ ಬರುತ್ತೆ.
ಮೇಡಮ್ ಅಡ್ವೊಕೇಟ್ ಫಾರ್ ಪಿಟಿಷನರ್ ನಾನು. ಅದರಲ್ಲಿ ಕ್ರೈಮ್ ನಂಬರ್ ಕಾಮನ್ ಇದೆ, ಚಾರ್ಜ್ ಶೀಟ್ ಬೇರೆ ಬೇರೆ ಆಗಿದೆ.
ಕ್ರೈಮ್ ನಂಬರ್
ಅದೇ ಹೇಳಿದ್ದು.
ಏನ್ ಹೇಳಿ ಸರ್? ಚಾರ್ಜ್ ಶೀಟ್ ಬೇರೆ ಬೇರೆ ಹಾಕಿದಾರಾ?
ಚಾರ್ಜ್ ಶೀಟ್ ಬೇರೆ ಇದೆ ಅಂತ ಮೇಡಮ್, ಕ್ರೈಮ್ ನಂಬರ್ ಒಂದೇ.
ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಎಲ್ಲ ಸೇಮ್
ಎಲ್ಲ ಸೇಮ್. ಆಕ್ಚುಲಿ ನೇಚರ್ ಆಫ್ ಅಫೆನ್ಸ್ ಸೇಮ್ ಏನೇ, ಅದರಲ್ಲಿ ಏನು ಅಂತ ದೊಡ್ಡ ವ್ಯತ್ಯಾಸ ಏನಿಲ್ಲ.
ಅಲ್ಲ, ಅವಾಗ ಒಂದೇ ಅಲ್ವಾ ಮೇಂಟೈನಬಲ್?
ಏನಮ್ಮ, ಇಲ್ಲ ಒಂದೇ ಹಾಕ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. ಅಲ್ಲ ಕ್ರೈಮ್ ನಂಬರ್ ಇದೆಯಲ್ಲ ಬೇರೆ ಬೇರೆ.
FIR ಒಂದೇ ಇದೆಯಲ್ಲ?
ಇಲ್ಲ CC ನಂಬರ್ ಬೇರೆ ಬೇರೆ ಇದೆಯಲ್ಲ.
CC ನಂಬರ್ ಬೇರೆ ಇದೆ. ಸೊ ಅದಾಗೆ ಅನ್ಸದಾ?
ಹೌದು
ಮೇಡಮ್ ಬರ್ತಾರೆ.
ಅಲ್ಲ ನೀವೇ ಕ್ಲಬ್ ಮಾಡ್ಕೊಂತೀರಿ, ಮಾಡ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ, ನಮಗೇನು ತೊಂದರೆ ಇಲ್ಲ.
ಸೇಮ್ FIR.
FIR ಸೇಮ್ ಮೇಡಮ್, ಆದ್ರೆ ಚಾರ್ಜ್ ಶೀಟ್ ಬೇರೆ ಬೇರೆ ಆಗಿದೆಯಲ್ಲ. ಇದ್ರಲ್ಲಿ ನೋಡಿ CC ನಂಬರ್ 268/2020.
ಕ್ಲಬ್ ಮಾಡ್ಸದಾ?
ಕ್ಲಬ್ ಮಾಡಿಸಿ, ಏನು ತೊಂದರೆ ಇಲ್ಲ. ಕ್ಲಬ್ ಮಾಡಿ, 3 ಮ್ಯಾಟರ್ ಕ್ಲಬ್ ಮಾಡಿ, ತೊಂದರೆ ಇಲ್ಲ.
ಹಲೋ ಸರ್ ಮಹೇಂದ್ರ ಅವರಾ? ಸರ್ ಉಮಾ ಮೇಡಮ್ ಕೋಟಿನ ಮಾತಾಡ್ತಾರ.
Come back tomorrow. There's a medical emergency. He's going to the mother is bail. Yeah, no, whenever the lordship is the agency is there because it's a massive surgical. No, first fresh matter. I will mention the lordship if you want. Yes, ma'am. No need for me to mention. So kind of you. Okay.
Waiting for? Urgent ಅಂದ್ರೆ ಏನೋ medical ground. ಅಂತ ಬರ್ಕೊಟ್ಟಾರೆ. ಅದಕ್ಕೆ ಮಾಡಿದ್ರು ನಾಳೆ ಬೆಳಗ್ಗೆ ಅಂತ. ತುಂಬಾ emergency ಅದಕ್ಕೆ ಬರ್ಕೊಟ್ಟಿದ್ದೀನಿ. ತಗೊಂಡಿದ್ದೀನಿ. ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ. ಇದಕ್ಕೆ submission. ಬರ್ತಿದ್ದೆ. ಆಮೇಲೆ ಇವಾಗ ಲೆಟರ್ ಬೆಳಗ್ಗೆ ಬರೀತಾರೆ. medical ನಾನು ಯಾಕಂದ್ರೆ ಅಂದ್ರೆ ಆಗಲ್ಲ ಆನ್ಸರ್ಗೆ ಆಗಲ್ಲ ನಾನು ಬಿಟ್ಟಿಲ್ಲ ನಾನು ಬಿಟ್ಟಿದ್ದೆ ಅವಳು ಬಿಟ್ಟೆ ಅಂತ ಹೇಳಿದ ತಕ್ಷಣ ರಿಯಾಕ್ಷನ್ ಇವಾಗ ಹೆಂಗ್ ಬರುತ್ತೆ ಅದೇ ರಿಯಾಕ್ಷನ್ ಸರ್ ಮೆನ್ಷನ್ ಮಾಡಿ
ಮೆನ್ಷನ್ ಮಾಡ್ಲಾ
ಮಾಡಿ ಮಾಡಿ
ಮೇಡಮ್?
ನಾನು ನಿಮ್ಮನ್ನ ಹುಡುಕ್ದೆ ಎಲ್ಲಿ ಕಾಣಿಸ್ಲಿಲ್ಲ ನನಗೆ ಫೈಲ್ ತರಿಸ್ತೀನಿ ಅಂದ್ರೆ
ತರಿಸಿದ್ರಾ?
ತರಿಸಿದ್ದೀನಿ
ನೋಡಿ ಅಲ್ಲಿ ರಿಸ್ಪಾಂಡೆಂಟ್ ಶಾರ್ಟ್ ಟೈಮ್. ಐ ಡಿಡ್ ನಾಟ್ ಸಿಕ್ ಟೈಮ್ ಮೇಡಮ್.
ಮೆನ್ಷನ್ ಮಾಡಿ ಮೇಡಮ್
ಒಂದ್ಸರಿ ತೋರಿಸ್ತೀರಾ?
ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕು
ಇಲ್ಲ ನಾ ಮಾಡ್ತೇನೆ. ತಾವು ತೋರಿಸಿದ್ರೆ ಅವ್ರಿಗೆ ಏನೋ ಒಂದು ಚೇಂಜ್ ಆಗ್ಬೋದು ಅಂತ.
ಅದಕ್ಕೆ ನಿಮ್ಮ ಹತ್ರ ಎಷ್ಟೊಂದು ಹೇಳೋದು ಯಾಕೆ ಚೆನ್ನಾಗಿದೆ ಮೇಡಮ್ ನಾನು ಚೆನ್ನಾಗಿ ಕಂಪ್ನಿ ಆಗ್ತದೆ ನಾನು ಕೇಳ್ಕೊಂಡಿರಲಿಲ್ಲ ಕಡೆ ಕಿಸ್ಕೊಂಡು ಕೇಳ್ಕೊಂತ ಮಾತ್ರ ಕೇಳ್ತು ಬೇರೆ ಇನ್ನೇನಾದ್ರು
ಆಲ್ಮೋಸ್ಟ್ ಅಲ್ಲೇ ಸಿಗ್ತಾ ಇದ್ದಾವೆ. ಕ್ಲಾಪ್ ಹಾಕಿ ಎಲ್ಲ ರೆಡಿ ಇಟ್ಟಿದ್ದೀನಿ ಅದನ್ನ. ಇವಾಗ್ಲೂ ಕ್ಲಿಯರ್ ಕೊಡೋದ್ರಲ್ಲೇ ಇದೆ. ಅವರು ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಅಲ್ಲೂ ಅಮೌಂಟ್ ಬರ್ತಿದ್ದಾರೆ, ಏನಕ್ಕೆ ಅಂತ ಬರ್ಕೊಂಡು ಮೇಡಮ್ ಇದೆಲ್ಲ 23 ಲಿಸ್ಟ್ 23 ನಮ್ಮ ಅದೊಂದೇ ಇಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅದು ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ? ಅದು ಕೊಟ್ಟಲ್ಲ ನೀವು ಅಲ್ಲ ಅದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೊಂಡ್ಬೇಕಂದ್ರೆ ಏನಿಲ್ಲ 5 ಮಿನಿಟ್ಸ್ ಇಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಆಗೋಗ್ಬೋದು. 30 ಹಾಕೊಳ್ಳಿ, ಇಲ್ಲ ಅಂತಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಎನಿ ಡೇ 24 ಎನಿ ಡೇ.
ಸೌಮ್ಯ
70 ಬೇಡವಾ?
ಬೇಡ ಬೇಡ, ಹೆವಿ ಆಗುತ್ತೆ. ಇದು ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 23 39. ಅದೊಂದು ಫೋನ್ ಮಾಡಿ ಹೇಳಪ್ಪ ಅವ್ರಿಗೆ. ಮೆಮೊ ಬೇರೆ ಕೊಡ್ಬೇಕು, ಅದ್ರಲ್ಲಿ ಕೊಡ್ತಾರೆ ಮೇಡಮ್. ಕೇಳಿರೋದು ಮುಂಚೆ ಮಾತ್ರ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಮಾಡಿಲ್ಲ ಅಂತ ಇವ್ರು ಕೇಳಿಲ್ಲ, ಹ್ಯಾಂಡ್ ಟೈಪ್ ಕೇಳಿಲ್ಲ. ರವಿ ಅವರೇ 4570 ಇವತ್ತಿಂದು ಲಿಸ್ಟ್ 27 ಇವ್ರಿಗೆ ಹೋಗ್ಬೇಕು. GHಗೆ BH ಹತ್ರ ಇದೆ. GH ಹತ್ರ ಹೋಗುವಾಗ ಇನ್ನೊಂದು ಡೇಟ್ ಕೊಡ್ತಾರೆ. ಸೌಮ್ಯ ಅದೊಂದು ಡೇಟ್ ಕೊಡ್ತಾರೆ, ಗೊತ್ತಿಲ್ಲ, ಅವ್ರ ಹತ್ರ ಇದ್ದೀನಿ, ಅಲ್ಲಿದೆ ಅಂತೆ. ಅದಕ್ಕೆ ಇದೊಂದು ಬರ್ಕೊಟ್ಬಿಡಿ, ಸೀರಿಯಲ್ ನಂಬರ್ 23 ಇದೆ. ಇನ್ಸ್ಟೆಡ್ ಆಫ್ 24/9 13 ಮೆಮೊ ಜೊತೆಗೆ ಮೆಮೊ ಕೊಡ್ತೀವಿ. ಇಟ್ಕೊಂಡಿರಿ, ಕರಿತೀವಿ. ಯಾಕೆ ಮಾಡಿ
ಕರೆಕ್ಟಾಗಿ ನಾನು ಅವಾಗ ತಾನೇ ಸೆಲ್ಲಿಂಗ್ ಮೋಡಿಗೆ ತೆಗ್ದಿದೆ ಅರ್ಥ ಆಗ್ತಿಲ್ಲ ನೀನು ಫೋನ್ ಮಾಡಿದೆ ಫೋನೇ ತೆಗ್ದಿಲ್ಲ ಕಣಂತ ಮುಗಿ ಸೆಲ್ಲಿಂಗ್ ಮೋಡಲ್ಲಿ ತೆಗ್ದಿಲ್ಲ matter pertaining to Dharwad bench.
My lords, kindly. This 2 serial number 19. Lord, it was previously listed on 12/8. Adjourned to my lord. At my request, my lord, it was adjourned to my lord 10/9. On 10/9, my lord, other side took time, my lord. I did not seek time. I was.
What you want?
But
Directly come to the point.
interim order is not extended, my lord.
The same matter which we argued today morning, my lords, about 2O and 2S. The inspector having registered.
Matter is covered by, my lord, series of judgments of this honorable court. Lord, on that day, my lord, 12/8, I have,
It was not extended.
Lord, the other side took time. Lord,
The fact I am saying.
Yeah,
it was
yes,
not
ma'am.
Time doesn't have anything to do with the non-extension of the interim order. Let him make submission on the point of the issue, my lord.
Yeah, yes. I am not, Lord, I am not attributing anything on my learned friend. But on 12/8, I took time. Other date, he took.
ಯಾವಾಗ ಹೋಗಿದೆ?
Matter is somewhat, it is covered by, my lord.
Obliged.
Matter pertaining to Dharwad bench. Serial
My
number.
lord, I am for the petitioner. For the respondent, my lord. My lord, the petitioner had earlier filed a petition, my lord, which was disposed of by observing that the inquiry which has been initiated relating to the caste verification committee is still pending. And therefore, the petition filed by the petitioner seeking quashing of the FIR was disposed of, my lord. My lord, subsequently, my lord, in criminal petition number 102039 of 2018, wherein a similar complaint was filed, has been quashed by observing that as on the date when the certificate was issued, my lord, I have produced the order passed in criminal petition number 102039 of 2018, my lord.
Now
It is
this
in the
is
file, my
crime
lord.
number, which crime number?
My lord,
This
it is
petition
relating to, my lord, in criminal petition number 102039 of 2018, that was a petition filed by Srimati Shamla Bandekar.
No, sir, I am asking you, this petition pertains to crime number 21.
Yes, my lord, crime number 21.
Earlier petition came to be dismissed.
It was also for the same crime, my lord, and it was disposed of only on the ground that the enquiry is still pending before the district caste verification committee, and therefore at present the application filed by the petitioner cannot be considered.
Yes.
My lord, my respectful submission is wherein a similar was filed against one
Maybe, sir,
Shamla B. Bandekar.
Your prayer is already rejected by dismissing your petition. Now again, why you are before this court?
But even now the order passed by the DCBC has not been set aside. It's still staring at it. My lord, as on the date when they allege that there is misuse of the caste certificate, my lord,
So
the
now
caste certificate.
you are before this court based on the order of the coordinate bench, is it? No, that
Yes, my
cannot be
lord.
done. That cannot be done. When an opinion is already formed and your petition is already dismissed, I cannot follow the verdict of the coordinate bench to undo this order. How can it be? If
My
you are
lord, it
agreed
is-
by this, you have to challenge this, that's all.
My lord, my respectful submission is as far as on the date when the alleged offense is alleged
Whatever
to
it
have
may
been.
be, you cannot force the court to follow the order passed by the coordinate bench. If you are aggrieved, you challenge this order. Get it set aside. That is the only way out. You cannot produce some other order and compel me to relook into your opinion and reform it. No, it is unknown to law. If there is any change circumstance, you can, but it is not the way. Which is the order you are placing reliance on?
My lord,
Where is that
the
order?
order which is, my lord, along with the memo, I have produced it in the file, my lord, it is in the file in criminal petition number 102039 of 2018, my lord.
This is dated 2022. My order is of
Yes, my lord,
2021, much prior to that.
yes, my lord, subsequent to that, my lord, this order was
How can you
passed.
compel the court to follow that? And what is the
My lord,
basis?
because, my lord, the facts of my case and that case are entirely same, my lord.
Maybe even then, I am not bound by that order. That is subsequently passed order.
Yes. So, my lord, in this case also, my lord, the alleged offense
No, sir,
was,
sorry. No, nothing. The petitioner oblique accused is before this court trying to quash the FIR registered in crime number 21 of 2007 of Karwara Town Police Station. Registered for the offences punishable under sections 198, 199, 200, 420 IPC. This is para number 2. This is order dated 20th July 2021. Third so and so para number 3. Para 4. Learned counsel for the petitioner submitted that coordinate bench of this court in criminal petition number 102039 of 2018 allowed the similar petition and the FIR registered in crime number 123 of 2018 of Karwar Town Police Station was quashed, and therefore the present petition is also required to be allowed in the interest of justice. Per contra, learned counsel for learned special counsel for so and so. Respondent number 1 submits that the petitioner had already approached this court seeking similar relief in criminal petition number 1335 of 2007, and the same came to be dismissed with a order dated 20th July 2021. Under such circumstances, the petition is liable to be dismissed in limine. Peruse the material point for consideration. It is admittedly the petitioner had filed similar petition in criminal petition number 1335 of 2007 seeking similar relief of quashing the FIR referred to above. The said petition came to be dismissed on merits. Has filed this petition only on the basis of the subsequent order passed by the coordinate bench of this court dated 13th June 2022 in criminal petition number 102039 of 2018. I do not find 18 to contend that the court has to follow the subsequent decision of the coordinate bench of this court to undo the effect of the order dated 20th July 2021 passed by this court. I do not find any merit in the said submission. The petitioner cannot compel this court to follow the order of the coordinate bench of this court, which was passed subsequently. Hence, I answer the above point in the negative and proceed to pass the following petition dismissed.
Please.
Serial number 2, M. Mohan Kumar.
Appearing for the petitioners in this matter, my lords. My lords, sir,
My lord,
it is a
sir,
case in which,
respondent.
my lords, sir, it is a case in which I draw the attention of this honorable court to the complaint at page number 14. It is there.
Why there are 3 petitions?
My lords, because there are 3 charge sheets, my lords, having distinct numbers.
Okay.
3 charge sheets having distinct crime, CC numbers. Crime number is the one and the same, accused is the same, my lords. It may be clubbed together, my lords. 3 petitions.
I will issue notice to respondent.
My lords, sir, there is one issue for being addressed, my lords. It is covered by the Honorable Supreme Court's decision. Here, my lords, sir, an exoneration has resulted insofar as the allegations as against the petitioner, my lords, sir. And my lords, the exoneration is totally on merits, sir. And that, my lords, it has been done by the Karnataka Lokayukta. The inquiry report is at page number 110.
I will consider it on merits. Let the respondent take notice. Who will take
My lords,
notice?
until then, let there be the proceedings in criminal court, let it be in abeyance, my lords, sir. It is a settled position of law, my lords, sir.
So what is the proceedings before the court? What is the
It is
stage?
at HPC, my lords, sir. Stage of HPC.
Already final report is filed.
Right. Final report has been filed and HPC stage is what is pending now, my lord, sir. If not by this honorable court.
Huh? Government.
Please, Modi.
No, who is for the respondent?
Government, my lords.
I am respondent number of state, my lords.
Respondent number?
1.
You are representing the state.
Yes, my lords.
You are the HCGP or what is your designation?
AGA, my lords.
AGA. Learned AGA. Learned AGA takes notice for respondent number 1. Issue notice to respondent number 2. Complainant.
The complainant, my lords, himself has, who is the government, has accepted the inquiry report, also exonerated this petitioner of charges, my lords. It is also forthcoming there. And they are the witnesses in this case. Even if this is going to be proceeded further.
Yes. I will take up the matter next week, somewhere next week. I will consider that your application for stay. Yes. After 1 week. Yes. ಅದೇನು ವೆರಿಫೈ ಮಾಡ್ಲಿಕ್ಕೆ ಕೊಡಿ 11.
Last one matter, list 2, serial number 11.
Petitioner, my lordship, has taken steps, my lordship. Proposed dependent number 8 and 9.
Who filed this IA 1 of 2021?
Well, petitioner.
What is that for? ಅದೇನೋ ಒಂದು ಹೇಳಿ. ಇದು ಇಲ್ಲಿ ಕಂಟಿನ್ಯೂ ಮಾಡಿ. They are already brought on record by amending the cost title. On the basis of the order dated 24/3/2021, under such circumstances, IA 1 of 2021 does not survive for consideration, hence the same is dismissed. Next, IA 1 of 2019 was filed seeking stay of the further proceeding before the trial court, which was filed in the year 2019. I do not find any reason to keep the application pending, hence IA 1 of 19 is also dismissed. Next, learned counsel for the petitioner paid PF for issuance of notice to respondent number 8 and 9. Issue notice. Yes.
Entry mart extend ಮಾಡಿ.
Interim order ಎಲ್ಲಿದೆ? ಇದೆಯಾ? ಇದೆಯಾ? ಇವತ್ತಿಗಿದ್ರೆ extend ಮಾಡಿ. Next. ಯಾವ್ದಿದೆ ಮತ್ತೆ? ಅದು ಕರೀರಿ.
Passport matter, serial number 7. Krishna Kumar KK.
May I, my lordships are directed to prepare a chart of offences. Just made a small note.
This matter was heard for some time.
Heard for some time, my lord. This matter, my lords, wherein prenatal diagnostic and abortion, my lords. Successive petition, my lords. Last week, this matter had come up.
Correct. What is the allegation against each of the
Yes,
accused?
each, the chart that I have prepared, my lords.
This petitioner is
Accused number 11.
11.
11.
This bail was granted to
Accused number 9.
Accused number 9, my lords.
accused number 9.
Yes.
In all, there are 12 accused.
In all, there are 13 my lords, one accused, against one accused, my lord, there is a stay. Pass in the quashing criminal petition that has been filed, my lord.
So in all 13 accused.
In all 13, out of which one is, my lords, under stay. But ಇದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ, ಅವ್ರನ್ನು accused number 5 ಅಂತ ಹೇಳಿಲ್ಲ, ಬಟ್ ಅವ್ರದ್ದು ಏನೇನ್ ರೋಲು ಅನ್ನೋದನ್ನು ಎಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಲಮ್ ನಂಬರ್ 17 says.
Now tell me.
Yes.
What is the role attributed to accused number 11? That is the
Yes,
petitioner.
accused number 11.
What is the role of accused number 9?
Yes.
Who was granted bail?
Yes.
Whether you are entitled for parity?
Yes.
Yes.
9 first head.
Last page, your lordship, the second page contains, in the third page, my lords, accused number 9 is there.
Pagination ಇಲ್ಲ.
My lords?
No pagination.
No, sorry, it's a third page, my lords, sorry. I 6 page ಇದೆ, note
Number
just ನಾನು
ಹಾಕ್ಬೇಕಲ್ವಾ?
ಇನ್ಫಾರ್ಮಲ್ ಆಗಿ ಕೊಟ್ಬಿಟ್ಟೆ, ಸಾರಿ my lords, I should have done it. Serial number ನಲ್ಲೇ ಬರ್ತಿದೆ, 9th.
Serial number?
9, accused number 9 is serial number 9.
Yes.
Lords.
He is on bail now.
He is on bail.
Yes.
In response to the inquiry by the FIR, my lord, husband of CW2, against whom there is an interim order, my lord, has shared the contact details of accused number 8 and said that he will diagnose the sex of the fetus in the womb of CW2. And on 22/2/2024, called accused 8 through mobile and said that he is sending CW2 to him to get her scanning done and check what is the child in the stomach, and he should give him some commission out of the money received from them. Then, my lords, in the sum, accused number 6, 7, and 13, who are absconding now, as per their instructions, my lord, accused number 8, 9, 10, and 11 used to bring pregnant ladies to the place of scanning, is what the allegation.
Yes, what is the allegation against 11?
Against accused number 11, my lords, in the next place, called A6 over mobile phone on 5/5/2024, and as per instructions, as instructed by A6, went near the temple and joined accused 10 and picked up CW2 and brought her near the house of CW10. Then, along with Accused number 6 and 9, my lord, brought CW to back to her husband A5 in FIR. And there ಅವರು 3 ಜನನು ಸೇರ್ಕೊಂಡು CW2 ಹಸ್ಬೆಂಡಿಗೆ ಭ್ರೂಣದಲ್ಲಿರೋ ಹೆಣ್ಮಗು ಅಂತ ಹೇಳಿದ್ದಾರೆ ಅಂತ. This is the allegation. This third allegation is common. The police have divided Milord's accused number 6, accused number 7 and 30. They are friends. They were doing the scanning. And these accused number 8, 9, 10 and 11 were helped them in driving, bringing the clients to the place as per their direction. And these other accused persons, my lords, 1 to 4 and 12, they have conducted, or they used to conduct this abortion, is what the sum and substance of the allegations. Only, my lords, here, as per the charge sheet, my lords.
1 minute, 1 minute. Only ground charge sheet is already filed on Thursday.
Lords.
Granting bail to accused number 9. Only ground is that the charge sheet is already filed.
Yes.
No other grounds.
And one more is that, my lords, the alleged scanning took place at the CW10's place.
No such discussion.
It is there. Lords, kindly see, para 12, page 8 ತಾವು ನೋಡಿದ್ರೆ.
ಏನಿದೆ?
Ma'am, lords.
Yes.
Learned counsel for the petitioner has submitted that CW10 so and so is actually involved in the offense, but she is shown as witness. But unfortunately, this petitioner is cited as accused and has been in custody since so and so. It is
That is the submission made by
yes,
the counsel.
yes. It is relevant to note that while considering bail application, court is not expected.
Not
so and so.
expected
Then,
to
my
go.
lords, it has been. My only submission is this, my lords. Here, if lordship may kindly see, as per if you go by the police version, first, my lords, on 22/4, the CW2 was taken to checkup, and then, my lords, again she was asked to come after some time, and my lords, on 6/5/5, my lords, again she was taken to on that day, my lords, both the day CW10, both the day accused 10 has taken her, and on the second day accused number 11 was there, is what the case ಅವ್ರ A6 ಗೆ ಅವ್ರು ಫೋನ್ ಮಾಡಿದ್ರಂತೆ. A6 asked him to go and join A10 and he went there and ಅವ್ರ ಜೊತೆಗೆ ಅವರು CW10 ಮನೆಯವರಿಗೆ ಕರ್ಕೊಂಡು ಬಂದಿದ್ದಾರೆ. Then my lords, there as per the prosecution version itself, it was accused number 6 who tells her that the child is the womb is a girl and what do you want to do with? Then she says that I have to talk to my husband, and then they brought her to near the place where accused 5 and CW3 were staying. Their accused 5 requested them to remove this, and then A6 gives him the contact of accused number 1.
Now only accused number 9 is on bail.
Yes,
No one
accused
else.
number 9 is on bail. Accused number 5, my lords, against him there is stay, hence he is not arrested.
Yes.
And 3 accused persons, that is accused number 6, 7 and 13 are, my lords, still absconding as in the date of charge sheet. I don't know any subsequent arrest or development, my lords, not within my. Even with this, my lords, A6, if even prosecution case is accepted as it is, my lords, A6, A1 and A12 appears to be the prime accused, my lords. And all others, my lords, have played some role knowingly, unknowingly, peripheral roles they have been attributed. Even if lordships may kindly see the charge sheet, my lords, charge sheet, my lords, column number 70,
Page number.
Page, my lords, charge sheet, page number 36, lords, not in my petition. Lordship got it. In the last paragraph, they say, ಆರೋಪಿ 6, 7 ಮತ್ತು 13 ರವರುಗಳು ಸ್ನೇಹಿತರಾಗಿದ್ದು, ಇವರುಗಳು ತಮ್ಮ ಬಳಿ ಭ್ರೂಣಲಿಂಗವನ್ನು ಪತ್ತೆ ಮಾಡುವ ಸ್ಕ್ಯಾನಿಂಗ್ ಮಿಷಿನ್ಗಳನ್ನು ಅಕ್ರಮವಾಗಿ ಇಟ್ಟುಕೊಂಡು ಗರ್ಭಿಣಿ ಹೆಂಗಸರುಗಳಿಗೆ ಕಾನೂನುಬಾಹಿರವಾಗಿ ಭ್ರೂಣಲಿಂಗ ಪತ್ತೆ ಮಾಡುತ್ತಿದ್ದು, ಇವರುಗಳ ಬಳಿಗೆ ಗರ್ಭಿಣಿ ಹೆಂಗಸರನ್ನು ಸಂಪರ್ಕ ಮಾಡಿ ಕರೆದುಕೊಂಡು ಬರಲು ಆರೋಪಿ 8, 9, 10, 11 ರವರುಗಳು ಮುಖಾಂತರ ಕರೆಸಿಕೊಂಡು ಕಾನೂನುಬಾಹಿರ ಭ್ರೂಣಲಿಂಗವನ್ನು ಪತ್ತೆ ಮಾಡಿದ್ದು, ನಂತರ ಇವರುಗಳ ಆರೋಪಿ 1, 3, 2, 3, 4 ಮತ್ತು 12 ರವರುಗಳ ಬಳಿಗೆ ಹೆಣ್ಣು ಭ್ರೂಣಗಳನ್ನು ಕಾನೂನುಬಾಹಿರವಾಗಿ ಗರ್ಭಪಾತ ಮಾಡಲು ಗರ್ಭಿಣಿಯರನ್ನು ಕಳಿಸುತ್ತಿರುತ್ತಾರೆ.
They are all middlemen.
My humble submission is that will not here even
They
if it is
identify the pregnant woman
No.
and persuade them to go there.
ಅಲ್ಲಲ್ಲ, there is nothing with great respect, my lords, even ಯಾವ್ದೋ ಸ್ಟೇಟ್ಮೆಂಟ್ ಗಳಲ್ಲಾಗಿ even ಇದರಲ್ಲೂ ಬಂದಿಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಕೂಡ.
I am saying it is the contention of the prosecution.
No,
that
even
they are the
their contention is also not that. If lordship may kindly see, if there is such thing, ಯಾರನ್ನ ನಾವು ಕರೆದ್ವಿ, ಯಾರು ಇಲ್ಲಿ only one abortion that has taken sufficient. Yes, my lords, for that, in that I have neither solicited anybody
That is
nor
your
shared
defense.
anything.
That is your defense.
No, our head prosecution prakara, it is not my defense. Our prosecution case talli kuda nanna patra irodu, I accidentally called A6. I called, you lost me kindly see. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಅಲ್ಲಿ ಏನು ಇಲ್ಲ ನನಗೆ ಇದು ಆಶ್ಚರ್ಯ ಬರೋದು ಯಾಕೆ ಅಂತಂದ್ರೆ, A9, A10, A11 ಎಲ್ಲ ಅರೆಸ್ಟ್ ಮಾಡಿ ಅವ್ರದ್ದು ಏನು ರಿಮ್ಯಾಂಡ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕುವಾಗ, ಆಸ್ ಆನ್ ದಟ್ ಟೈಮ್, ಲಾರ್ಡ್ಸ್, allegedly the voluntary statement was there with the police, because remand application does refer to the voluntary statement.
What statement of?
Voluntary statement of these accused persons was there with the police, allegedly, because remand application talks about it, and as per that, an entirely different version is given. Now, those voluntary statements are made available. There, even then itself, police had, we have allegedly said before the police the new role that is attributed to us in the charge sheet. But remand application is completely silent about this new role.
Now, what is the allegation in the remand report?
In the remand application, the allegation against me was that I got my wife's pregnancy terminated. Similarly, accused number.
What is there in your voluntary statement?
Now I see in that ಅವತ್ತು termination ಮಾಡಿಸ್ದೆ ಅಂತನೂ ಇದೆ. ನನ್ನ ನೆಂಟಿದ 2 ತಿಂಗಳ ಹಿಂದೆ ನಾನು termination ಮಾಡಿಸಿದ್ದೆ
That is
ಅಂತನೂ
the
ಇದೆ.
information given by you.
No, not only that. That voluntary statement also says all these things. ನಾನು ಅವತ್ತು ಅವ್ರು ಇವ್ರನ್ನೆಲ್ಲ ಕರ್ಕೊಂಡು ಹೋದೆ ಬಂದೆ ಅಂತ ಈಗ ಏನು ಹೇಳ್ತಾ ಇದ್ದಾರೆ. This is also there, but remand application is silent. My only submission is that, my lords, these are cooked up to suit their convenience. Of course, something might have happened. Nannanna, I have been summoned only on the reason that they have allegedly found my number in the accused number 6 CDR. Where is the CDR? God only knows. It is not a subject matter of, it is not a part of charge. The summons, the notice that was issued to me only says that there are some calls that has come to you through, even the remand application says that, because there were certain telephone calls made to my number from absconding accused number 6's number, hence I have been summoned. But that CDR is not even part of the charge. Entire charge sheet na ತಗೊಂಡು ಹಾಕಿದ್ದೇನೆ, even it is not there. Even, my lords, my second submission, my lord, accused the CW2, my lords, the allegations that are made here, the sections that are offenses that are alleged, my lords, my humble submission is, but for even assuming, accepting the facts alleged by the prosecution as true, my lords, only 312 would apply. 312 ಅಂತಂದ್ರೆ only 3 years of imprisonment. If the pregnancy is advanced, then 7 years of imprisonment. All other sections would apply only in the absence of consent of the women. ಇಲ್ಲಿ entire 161 statement allagli ಅಥವಾ CW3, who happens to be a sister of A5, who allegedly was accompanied to the place of abortion or on the day of abortion. There she states about the conversation that has taken place between CW2 and CW3. All that reveals that there was no force or it was not done against the will or consent of CW. In the absence of that, there is no materials to state that. Even if it is accepted that it is so, then there is not even a single word in the statement of CW2 or in the statement of CW3. Those are the only 2 eyewitnesses to the case, and apparently a victim to the case, that what was she wanted, whether she was forced to, all these things, it is silent. She follows and she does everything. Perhaps she was in agreement with her husband.
1 minute. Yes, what is it?
My lord, the charge sheet, my lord, the allegation against.
No, who was having the scanning machine out of these 13 accused?
Lord, it is 6, 7 and 13, my lord.
6,
7,
A6.
13.
Okay. Who used to determine the sex of the fetus? So only they, 6, 7
Yes,
and
my lord.
A6. Allegation is only A6.
8, 9, 10 and 11, my lord, they used to bring these pregnant women to the accused number 1.
8, 9, 10 and 11.
Yes, my lord.
Similar allegations.
Yes, my lord.
They used to bring this
They used to
pregnant
bring-
women
Yes, ma'am.
for scanning
Yes, my lord. For scanning.
and pursued for
Yes.
MTP.
Yes,
MTPL abortion.
please.
Parity.
For A9, my lord.
A9 already on bail.
Yes,
This petitioner is accused number 11. Similar allegation.
yes.
Yes. So. The petitioner being accused number 11 is seeking grant of bail. He was apprehended on 10/5/2024. Since then, he is in judicial custody. Initially, the FIR was came to be registered. Against accused number 125. On the basis of the first information lodged by Dr. Bettaswamy. Bettaswamy is a district surgeon. Is
District.
the complainant?
Is a complaint. Yes.
District surgeon,
Our district health officer.
DHO,
DHO.
district health officer. After investigation, charge sheet is came to be filed. Against accused numbers 1 to 13. For the various offences as referred in above. The allegations made against the present petitioner is that he had a contact with accused number 6, who was having a scanning machine installed unauthorizedly and illegally. Persuaded CW2 to undergo scanning. The CW2 dash a pregnant woman to undergo scanning for the purpose of sex determination. That is the only role played by him.
Yes, my lord, that is the allegation.
This petitioner took CW2, accused number 6,
Yes, my
for
lord.
scanning.
Yes.
No, on the instructions of accused number 6, my lord, he has taken for the scanning. Yes, yes, my lord, that is the allegation.
Similar allegations appears to be done against accused number 8, 9, and 10. Similar allegation.
8, 9, 10.
10 and 11.
Yes,
11 is the petition. 8, 9, and 10.
10 and 11.
Huh?
10 and 11.
11 is the petitioner.
Yes, ma'am.
Learned counsel for the petitioner produced the copy of the order dated 3rd September 2024. Passed in criminal miscellaneous 5259 of 2024. By the learned 3rd Additional District and Sessions Judge Mandya, sitting at Srirangpatna. Allowing the petition filed under section 439 of CRPC by accused number 9. By observing that the charge sheet is already filed and the petitioner is not required for further investigation. When similar allegations are made against the present petition, I am of opinion that the petitioner is also entitled for the benefit of parity with accused number 9. It is not the contention of the prosecution that the petition, no criminal antecedents.
No.
No.
Petitioner is having any criminal antecedents. Under such circumstances, the petitioner may be enlarged on bail subject to conditions which will.
one submission, now the matter is submitted, then the SC number is given, that may also be. First, could see only there.
Then counsel for the petitioner submits. Now the matter is committed to the Sessions Court.
The additional district concession judge.
Pending in SC 3061 of 2024 on the file of
Third additional district concession judge
third
sitting at
additional district
Srinagar.
concession. Judge Mandya sitting at
Srinagar.
Srinagar. Adana operative portional adana. Yes.
Serial number 9, D Latif.
Counsel for the petitioner is absent, no representation. Is not.
To pass over matter, serial number 31, Maya Valla, Vandana PL. PP Patil.
ಇದು ಒಂದೇ ಇರೋದು.
Non-petition and page number 88 of the complaint, non-petition, not this. My lords, I want my lords, as my lords have already said that my lords has been apprised in terms of the facts of the case. I only would seek my lords to bring attention to few prepositions of law which.
You restrict your argument only to these two petitions. 56253, 56703, where the petitioners are not the public servants.
Lords, even the other one is where the learned senior counsel has argued, Shri Udayawalla. That is
He
one
is
where,
not a public servant.
no, he is a public servant.
So I will deal with it separately,
Please, my lords,
because these two are not the public servants.
please, my lords.
Dispose of these two petitions under a common order.
My lords, even that, my lords, I have only a few crisp submissions to make.
Maybe first you restrict your submissions only with regard to these,
Please, my
who are
lords.
not the public servants.
My lords, it's a settled principle of law, my lords, that unless until the FIR does not, the complaint does not disclose a commission of a cognizable offense, interference under 482 is not called for, is what is a settled position of law. I have the latest judgment of the Supreme Court, my lords, which says that 482 is a sparingly to be exercised jurisdiction. And
You are for respondent number 2.
please, my lords, the then ACB and currently the loci.
It is not amended. Petition is not amended. Petition is not amended.
My lords, one of the main petition was amended, it was posted, the rest of them.
24/8/2023, I amended my petition.
No, you are not in 53, 562. Nodi, ಇನ್ನೊಂದ್ರಲ್ಲಿ ನೋಡಿ.
ಮಾಡಿದ್ದೀರಾ? I will amended the cost paper.
ಇಲ್ಲಿ
ಯಾವ್ದು ಇಲ್ಲ.
ಬರೀ ಹಿಂಗ್ ಹೇಳ್ಬೇಕು ಅಂತ ಗೊತ್ತಾಗ್ಬೋದು.
Amend ಆಗಿಲ್ಲ.
ಅದೇ ಓಡಾಡೋದಿಲ್ಲ ಸ್ವಲ್ಪ.
You should not have.
Yes.
Start ಮಾಡ್ಲಿ. ಮತ್ತೆ ಕೇಳಿ. ಸುಮ್ಮನೆ ಹೇಳ್ತಾರೆ, once election ಅನ್ನೋ comment.
ಅದಾಗಿದೆ ಬೇರೆ.
She will pass a separate order in your matters ಅಂತ ಹೇಳಿದ್ದಾರೆ.
Yes.
Please, my lords. My lords, my only respectful submission is the complaint is filed by one person claiming to be a social activist, my lords, who states a certain set of facts before in his complaint, my lords. In the said complaint averment, there are, I'll just read it, my lords, in petition number.
He is only a whistleblower.
Kind of, my lords, but whether from the complaint averment, is there a cognizable offense forthcoming is the crux of the issue which this honorable court may have to deal with, my lords, especially in case of a interference under 480. Because the Supreme Court says, my lords, as late as Neharaka infrastructure judgment, my lords, it says when they provide a premise in which there can be an interference. And that interference, my lord, solely is based on the fact that if the complaint does not even provide for a commission of a cognizable offense, yes, interference is warranted as such. Now here, my lords, in the complaint, it is based on 3 parameters, my lords. Firstly, my lords, I'll read the 3rd paragraph. Dinanka 19/5/2001.
Number.
My lords, page number 88, my lords, annexure C, petition number 56253. This is a complaint.
Yes.
Dinanka 19, my lords, 3rd paragraph from the top, my lords. I don't want to bother my lords with other details. It only gives factual things. The allegation per se start here. ದಿನಾಂಕ 19/5/2000 ಕ್ಯಾಬಿನೆಟ್ ಅನುಮೋದನೆ ಇಲ್ಲದೆ PWD ಇಲಾಖೆ KMFFಗೆ 4 ಎಕರೆ 14 ಗುಂಟೆ ಜಾಗವನ್ನು ಬೊಮ್ಮನಹಳ್ಳಿ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಕಚೇರಿ ರಿಜಿಸ್ಟರ್ ಮಾಡಲಾಗುತ್ತದೆ. ಅಚ್ಚರಿ ಎಂದರೆ ರಿಜಿಸ್ಟರ್ ಮಾಡಲು ಕೇವಲ 10 ದಿನಗಳ ಈ ಜಾಗವನ್ನು ಪರಭಾರಿ ಮಾಡಲಾಗುತ್ತದೆ. What is relevant is, my lords, though the land has been allotted way back in the year 1984, there is a sale deed executed abruptly at certain point in time, much after the lapse of the allotment, where they have been holding from 1984 till a certain period in 2008.
No, allotment of land is
1984.
1998.
No, my lords. 1984 is the application. 1986 is where it is allotted. I will show from the preliminary report. My lords,
is it a lease or grant?
it was a grant kind of a thing, my lords. And why these become important is, my lords, the complaint clearly says that firstly, there was no sale deed. A sale deed is executed in a manner not known to law. And within 10 days of that, there is some kind of a disbursement.
Deed is dated?
My lord, sale deed is dated 19/5/2008.
2008.
Please.
Then within 10 days?
Within 10 days, there is some kind of dispersal. Is a complaint ever meant? It has been given off to someone else. Actually, they give it on a long lease, my lords, in this present case. Now, further, my lords, ದಿನಾಂಕ 29/5/2008 KMF PVK ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಎಂದ ಕಂಪನಿಗೆ ಜಾಯಿಂಟ್ ವೆಂಚರ್ಗೆ ಇದ್ದು ಇದನ್ನು ಪರಭಾರಿ ಮಾಡುತ್ತದೆ. That is, my lords, 10 days after that. This is forthcoming from the complaint. I'm not taking assistance of anything else. Next minutes. ನಂತರ ಹಲವು ಕಂಪನಿಗಳಿಗೆ ಈ ಜಾಗ ಪರಭಾರಿ ಆಗುತ್ತದೆ. It gets shifted hands from 1 to 1 and 1 to 1 and 1 to n. PVK ನಂತರ ಈ ಜಾಗವನ್ನು ಹ್ಯಾಸ್ಕೋ ಕಂಪನಿಗೆ, ನಂತರ PVK ಕೋರ್ಮಂಗಳ ಎಂಬ ಕಂಪನಿಗೆ, ನಂತರ ಹಿಂದೂಸ್ತಾನ್ ಇನ್ಫ್ರಾಸ್ಟ್ರಕ್ಚರ್ ಎಂಬ ಕಂಪನಿಗೆ, ಅನಂತರ ಮಂತ್ರಿ ಹ್ಯಾಬಿಟ್ಯಾಟ್ ಎಂದ ಕಂಪನಿಗೆ ಸತತವಾಗಿ ಜಂಟಿ ಅಭಿವೃದ್ಧಿ ನೆಪದಲ್ಲಿ ಪರಿಭಾರಿ ಆಗುತ್ತದೆ. So it gets changed in hands in a very clandestine manner. The allegation of the complaint, my lord, says. Though it has been under KMF for a good number of days, because in the first paragraph he says, in the second paragraph, 19/9/84 KMFಗೆ ಅಧ್ಯಕ್ಷರಾದ ಶ್ರೀ KB ಮಲ್ಲಪ್ಪನವರು ರಾಜ್ಯ ಸರ್ಕಾರಕ್ಕೆ ಪತ್ರ ಬರೆದು, ಮಿಲಾಡ್ ಸರ್, ಪ್ಯಾರಾ 2, I may just go back to read. 1984 ಕಂಪನಿಗೆ ಆದ ಅಧ್ಯಕ್ಷರಾದ ಸೋಯನ್ಸೋರ್ ಅವರು ಸರ್ಕಾರಕ್ಕೆ ಪತ್ರ ಬರೆದು MG ರಸ್ತೆ ಖಾಸಗಿ ಕೊಠಡಿಯಲ್ಲಿರುವ 46,000 ರೂಪಾಯಿ ಬಾಡಿಗೆ ನೀಡಿ ಕಾರ್ಯನಿರ್ವಹಿಸುತ್ತಿದ್ದು ಸರ್ಕಾರದಿಂದ ಜಾಗ ಕೊಟ್ಟರೆ ಸ್ವಂತ ಕಟ್ಟಡ ಕಟ್ಟಬಹುದು ಎಂದು ಮನವಿ ಮಾಡಿರುತ್ತಾರೆ. So the pretext on which it was taken was to have their headquarters building, privately self-owned building.
Yes.
And that was allotted. No sale deed was executed. At some point in time, sale deed is executed, and within 10 days of the sale deed, it is given on a joint venture to various other people. Next paragraph, please. Next page. ಅಚ್ಚರಿ ಏನೆಂದರೆ ಪರಭಾರಿಯು ಕಾನೂನು ಉಲ್ಲಂಘಿಸಿ KMF ಅವರು ಸರ್ಕಾರಕ್ಕೆ ಖಾಸಗಿ ಬಿಲ್ಡರ್ಗಳಿಗೆ ಕೋಟ್ಯಾಂತರ ರೂಪಾಯಿ ವಂಚಿಸಿ ಸರ್ಕಾರ ಜಗದನ್ನು ಬೃಹತ್ ವಾಣಿಜ್ಯ ಸಂಕೀರ್ಣ ಕಟ್ಟಿರುತ್ತಾರೆ. So there is a commercial construction that has come up in a manner, it has been handed over dehors the provisions of the law is their specific submission. Next, ಇದರಲ್ಲಿ ವ್ಯಾಪ್ತಕ್ಕೆ ಭ್ರಷ್ಟಾಚಾರ ನಡೆದಿದ್ದು ಬಿಲ್ಡರ್ಗಳು, KMF ಅಧಿಕಾರಿಗಳು, PWD ಅಧಿಕಾರಿಗಳು ಸೇರಿಕೊಂಡು ಸರ್ಕಾರಕ್ಕೆ 200 ಕೋಟಿ ರೂಪಾಯಿ ಬೆಲೆ ಬಾಳುವ ಭೂಮಿಯನ್ನು ವಂಚಿಸಿ ಭಾರಿ ಪ್ರಮಾಣದ ಭ್ರಷ್ಟಾಚಾರ ಎಸಗಿರುತ್ತದೆ. My lords, my submission, my lords, is now, my lords, may please permit me to state that in Lalita Kumari's judgment, my lords, the Honorable Supreme Court has categorized about 4 category of cases, and corruption being one of them. The Honorable Supreme Court was an opinion that if there is a complaint and if there is a requirement, a preliminary inquiry should be held before going into it. In those days, my lords, it was actually held that in all cases it should be. Now it has been watered down to say that depending on the facts and circumstances, it is required that if there is a situation, there is some allegation being made, then a responsible officer should hold a preliminary inquiry. Based on that, my lords, may have my statement of objection in the main petition. A preliminary inquiry has been held.
Yes.
In the preliminary inquiry, my lords, I'll only point out 2 or 3 paragraphs. The statement of objection, my lords, in writ petition number 46675. 46675. For 6675, my lords, there are statement of objection filed on 13th September 2023. Page number 11, my lords, it starts.
Yes.
I would like to draw only attention to certain paragraphs, my lords. Page number 12. Para 4, my lords. Before this, my lords, the factual aspects are para 3, 1986, if my lords could see on 3rd line, is the date on which the application is made, and para 3, 1998, 4 acres, 14 guntas are allotted.
Page number 12.
Page number 12, my lords, para 3. KMF ಇನ ಕೋರಿಕೆಯಂತೆ ಪರಿಗಣಿಸಿ ಸರ್ಕಾರ ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆ ಉಪ ಕಾರ್ಯದರ್ಶಿಗಳು ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ರಂದು ದಿನಾಂಕ 1986 ರಂದು ಮುಖ್ಯ ಇಂಜಿನಿಯರ್ ಕಟ್ಟಡ ವಿಭಾಗ ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆ ಇವರಿಗೆ ಬರೆದು, and then, my lords, the next paragraph is 3/3/1998 is the allotment. Lords, page number 12, the statement of objection is filed on 13th September. My lords have
You
it.
are referring to preliminary investigation report?
Please, my lords.
ಅದರಲ್ಲಿ ವಿಚಾರಣಾಧಿಕಾರಿಯ ಅಭಿಪ್ರಾಯ.
No, my lords. ಟಿಪ್ಪಣಿ ವಿಚಾರಣೆ ಕಾಲಕ್ಕೆ ಸಂಗ್ರಹಿಸಿದ ದಾಖಲೆಗಳು. Statement of objection, my lords, is dated 13th of September 2023. Running page number 11, my lords have.
ಟಿಪ್ಪಣಿ, yes.
Tippani. Next page is 12, my lords.
Yes.
12, my lords, I was reading para 3. This only gives facts, but para 4 is relevant. I want to point out something on para 4. ಸದರಿ ಜಮೀನಿಗೆ ದರ ನಿಗದಿಪಡಿಸುವ ಕಾಲಕ್ಕೆ 1986ರಲ್ಲಿ KMF-ಗೆ ಭೂ ಮಂಜೂರು ಮಾಡುವಾಗ ಅಂದು ನಿಗದಿಪಡಿಸಿದ ಎಕರೆಗೆ 50,000 ರೂಪಾಯಿ ದರವನ್ನು 1998ರಲ್ಲಿಯೂ ಕೂಡ ನಿಗದಿ ಮಾಡಿರುತ್ತಾರೆ. ದರ ನಿಗದಿಪಡಿಸುವ ಕಾಲಕ್ಕೆ ಸೂಪರಿಂಟೆಂಡೆಂಟ್ ಇಂಜಿನಿಯರ್ ಕಟ್ಟಡಗಳು ವೃತ್ತಿ ಬೆಂಗಳೂರವರು ತಮ್ಮ ಪತ್ರ ಸಂಖ್ಯೆ ರಲ್ಲಿ ಸರ್ಕಾರದ ಕಾರ್ಯದರ್ಶಿ ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆ ಇವರಿಗೆ ಸಲ್ಲಿಸಲಾದ ವರದಿಯಲ್ಲಿ, since the allotment has to be made for construction of the office for KMF, which is not a profit earning organization,
yes,
and not for any other commercial purpose as being done in case of other government departments. So, my lords, the basis or the premise on which the land was allotted to them on a concessional rate is that It is not indulging any commercial activity, but it is for a private head construction of a head office. Now, my lords, may please have page number 13. There is one subtle fact, my lords, in between. Certain two portions of these lands are given on a long lease earlier itself, but they are given for a big sum of 50 lakh rupees. As way back as in 2008, I have put it in my statement of objection on an affidavit, my lords, at para 9. It is of relevance to note that the present lease is for an amount of in the year 99 itself, my lords, they gave it on a long lease. At that point in time only, they gave it for 50 lakh rupees. That to a small portion of 19 guntas.
50 lakhs for
19 guntas.
50 lakhs per year.
Please, lease amount. It says for 10 years.
For 99 years.
For 99 years, 50 lakhs.
Yes.
In which year? 1999?
1999. And today, my lords,
For a lease period of 99 years.
19 guntas. For 19 guntas. And now here, my lords, 2 acre and 30 guntas is given for a much lesser sum.
99 years and they did not read, my lord. For a period of 99 years.
It is irrelevant, my lord.
For 99 years.
Even otherwise, now what is the lease period, my lords?
For 30 years.
30 years. But even then, my lords, now the acreage is 2.5 acre.
Yes.
Now, my lords, may please come back to page number 13 of the report. At this juncture, my lords, the KMF decides that we are not able to build our main building because of various financial reasons.
Yes, yes.
And my lords, they decide to...
They already constructed their administrative office elsewhere.
Yes.
Yes.
My lords, page number 13 at the bottom, the investigating officer takes note of a certain circular issued by the government saying that when a certain land is given for a certain purpose, if that is not used, you will have to return it back. Well, it's page number 13 at the bottom of the paragraph. Karnataka ಸರ್ಕಾರವು ತನ್ನ ಸುತ್ತೋಲೆ ಸಂಖ್ಯೆ ಸೋ 90 ದಿನಾಂಕ 22/8/1999 ಬೇರೆ ಇಲಾಖೆಗಳಿಗೆ ನಿರ್ದಿಷ್ಟಪಟ್ಟ ಉದ್ದೇಶಕ್ಕಾಗಿ ಕೊಟ್ಟ ಜಮೀನನ್ನು ಸದರಿ ಉದ್ದೇಶಕ್ಕೆ ಯಾವ ಸಂಸ್ಥೆಯು ಬಳಸದೇ ಇದ್ದಲ್ಲಿ ಅದನ್ನು ಸರ್ಕಾರಕ್ಕೆ ಹಿಂದು ಕೊಡಬೇಕೆಂದು ಆದೇಶಿಸಿರುತ್ತದೆ. ಅಲ್ಲದೆ ಸದರಿ ಸಂಸ್ಥೆಯು ನಿರ್ದಿಷ್ಟ ಉದ್ದೇಶಕ್ಕೆ ಕೊಟ್ಟ ಜಮೀನನ್ನು ಬೇರೆ ಉದ್ದೇಶಕ್ಕೆ ಬಳಸುವುದನ್ನು ಅಥವಾ ಮಾರಾಟ ಮಾಡುವುದನ್ನು ನಿರ್ಬಂಧಿಸಿದೆ.
Yes.
ನೆಕ್ಸ್ಟ್ ಮೈ ಲಾರ್ಡ್ಸ್, ಈ ಪ್ರಕರಣದಲ್ಲಿ ಸರ್ಕಾರದಿಂದ ರಿಯಾಯಿತಿ ದರದಲ್ಲಿ ಕಚೇರಿ ನಿರ್ಮಿಸಲು ನೀಡಿದಂತ ಜಮೀನನ್ನು ಕೆಎಂಎಫ್ ಕಾರಣಾಂತರಗಳಿಂದ ಕಚೇರಿ ನಿರ್ಮಿಸಿದ ಉದ್ದೇಶವನ್ನು ಕೈಬಿಟ್ಟು ಸದರಿ ಜಮೀನನ್ನು ಮೇಲ್ಕಂಡ ಸರ್ಕಾರದ ಸುತ್ತೋಲೆ ಆದೇಶದಂತೆ ಮರಳಿ ಸರ್ಕಾರಕ್ಕೆ ನೀಡಬೇಕಿದ್ದು ಸದರಿ ಸುತ್ತೋಲೆಯಲ್ಲಿ ಆದೇಶ ಉಲ್ಲಂಘನೆಯಂತೆ ಕೆಎಂಎಫ್ ವಾಣಿಜ್ಯಕ್ಕೆ ಉದ್ದೇಶಕ್ಕೆ ಬಳಸಿರುತ್ತಾರೆ. Now, my lords, at the bottom of 14th page, last paragraph I want to read.
Yes, page number?
14, my lords, from which I was reading. 14, bottom line. Now, before they sell it, my lords, before they enter into this lease agreement or whatever that is being alleged to be in violation, they take a legal opinion. That is highlighted here. ಕೋರ್ಮಂಗಳದ ಜಮೀನನ್ನು ಕೆಎಂಎಫ್ ಆಡಳಿತ ಮಂಡಳಿಯು ಸಭೆಯಲ್ಲಿ ಪಿವಿಕೆ ಕಂಪನಿಗೆ ಲೀಸಿಗೆ ನೀಡಲು ಟೆಂಡರ್ ಪ್ರಕ್ರಿಯೆಯನ್ನು ಮೂಲಕ ತೀರ್ಮಾನಿಸಿದ ನಂತರ ಕೆಎಂಎಫ್ನ ಅಧಿಕೃತ ವಕೀಲರಾದ ಮೆಸರ್ಸ್ ಕೇಶವಿ ಅಂಡ್ ಕಂಪನಿಯವರು ಅಭಿಪ್ರಾಯ ಕೇಳಿದ್ದು ಕಂಪನಿಯು ದಿನಾಂಕ 17/3/2008 at the bottom of 14 minutes ರಂದು ಕೆಎಂಎಫ್ಗೆ ಬರೆದ ಪತ್ರದಲ್ಲಿ ಕೋರ್ಮಂಗಳ ಜಮೀನು ಸರ್ಕಾರದಂತೆ ಕೆಎಂಎಫ್ಗೆ ಹಂಚಿಕೆ ಆಗಿದ್ದು ಕಂದಾಯ ಇಲಾಖೆಯ ದಾಖಲೆಗಳಲ್ಲಿ ಕೆಎಂಎಫ್ನ ಹೆಸರು ನಮೂದಿ ಆಗಿರುತ್ತದೆ. ಆದರೆ ಈವರೆಗೂ ಕನ್ವೇಯನ್ಸ್ ಡೀಡ್ ಆಗಿರುವುದಿಲ್ಲ. ಈಗಾಗಲೇ ಸದರಿ ಜಮೀನನ್ನು ಲೀಸಿಗೆ ನೀಡಲು ತೀರ್ಮಾನಿಸಿರುವುದು ಕಂಪನಿ ಜಮೀನು ನೀಡುವ ಮೊದಲು ಸರ್ಕಾರದಿಂದ ಕೆಎಂಎಫ್ ಕಂಪನಿ ಹೆಸರಿಗೆ ಕನ್ವೇಯನ್ಸ್ ಡೀಡ್ ಮಾಡಿಕೊಳ್ಳಲು ಅವಶ್ಯಕತೆ ಇರುತ್ತದೆ. After this opinion, they get a sale deed, my lords. And what the sale deed says is also traversed here in this opinion. At the bottom of that page, page number 15, what does the sale deed say? So, my lords, whereas on the request of KMF, the state government issued 2 orders bearing so and so and so and so, dated so and so, granting an area of 4 acres, 14 guntas of land comprised in survey number so and so. Whereas no formal deed was executed by the government in favor of KMF, and in view of it, KMF requested government to execute a conveyance deed in its favor, conveying the property schedules on. Government hereby accept, acknowledge, acquits
Total
KMF.
land you said 2.5 acres.
My lords, originally 4 acres, 14 guntas is given to them. In that, my lords, 2 smaller portions are given in lease in 1999 only. Currently, there is 2 acre odd which is given in this transaction.
Yes.
So there are totally 3 sub units in that entire stretch currently. Government hereby accepts, acknowledge, acquits KMF therefrom. The government as absolute owner hereby grants, transfers, conveys unto KMF by way of absolute conveyance deed 4 acres, 14 guntas. The KMF shall be entitled to hold, possess, build upon, and enjoy the scheduled property thereby hereby sold it, and rents and profits received therefrom, without any disturbance or interference by the government or any other person. Now, next, my lords, Rule 18 and 19, what does the transaction of business rule say and how you deal with such property is dealt with? Because there is a specific averment, my lords, in the complaint saying that in violation of the, without a cabinet approval, the sale deed has been executed. Complaint avermental.
Where has he said that? Objections.
Lords, my whole sum and substance of reading this preliminary report is that whenever there is a complaint in as much as 4 or 5 categories of cases, the Supreme Court has said you need to hold a preliminary inquiry. We have held a preliminary inquiry, and prima facie, from the face of the preliminary inquiry, which is rather a detailed inquiry, there seems to be an issue where it requires that an investigation be conducted. And to that effect, my lords, a report has finally been submitted. My lords may have page number 22 of it. My lords, the learned senior counsel has earlier read a certain portion of it. I only want my lords to come to page number 20 of that report. Whatever is highlighted is the opinion, my lords. And final opinion says, ಆದ್ದರಿಂದ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಅಂದಿನ ಕೆಎಂಎಫ್ ಆಡಳಿತ ಮಂಡಳಿ ಹಾಗೂ ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರು ಹಾಗೂ ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆಯ ಅಂದಿನ ಕಾರ್ಯಪಾಲಕರು ಅಭಿಯಂತರಕರು ಕಟ್ಟಡ ವಿಭಾಗ ಬೆಂಗಳೂರು ಇವರ ಮೇಲೆ ಕಲಂ 13(1)(c)(d) 13(2) PC ಆಕ್ಟ್ ಅಂಡ್ 420 IPC ಅಡಿಯಲ್ಲಿ ಪ್ರಕರಣ ದಾಖಲಿಸಲು ತನಿಖೆ ಕೈಗೊಳ್ಳಬಹುದಾಗಿದೆ. Now this is submitted in the higher ups, my lords, and even a permission to register an FIR is sought. Pursuant to that, an FIR has been registered.
Yes.
So my respectful submission, my lords, is that there is a complaint. The complaint specifically alleges commission of a certain cognizable offense, based on which, just based on the complaint, the FIR has not been registered. A proper preliminary inquiry has been conducted by a designate officer who has submitted that to his higher ups, who have, in a manner known to law, taken note of all the facts and issues involved therein, and in a conscious manner have decided to register an FIR. And even in the FIR, my lords, at this juncture, I would like to point out, my lords, none of these petitioners who are before this court have been named as such as on this day. It is only, my lords, that those are the officers who were responsible for this decision making at that point in time. In these are the organization is what has been noted. My lords have already seen that portion.
Yes.
Now, my lords, my respectful submission is that it is the case of the petitioners, my lords, that now, my lords, other than the first proposition of law, I want to cite a few judgments in support of what is being said, my lords. My lord, State of MP versus Avud Kushore Gupta and others. My lords, may please permit me. Para number 11. I only want to read the relevant portion. As noted above, para number 11, 700 page notes, page number 700. As noted above, the powers possessed by the High Court under 482 of the code are very wide, and the very plenitude of the power requires great caution in its exercise. Court must be careful to see that its decision in exercise of this power is based on sound principles. The inherent power should not be exercised to stifle a legitimate prosecution. The High Court, being the highest court of the state, should normally refrain from giving a prima facie decision in a case where the entire facts are incomplete and hazy, more so when the evidence has not been collected and produced before the court, and the issues involved, whether factual or legal, are of a magnitude and cannot be seen in their perspective without sufficient material. Of course, no hard and fast rule can be laid down in this regard to cases in which the High Court will exercise its jurisdiction of quashing the proceedings. It would not be proper for the High Court to analyze the case of the complainant in the light of all probabilities in order to determine whether a conviction would be sustainable, and on such premises arrive at a conclusion that the proceedings are to be quashed. It would be erroneous to assess the material before it and conclude that the complaint cannot be proceeded with. In proceedings instituted on complaint, exercise of the inherent powers to quash the proceedings is called for only in a case where the complaint does not disclose any offense or is frivolous, vexatious, or oppressive. If the allegations set out in the complaint do not constitute the offense of which the allegation has been made by the magistrate, it is open to the High Court to quash the same in exercise of the inherent powers under so and so. It is not, however, necessary that there should be meticulous analysis of the case before the trial to find out whether the case would end in a conviction or an acquittal. The complaint has to be read as a whole. If it appears that on consideration of the allegations in the light of the statement made on oath of the complaint, that the ingredients of the offense or offenses are disclosed, and there is no material to show that the complaint is malified, frivolous, or fictitious, in that event, there would be no justification for interference by the High Court. Now, my lords, para 13, last one. It is to be noted that the investigation was not complete, and at that stage, it was impermissible for the High Court to look into material. My lords, here, there has nothing happened except for the preliminary report, which is rather detailed, the acceptability of which is essentially a matter of trial. While exercising jurisdiction for it, it is not permissible for the court to act as if it was a trial court. Even when the charge is framed at that stage, the court has to only prima facie be satisfied about the existence of sufficient ground for proceeding against the accused. For that limited purpose, the court can evaluate the material and documents on record, but it cannot appreciate evidence. There is another judgment I want to place, my lords, that now if they may say, my lords, there is a sale deed, there is some proceedings, in that proceedings this happened, the sale deed is given me power. All of this is not to be jettisoned. Here is my case, my lords. Next, the court is not required to appreciate the evidence and conclude whether the materials produced are sufficient or not for convicting the accused. In so and so, it was observed that when the material relied upon by a party are required to be proved, no interference can be drawn on the basis of those material to conclude the complaint to be unacceptable. The court should not act as on an annexures to the petitions under 482, which cannot be termed as evidence without being tested and proved. When the factual position of the case at hand is considered in the light of the principles of law highlighted, the inevitable conclusion is the High Court was not justified in quashing the investigation. Now, my lords, the next one is 2023, volume 6, page number 599. Here, my lords, the broad principles, especially a case where PC Act was involved. I want to highlight that, like the one in the present case. Page number 583, paragraph number 79.
Yes.
Finally, following the above, what is of substantial importance is that if criminal prosecution is based upon adequate evidence and the same is otherwise justifiable, it does not become vitiated on account of significant political overtones and malafide motives. We can say without fear and contradiction, it is not at all case in our country that an individual who is accused of the acts of omission punishable under the PC Act, but has the blessings of the ruling dispensation, it is booked by the police and made to face prosecution. If indeed in such a case, the succeeding political dispensation initiates steps for launching of prosecution against such an accused, he or she is allowed to go scot-free despite there being materials against him merely on the ground that the action initiated by the current regime is malafide in the sense that it, this may not be much relevant. I want to read the next paragraph. Having regard to what we have observed in paragraph number 47 to 50 and to maintain probity in the system of governance, my lords have paragraph number 80.
Yes, proceed.
Page number 80. Having regard to what we have observed above in parasol and to maintain probity in the system of governance as well as to ensure that societal pollutants are weeded out at the earliest, it would be eminently desirable if the high courts maintain a hands-off approach and not quash a first information report pertaining to corruption cases, especially at the stage of investigation, even though certain elements of strong tactics of the ruling dispensation might be discernible. The consideration that could apply to quash of first information report pertaining to offences punishable under general penal statutes, ex proprio virgio, may not be applicable to the PC Act offences. Majorly, the proper course of high courts to follow is cases in cases under the PC Act would be to permit the investigation to take to its logical conclusions and leave the aggrieved party to pursue the remedy made available by law at an appropriate stage. If at all interference in any case is considered necessary, the same should rest on the very special features of the case. Although what would constitute special feature has necessarily to depend on the peculiar facts of each case, interference could be made in exceptional cases where the records reveal absolutely no material to support even a reasonable suspicion of a public servant having intentionally enriched himself illicitly during the period of his service, and nothing other than malafide is the basis of subjecting such servant to an investigation. Now, here is a case, my lords, where there is an explicit allegation being made, and my lords, last one decision, whether, because my lords, at this juncture, a lot of documents are being produced to show that there were some proceedings, some kind of authority given to sell them, the board having constituted a committee and the board having taken certain unanimous decision in its meeting. And in those meetings, they have been given a sale deed, and that sale deed gives them the power to alienate it, to lease it, to make profits out of it. If all of that is true, my lords, an investigation will ensue, and in the investigation, they will be given those reliefs. They can appear before the investigating officer and make out this case as well. Now, my lords, in this last of the judgments, my lords, which is 2020, my lords have that 2023 Supreme Court cases 317.
Yes.
Rajiv Kaurav versus Bhai Saab and others.
Yes.
Lords, para 8. It is no more res integra that exercise of powers under section 482 to quash a criminal proceeding is only when an allegation made in the FIR or the charge sheet constitutes the ingredients of the offences alleged. It should have been no, I'll read it once again, my lords. It is no more res integra that exercise of powers under section so and so to quash a criminal proceeding is only when an allegation made in the FIR or the charge sheet constitutes the ingredients of the offense challenged. Interference by High Court under is to prevent the abuse of process of any court or otherwise to secure the ends of justice. It is settled that the evidence produced by the accused in his defense cannot be looked into by the court except in very exceptional circumstances at the initial stage of the criminal proceedings. It is trite law that the High Court cannot embark upon an appreciation of an evidence while considering the petition filed under 482 for quashing criminal proceedings. It is clear from the law laid down by this court that if a prima facie case is made out disclosing the ingredients of the offences alleged against the accused, the court cannot quash a criminal proceedings.
Yes.
Now, my lords, my to summate my entire submissions, I'll only put this in a few sentences. There is a complaint. Complaint in very succinctly, in a very short complaint, but explicitly alleges that there is corruption, violation of certain established norms in terms of the facts which have transpired. That is, immediately 10 days after the sale deed, it is given to someone else. And from there, it has changed 4 or 5 hands, giving room for a suspicion that a certain government land, which was meant for a government purpose, handed over for a particular purpose, has now been commercially exploited by an entity.
Yes.
And the officers in charge of these decision making are alleged to have committed certain of the offenses under the PC Act, though the complaint does not specifically mention those offenses as such. There is an allegation, my lords, that there is some form of mismanagement and corruption as such. Based on this, my lords, on the face of it, because there is, it does not constitute any offense or alleges, a preliminary inquiry is held. In the preliminary inquiry, lot of documentation is assessed, looked into, and my lords, the preliminary inquiry, we have only given the main report. It has got all the annexures which my lords could see. And having analyzed all of that, a responsible officer has now given the report to his higher ups, who have, after having dwelled upon that preliminary report, opined that yes, an FIR has to be registered. Pursuant to that, FIR has been registered. In the FIR also, none of these petitioners who have approached this honorable court and have stalled the proceedings at the very nascent stage itself have not been named thus far. And one of the learned senior counsel only says that because they were summoned twice or thrice, they have approached this honorable court. My lords, my only respectful submission is the investigation is at a nascent stage. At this juncture, interference by this honorable court is uncalled for. And established principles of the honorable Supreme Court and the law laid down by Supreme Court and this court time and again state that the investigation should be taken to its logical conclusion. And if the petitioners have not committed any offense, they would definitely be absolved of any of the liability as such. My lords, this is the main argument as regards where the learned senior counsel has appeared. My lords, in the other two, I would only add that they have not even been named, my lords. At least because the FIR clearly says officers of the PWD and and KMF at that particular point in time. So the other two petitions are filed by private individuals who are not even public servants.
Yes.
So, my lords, my respectful submission is all of them may be dismissed, my lords.
In the petition represented by the learned senior advocate, he is an employee.
He was an employee who is now retired.
Yes.
He was an employee who is retired.
Was an employee of
KMF.
KMF.
To which the land was given.
Yes.
Lord. Please look at, my lord, who has, my lord, when we look at the factual matrix, my learned friend, of course, has waxed eloquent, saying that, my lord, this judgment, that judgment. I'll point out, my lord, every one of the judgments which my learned friend has given, my lord, has no application here. See, my lord, what exactly had happened. If we are not just take, my lord, my list of dates, what happened was, government, my lord, gave this land so that we could have a corporate office. And, my lord, before I take your lordship further, please see, my lord, what does, my lord, the cooperative society, my lord, Karnataka Milk Cooperative Society consist of? Please come to, my lord, page 33, annexure A.
Or petition.
Petition copy, my lord.
ಇವೆಲ್ಲ ಬೇಡ. Page number?
Page, my lord, it starts at page 33.
Yes.
Please come to page 42. I'll tell your lordships why. The board of directors, my lord, clause 20.1.1, your lordships get that? Page 42 only.
20.26 ಇದೆ 26 point.
I'm sorry, my lord,
20.1
my lord.
that is in page number 42.
42, my lord, correct.
Board of Directors.
Yes, my lord.
Yes.
Who are they? One, elected director from each affiliated milk union. Two, secretary to government, animal husbandry and fisheries department. Three, registrar of cooperative societies. Four, one nominee of the National Dairy Development Board. National Dairy Development Board is the central government organization. Five, director of animal husbandry and veterinary service. My lord, high officials of the government are, my lord, part of this board. One, what happened? The land, my lord, was, we asked for the land. Who? KMF. Why did they ask? Because, my lord, we wanted to build a board corporate office. We, my lord, we're in a rented house, my lord, premises. We wanted a corporate office. We, my lord, sought for the land. Government said, yes, we are giving the land. My learned friend started saying there's no cabinet note, my lord. My learned friend is leading evidence. There's nothing, my lord, in this, in the entire objection that he has filed. Cabinet note illa ant heli illellu bandilla, cabinet munde bandilla. If he, my lord, again points it out, let him show it.
Complaint averment, I read. Complaint averment.
Huh?
Complaint averment. I did not read any document. I read the complaint averment.
Let
at
us
page-
look at the complaint averment. Who has
page
given the complaint?
88.
When was it? 165. Let us.
No, it is only, see, now only the complaint is before us and the preliminary investigation.
My lord,
report.
I'll tell you, lordship.
Nothing more.
Correct. Not only that, these other documents, my lord, of unimpeachable character, your lordships will look into. I'll point out, my lord, my learned friends, my lord, the judgment.
Yes.
There are enough judgment which have held. Even that judgment, my lord, also says, your lordships under 482 can look into, my lord, certain documents. And I'll point out how. Please come to, my lord, the order passed by, my lord, the complaint which was lodged. Before that, let me give you, your lordships, my lord, a sequence of events. We, my lord, were allotted this land.
No, that regarding that, you have already addressed the argument regarding the facts of the case.
My submission to your lordships is, after, my lord, a long lapse of, my lord, when was the, sorry. Come on, notes either, then I will not repeat myself.
Then not only notes, sir, I have already dictated whatever the argument you have addressed.
Very well, my lord. In that event, my lord.
It runs into 7 pages.
Please.
I have not left even.
No, my lord.
one.
I know, my lord. I know that. Your
Yes.
lordships have always been diligent.
That is why I request the learned counsel to address the argument at a stretch. So
That's
that
right.
it will
That
be
is
easy.
true, my lord. That is true. We should have. Adu unfortunately,
ಅದು
ನಾನು ಏನು
ಆಯ್ತು.
ಹೇಳೋದಿಲ್ಲ.
But I have
ನಾವೆಲ್ಲ-
done my homework.
I know that, my lord.
Yes. There is no, not necessary to repeat the same thing very well.
My lord.
Yes.
My submission to your lordships is, the sale, my lord, which took place after, my lord, 8 long years, a complaint is filed. And who, my lord, before whom was it given? ACB. ACP has been quashed by this honorable court saying that, my lord, it is a organization which is of, which is, my lord, absolutely no authority. And who gives the preliminary report? My lord, please look at the preliminary report. ACB inspector. I can understand some high level official, my lord, doing it.
That is taken over by Lokayukta now.
No, my lord.
The division
After
bench order
abolition of
itself,
ACB.
the division bench order itself says all proceedings, lock, stock and barrel are handed over to Lokay.
My lord, locks, my learned friend may have some patience. Lock,
Sorry,
stock
I'm
and
sorry.
barrel may have given it to, my lord, Lokayukta. But who conducted it? By an organization, my lord, which is, my lord, branded as being, my lord, illegal by this honorable court. And who conducts it? Inspector of police. Please look at it. I can understand, my lord, some higher official. And in respect of what? In respect of a complaint, my lord, logged in the year 2017 after, my lord, a long lapse of 8 years. 10 years. Long lapse of 10 years, my lord. This honorable court, honorable Supreme Court has time and again held this kind of a complaint. And by whom? Some interloper. The person who has complained, my lord, says, ಕೋರಮಂಗಲದ ಬಿಲ್ಡಿಂಗ್ ಅನ್ನ 10 ವರ್ಷದ ನಂತರ ಅದನ್ನ ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದು ಸೇಲ್ ಆಗಿದೆ. In fact, my lord,
This was necessitated, my lord, say I've already, my lord, noted it. I don't, my lord, to repeat myself. Just, my lord, 2 sentences. This was necessitated because I also pointed out lands, my lord, which we had started, my lord, people started encroaching into this very land. We lodged the police complaints. If we left it like that, then, my lord, there would have been, my lord, encroachments, and, my lord, people would have, my lord, taken over the entire land. They, in fact, my lord, we faced, my lord, similar situation in Rajajinagar, where, my lord, even now, my lord, the writ appeal is pending. Several, my lord, encroachment, people come and, my lord, put huts, put, my lord, buildings. Therefore, my lord, when, my lord, after 3 years, when NDBB did not, my lord,
Could have surrendered the land to the
my
government.
lord, no, it was a sale. Please look at, my lord, the order that was my learned friend's investigation report itself. It says it was given absolutely, my lord, your lord says asked for a report from the state government. State government says I have sold it. I have sold the land. Sold the land, my lord, with absolute right.
What was the consideration?
My lord, the consideration was at that time, my lord.
Sale deed is dated?
2000. 2000.
Page 93.
893, my lord. Already, 893. Page 93.
2008. It's there in the complaint only. And
2008, my lord.
2008.
The consideration amount?
2,17,000 in the year 90.
50,000 rupees per acre.
It was given, my lord. When was the allotment made? Ultimately, my lord, the allotment.
Page 55 also.
55 money.
That is in respect of 2.5 acres.
Correct. Illa, 4 acres, 7
4 acre, 14 gunta.
I think my learned friend may have some patience. When he argued, my lord, I did not even open my mouth. Please have some patience, have some courtesy.
My sincere.
Otherwise, my lord, it will never end.
4
4
acres?
acres, 14 guntas, my lord. Please come to, my lord, page 55.
Yes.
1998.
Yes.
86, sorry. 86, my lord. My lord, I can tell your lordships. 1965, my lord, in Sadashiv Nagar,
Yes.
the land
yes.
value,
You have
1.5
stated that.
rupees.
Yes.
To say in 2000, my lord, today, the land value is crores, yes. But then, my lord, it is absolutely safe. We get, my lord, rent. We get the land back. Ultimately, my lord, all these must be looked into, my lord. It's not that, my lord, oh, somebody has given a complaint. What kind of a complaint has he given? If your lordship look at, my lord, that complaint by an interloper after 10 long years, he says, oh, there is some golmaal. Other than that, my lord, there is nothing there in the entire complaint. What they do is, they say that, my lord, ACP has inquired into it by an inspector. And he says, my lord, his own report, my lord, if your lordship sees.
Section 17, only super assistant commissioner of
My
police.
lord, please come to, my lord, section 17 of the PC Act, my lord.
In metropolitan areas. Number. Metropolitan, only assistant for persons authorized to investigate.
17, if your lordship come, notwithstanding the contained in the Code of Criminal Procedure, no police officer below the rank in the case of Delhi Police Establishment Act of an inspector of police. Idu inspector of police alla. Yakandre Delhi Police Establishment alla. In the metropolitan area of Bombay, Calcutta, Madras, so and so, an assistant commissioner of police. Elsewhere, a deputy superintendent of police or a police officer of an equivalent rank. Yar madirodilli? Inspector. And what does he say? Yes, KMF shall be entitled to hold. Page 16 of the objection statement itself, my lord, that report says, KMF shall be entitled to hold, possess, build, sell, rent, profit out of. Inspector Madbutto. And after 10 long years?
Bylaws ಅಲ್ಲಿ ಇದೆ ಸರ್ 26.2 ಅಲ್ಲಿ I can lease sell the land also.
In fact, bylaws tav bandre, my lords may look at the bylaws itself. It entitles me, my lord, to purchase, sell, lease, page 43 of the petition copy. 26.2.
Yes.
To purchase, my lord, 26.2, my lord, at the bottom. To purchase, take on lease, powers and responsibilities, function of the board. To purchase, take on lease, give on lease, come sale, or otherwise acquire land, building, value exceeding 25 lakhs.
Yes.
Therefore, my submission to your lordships is, look at the complaint. Who lodges a complaint? Some interloper. When? After 10 long years. One. And nothing, my lord, no whisper except a bald statement saying that there is some golmaal in that. Other than that, nothing else. Page 165, my lord, is the complaint.
Yes.
Here he says, cabinet none more than my lord, please look at, my lord, the so-called inspection, my lord, the report. There's not a whisper that, my lord, there was no cabinet. State government, my lord, your lord says, ask them. Did you execute a sale deed? Answer is yes. Did they, my lord? They did not even say this sale deed is invalid or illegal.
They are not telling anything about this.
But you are not named in the FIR, not
Lord,
in the FIR,
no,
nor in the
I'll tell you,
complaint,
Lordship,
nor in
why.
the
No, my lord,
investigation.
I am because they say, my lord, employees of, my lord, erstwhile employees. Please come to. My lord, please come to please come to, my lord, page 169 ಅಲ್ಲಿ at 180 ಬಂದಿತಾವ್.
Page number?
180, my lord. It starts at 169. ಬಂದಿತಾವ್.
Annexure AA.
AA, my lord, correct. That is the same, my lord, report. ಅಲ್ವಾ? Correct. Police inspector. ಅವನಿಗೆ jurisdiction ಇಲ್ಲ. Because according to my learned friend, PC Act ಅಂತ ಅದು ಯಾವ್ದೋ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಬಿಟ್ಟು ಅದು PC Act ಇದ್ದ ತಕ್ಷಣ ಎಲ್ಲ you have to shut your eyes ಅಂತ ಹೇಳಿದ್ದಾರೆ.
This is only preliminary inquiry.
My lord,
It is not an investigation.
my submission to your lordship says, the fact of the matter is that, my lord, the complaint, my lord, is filed after 10 long years, says
Yes.
that, my lord, the
See, my question is,
yes,
the petitioner is not named anywhere in this proceedings. Not in the complaint, not in the preliminary inquiry report. Nor in the
preliminary inquiry
FIR.
ಇದೆ. ರಾಮಲಿಂಗೇಗೌಡ. Preliminary inquiry, page 180, my lord, second paragraph.
While stating the facts, there is reference to the.
ಅವ್ರ ಮೇಲೆ ಹಾಕಿ ಅಂತಾನೆ ಇದೆ.
ಇಲ್ಲ ತಾವು can I read, my lord? Page 180 ಬನ್ನಿ ತಾವು.
180?
Yes, my lord, second unnumbered paragraph ಬನ್ನಿ. 180. ಮೇಲ್ಕಂಡ ಖಾಸಗಿ ಸಂಸ್ಥೆಗಳಿಗೆ ಆರ್ಥಿಕ ಲಾಭ ಮಾಡಿಕೊಡಲು ಕಾರಣರಾದ KMF ಅಂದಿನ ಆಡಳಿತ ಮಂಡಳಿಯ ಸರ್ಕಾರದಿಂದ ಅನುಮತಿ ಪಡೆಯದೆ ಕನ್ವೇಯನ್ಸ್ ಡೀಡ್ ಮಾಡಿಕೊಟ್ಟಿರುವ ಲೋಕೋಪಯೋಗಿ ಇಲಾಖೆಯ ಕಾರ್ಯಪಾಲಕ ಇಂಜಿನಿಯರ್ ಆದ ಸತ್ಯನಾರಾಯಣ MD ಮತ್ತು KMF ನ ಅಂದಿನ ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರಾದ ರಾಮಲಿಂಗಾರೆಡ್ಡಿ ಅವರು ಕಲಂ 13(1) C13(2) PC Act ಪ್ರಕಾರ ಅಪರಾಧ ಎಸಗಿದ್ದು ಮೇಲ್ನೋಟಕ್ಕೆ ಕಂಡು ಬಂದಿರುವುದರಿಂದ ಸದರಿಯವರ ವಿರುದ್ಧ ಪ್ರಕರಣ ದಾಖಲು ಮಾಡಿ ಕ್ರಮ ಕೈಗೊಳ್ಳಬಹುದಾಗಿದೆ. So, my lord, I am
Yes.
yes. So my learned friend, to that extent, my lord, is not correct, that no naming.
No,
Second.
that query was raised by me.
Please, my lord.
That query was raised by the court. Because in other
no,
in other two matters, they
Correct,
were
correct.
neither the
Other-
public
In
servant.
fact, my lord, ಇದು ನಾನು ಅವ್ರ ಹತ್ರ ಇನ್ಫ್ಯಾಕ್ಟ್ ನಮ್ಮ ಫ್ರೆಂಡ್ ಅದೇ ಹೇಳಿದೆ ಹೊರಗಡೆ, ಇದು ತಲೆ ಮೇಲೆ ಕಲ್ಲು ಎತ್ಕೊಂಡು ಹಾಕೋದು ಅಂತಿದೆ. ನಾವಿಲ್ಲಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದು ಎಲ್ಲ ಆಗಿರೋದು, ಅವ್ರು ಬಂದ್ಬಿಟ್ಟು ಅದು ಅನ್ಕನೆಕ್ಟೆಡ್, my lord. I don't know. Anyway, I don't want to say anything more than that. ಅಷ್ಟೇ. ಪ್ರತಿ ಸತಿ ಬಂದು ಟೈಮ್ ಕೇಳಿದ್ದಾರೆ. My submission is, first, my lord, there is, my lord, enormous delay of 10 years. This honorable court, Supreme Court has time and again held, delay idre, my lord, it has to be quashed. Complaint itself is liable to be quashed. Second is, in this connection, my lord, I'll give you, lordship, my lord, some judgment for my lord's consideration.
ಕೊಟ್ಟಿದ್ದೀವಿ ಅನ್ಸುತ್ತೆ, ಬಟ್ ಒಂದು ಸೇರಿಸಿದ್ದೀನಿ ಸರ್.
ನಾನು ಕಾಪಿ ಮಾಡ್ಕೊಡ್ತೀನಿ. ಇದೆಯಾ?
ಅದು ಬಟ್ ಎರಡು ಸೇರಿಸಿದ್ದೀನಿ.
ಅದು ಇನ್ನೆರಡು ಸೇರಿಸಿದಾರಂತೆ ಲಾಸ್ಟ್ ಅಲ್ಲಿ. ಒಂದೇ ಸರ್ತಿ
ಸಾರಿ, ನಾನು ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಡ್ತೀನಿ ನಾನು.
ಆಯ್ತು, ಡಸನ್ ಮ್ಯಾಟರ್. ಅಥವಾ ಅವ್ರು ಮಾರ್ಕ್ ಗೀಟ್ ಮಾಡಿದ್ರೆ
ಬಟ್ ಅದನ್ನೇ ಮಾಡಲಿ ಸರ್. ಈಗ ಒಂದು ಅಡಿಷನಲ್
ಚೇಂಜ್
ಏನಾಗಲ್ಲ.
ಟೇಕ್ ಬ್ಯಾಕ್ ದಿಸ್. ಒಂದು 2 ಅಡಿಷನಲ್ ಇದ್ದದನ್ನ ಸೆಪರೇಟ್ ಆಗಿ ಕೊಡ್ತೀನಿ ತಮಗೆ. ಅದೇ ಪಾಪ
ಬೆಟರ್ ಅಡಿಷನಲ್ ಅಂತ ಕೊಟ್ರೆ, ಅಡಿಷನಲ್ ಅಂತ ಕೊಟ್ರೆ ಬೆಟರ್.
ಆಯ್ತು, ವಾಪಸ್. ನೋ, I understand, my lord. It's, my lord, ನಾನು ಯಾವಾಗ್ಲೂ ಹೇಳ್ತೀನಿ, ನಾವು ಇಬ್ರು ಇಲ್ಲಿ ತಮ್ಮ ಮುಂದೆ ಎಲ್ಲ ಕುಸ್ತಿ ಮಾಡ್ತೀವಿ, ಆಮೇಲೆ ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ನಾವು ಫ್ರೆಂಡ್ಸ್ ಇಬ್ರು ಹೋಗಿ ಕಾಫಿ ಕುಡಿತೀವಿ. ತಮ್ಮನ್ನ 10:30 5:30 4:45 ತನಕ ಇಲ್ಲೇ ಕೂರಿಸ್ಬಿಡ್ತೀವಿ.
4:45 ಆಮೇಲೆ we will start.
I know that, I know that. My lord, I have always said this openly also, my lord, in any public. ಈಗ ರಜಾ ಕೊಡಬಾರ್ದು ಹಾಗೆ ಹೇಗೆ ಅಂತಾರೆ. I have said this. It's very easy for you to say because judges work starts, my lord, after the court hours. And my lord, 22 high court, Supreme Court ಎಲ್ಲ ನೋಡ್ಬೇಕು ತಾವು. ನಾವು ಎಲ್ಲ ತಮಗೆ ಇಷ್ಟ ಹಾಕ್ಬಿಟ್ಟು ಕೊಟ್ಬಿಡ್ತೀವಿ, ಎಲ್ಲ ತಮ್ಮ ಭುಜದ ಮೇಲೆ ಹಾಕ್ಬಿಡ್ತೀವಿ, ನಾವು ಓಡೋಗ್ತೀವಿ ಆಮೇಲೆ. Please come to my lord the first of the judgments. Delay 89 1 SCC, my lord, page 1 ನಲ್ಲಿ. Please come to my lord paragraph 21. At running page, my lord, 14. Lastly, it was urged by the learned counsel for the respondent in these appeals that on the same principle on which criminal appeal number so and so in the matter of Desraj Singhal was dismissed, these appeals also deserves to be dismissed. My lord, these appeals are filed by the state against, my lord, dismissal of the complaint. So far as the submission is concerned, we find substance as regards the appeal against Kailash Nath. First information report in this case was lodged on 27th of August 1985. That is after about 6 years of the accrual of cause of action or taking place in the event which took place in 1979. And after about 3 years, even from October 31, 1982, when the respondent retired from service. Now in 1988, it would be pursuing a state claim. In this view of the matter, we are of the opinion that the order of the High Court quashing the first information report against Kailash Nath, respondent in criminal appeal number so and so, deserves to be maintained, though on a different. So, my lord, delay of 6 years, in this case 10 years. Now, my lord, look at the second judgment. Please come to, my lord, page 15.
Complaint is dated.
Complaint, my lord, sorry, complaint is dated 19/5/2017. Resolutions passed by, my lord, by the board is 8/11/2007. Tender invited.
Yes.
Registered, my lord, deed of conveyance, my lord, 2007, my lord, is the board resolution, and 2007, my lord, we invited tenders, and my lord, it was agreed to be given to them on lease, long-term lease. So, my lord, second judgment, my lord, please come to page 15, my lord, 15.
Yes.
Para 11 ಗೆ ತಾವು ಬಂದ್ರೆ at running page 19, my lord.
Yes.
This was, my lord, a case where ISKCON, my lords are aware of, my lord, ISKCON. ISKCON, my lord, Bangalore, one Madhu Pandit Das, my lord, was a president. He sold a bus, my lord, belonging to, my lord, ISKCON in Calcutta. Therefore, my lord, a complaint was lodged. Honorable Supreme Court quashed it. Please look at, my lord, para 11. It is again pertinent to note that even as per the case of the complainant, the alleged incident of bus theft, theft complaint
Yes.
had taken place in the year 2001. And it was only in 2009 that the substantial complaint was made in the court of Chief Judicial Magistrate, into Varshad Nantra, Alipur. It's just not believable that the concerned Bailgunj police station, Kolkata, would never have taken any action on the report made in 2002 on behalf of the powerful body like ISKCON, Calcutta, or on the letter dated so and so, written by the branch manager of ISKCON, Kolkata. Respondent number 2, complainant, also did not take any concrete action for getting the said complaint registered with regard to the alleged theft of the bus for a long period of 8 years, till the complaint in the court made, a complaint in the court was made, was filed in the year 2009. In the opinion of the court, such an inordinate delay of 8 years in filing the complaint in the court itself would be sufficient ground to quash the proceedings.
That's my presence may be dispensed. my lords.
Yes, yes.
Obliged.
Therefore, my lord, the 8 ವರ್ಷದ ನಂತರ ಇದು 10 ವರ್ಷ ಆಯ್ತು ಇಲ್ಲಿ. Please come to, my lord, the next one, page 25. Delay must be explained ಅಂತ ಹೇಳಿದ್ದಾರೆ page 25 ಅಲ್ಲಿ. Sorry. Page 25, my lord, 2010, 8 SEC 775. Please come to para 21, my lord, in this. At running page, my lord, 32, Bharat.
Yes,
Prompt and early reporting, page 32, my lord.
yes.
Prompt and early reporting of the occurrence of the first information with all vivid details gives an assurance regarding the truth of its version. In case there is a delay in filing the FIR, complainant must give explanation for the same. Undoubtedly, delay in lodging FIR does not make complainant's case improbable when such delay is properly explained. However, deliberate delay in lodging the complaint is always fatal. So, my lord, delay in lodging the complaint is always fatal. Explanation. If your lordship look at my lord the complaint, not one whisper. He simply says he is, my lord, been filing, my lord, all kinds of things. In fact, ನಾನು ಅದನ್ನು ಹೇಳಲಿಲ್ಲ ಯಾಕಂದ್ರೆ ಅವ್ರು ಸತ್ತೋಗ್ಬಿಟ್ರು. ಇಲ್ಲದೆ ಇದ್ರೆ ಇವ್ರ ಮೇಲೆ there are some, my lord, cases for malicious prosecution. ಅಂದ್ರೆ ಬ್ಲಾಕ್ ಮೇಲ್ ಮಾಡ್ಸಿ ನಾನು ಹೇಳೋದಿಲ್ಲ. ನಾನು ಅಂದ್ರೆ ಅವ್ರು ಸತ್ತೋಗಿದ್ದಾರೆ. So I didn't want to, my lord, bring all that to the phone because
Complainant is only a whistleblower.
please, my lord.
Whistleblower.
ಅಲ್ಲ ವಿಸಿಲ್ ಬ್ಲೋವರ್ ಸರಿ, ಅವರು ವಿಸಿಲ್ ಬ್ಲೋವರ್ ಅಲ್ಲಿ ಆನೆಸ್ಟ್ ಆಗಿ ವಿಸಿಲ್ ಬ್ಲೋವರ್ ಇರ್ತಾರೆ, ಡಿಸಾನೆಸ್ಟ್ ವಿಸಿಲ್ ಬ್ಲೋವರ್ಸ್ ಇರ್ತಾರೆ ಅಷ್ಟೇ. ಇನ್ನು ಅದಕ್ಕಿಂತ ಹೆಚ್ಚು ಹೇಳೋದಿಲ್ಲ, ಯಾಕಂದ್ರೆ ಪಾಪ ಅವ್ರು ಸತ್ತೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಷ್ಟೇ. ದೆನ್ my lord, 1 year's delay itself, my lord, ವಾಶ್ ಮಾಡಿದ್ದಾರೆ. ಪ್ಲೀಸ್ ಕಮ್ ಟು ಪೇಜ್ 34. 34.
Yes.
This was, my lord, a dispute between husband and wife. Please come to, my lord, paragraph 3.
No, between individuals, I can understand delay.
ಅಲ್ಲ ಇದು, my lord,
It is fatal. But here is an institution.
my lord,
Some
institution,
resolutions were taken in the institution.
my lord, my submission,
Outsiders may not know what is happening here.
my submission to your lordship says PC Act ಅಲ್ಲಿ first judgment. That is, my lord, not a, it's similar to ours, 6 years delay. Please look at it. Ultimately, my lord, I'll satisfy your lordship's conscience that there is nothing wrong, my lord, in what has been done by KMF. Page 1 iddu judgment ತಾವು ತಗೊಂಡ್ರೆ it is, my lord, PC Act.
Yes.
para 21 ಅಲ್ಲೇ ತಾವು ನೋಡಿದ್ರಿ ಆವಾಗ. Please come to, my lord, page 4 ಬಂದ್ರೆ ತಾವು your lords get all that. These appeals raise an identical question of law and conveniently be decided by a common order. Kailash Nath, respondent in criminal appeal number so-and-so, was working the executive engineer in the public works department in the state of Punjab. On various dates in that year, he placed orders for purchase of signboards which were required by the department to avoid accidents, so-and-so, so-and-so, so-and-so. Then, my lord, please, tavu, next page, 325 ಅಲ್ಲಿ top, sorry. Against the respondent under sections 1, 2, 5 of the Prevention of Corruption Act. So, my lord, this is also, my lord, under the Prevention of Corruption Act. 6 years delay, this honorable, my lord, the Honorable Supreme Court held, is liable to be quashed. Then, my lord, my lord, when I am, my lord, before your lordships as the erstwhile managing director. MD, my lord, mere bald statement that, my lord, he was the director is not sufficient to quash the complaint. Please come to role of the MD. Role of the MD ತಾವು ಸ್ವಲ್ಪ ಬಂದ್ರೆ bylaws ಅಲ್ಲಿ ಸ್ವಲ್ಪ ನೋಡಿ. Please take, my lord, page 36 of the compilation of judgments.
Yes.
Para 50 ತಾವು ಬಂದ್ರೆ ಇದರಲ್ಲಿ at, my lord, running page 52. As mentioned, sorry, 52, my lord, para 50. As mentioned here in above, High Court heard in giving its own interpretation of the decision in the case of SMS Pharmaceuticals Limited case, which was reiterated subsequently in several judgments, some of which have been indicated here and above, and relying instead on a decision of Rangachari case, the facts of which were entirely different from the facts of this case. It is now well established that in a complaint against the company and its directors, complainant has to indicate in the complaint itself as to whether the directors concerned were either in charge of or responsible to the company to its day-to-day management, or whether they were responsible to the company for the conduct of its business. Mere bald statement that a person was a director of the company, against which certain allegations have been made, is not sufficient to make such director liable in absence of any specific allegation regarding his role in the management of the company. And my lord, if your lordships look at, my lord, the board has to take a decision. In this case, my lord, board has taken a decision.
Only convener of the meeting was when directed by the board or found necessary. 29.2.
Yes.
Please come to, my lord, the next judgment at page 53, 2008, 5 SCC 662. Vicarious liability, my lord, against the director does not exist. Please come to page 53, para 16, my lord. Yeah, let's get that at page 57. The penal code, sorry. Page 57, bottom, my lord. The penal code save and accept some provisions, specifically providing, therefore, does not contemplate any vicarious liability on the part of a party who is not charged directly for commission of an offense. A criminal breach of trust is an offense committed by a person to whom property is entrusted. Ingredients of section 406 are, my lord, they set it out. Then, my lord, please come to para 19. As admittedly, drafts were drawn in the name of the company, even if the appellant was its managing director, he cannot be said to have committed an offense under section 406 of the penal code. If and when the state statute contemplates creation of such a legal fiction, it provides specifically therefore, in the absence of any provision laid down under the statute, director of a company or an employee cannot be held vicariously liable for offense committed by the company itself. In this case, your lordships have seen, my lord, there is a board resolution. Board has, my lord, comprised of, my lord, high officials of the government, secretary, my lord, husband and welfare, husband welfare, animal husbandry department, director of, my lord,
42 page.
registrar of cooperative society, director of animal husbandry, registrar of cooperative societies. All of them are there. And, my lord, I am only a mouthpiece. My lord, they said, go and ask for, my lord, the tenders. Transparency Act, my lord. Transparency Act provides, my lord, that, my lord, we must call for tenders. Tenders were invited.
He appointed as technical consultant.
Yes.
Annexure R ತಾವು ಬಂದ್ರೆ 81, my lord, at 86 ಬನ್ನಿ. Petition copy, my lord. Please have a look at it. Board passes a resolution. My lord, how am I, my lord? I am only, my lord.
You acted on the board resolution.
Yes, my lord.
Yes.
How am I, my lord, responsible? I asked myself, there can't be a vicarious liability. And I called for, my lord, tenders, invited tenders.
Yes.
And before that, my lord, please look at, my lord, we called for, my lord, report, my lord, I think, my lord, your lordships have already noted. Kesvi and Company, one of the leading, my lord, law firms of Bangalore. We asked them, my lord, for an opinion. Can we lease it out? They said yes. Thereafter, my lord, we appointed.
Provided there is a sale deed, conveyance deed.
ಆಮೇಲೆ ಮಾಡ್ಕೊಟ್ರು ಕನ್ವೆನ್ಸ್ ಮಾಡ್ಕೊಟ್ರು 2007 ಅಲ್ಲಿ ಮಾಡಿದ್ಮೇಲೆ ಆಮೇಲೆ ವಿ ಲೀಸ್ಡ್ ಇಟ್ ಔಟ್ 2017 ಅಲ್ಲಿ ಆಫ್ಟರ್ 10 years ಕಂಪ್ಲೇಂಟ್ and we, my lord, invited the consultant, appointed a consultant says, my lord, this is the methodology you have to do. Transparency Act, my lord, if your lordship take, my lord, the Transparency Act, we have to call for a tender. We called for a tender, public notice were issued. My lord, we produced, my lord, that report also. These are all public documents, and I'll point out, these documents can be looked into by your lordships under section 482.
ಅಲ್ಲಿ 75 in the paper publication ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೆ in 73. Yes.
ಮೂಟಿದೆ ನೋಡಿ ಅದರಲ್ಲಿ ಲಿಸ್ಟ್ ಡೇಟ್ಸ್ ಎಲ್ಲ ಸಾರಿ
Property development, the next to paper publication.
Yes.
Paper publication, my lord, also we produce. These are all public documents. In fact, my learned friend, my lord, gave your lordship, my lord, submitted one judgment before your lordship. Can I persuade your lordship? Look at my lord that judgment for a minute. The last of the judgment that he submitted, 2020, volume 3 SCC. Page, my lord, 317.
Yes.
ಅದರಲ್ಲಿ paragraph 8 ಅನ್ನು ಓದಿ ತೋರಿಸಿದ್ರು ತಮಗೆ. It is no more res integra that exercise of power under section 482 to quash the criminal proceedings only when an allegation is made. Sorry, line number, my lord, 1, 2, 3, 4, 5. It is settled law. Evidence produced by the accused in his defense cannot be looked into by the court, except in very exceptional circumstances. What are the exceptional circumstances? Please take, my lord, my judgment compilation.
ಇದು pin ಮಾಡಿ.
Lord, we must always, my lord, put it in a memo, date haki, page haki, yava paragraph. You must assist your lordship. Anyway, I don't
We
want to.
cannot expect anything, sir.
So sorry, we should, my lord, learn all this. And we must assist the court, my lord, in the best possible manner. That's all I can say. My lord, please come to, my lord, page 167. Noora 67.
Yes.
2015, 11 SCC 730. Paragraph 7 ತಾವು ಬಂದ್ರೆ guidelines, my lord, are set out as to under what circumstances court can look into, my lord, documents. We have carefully considered the rival submissions made before us. From a bare perusal of section 482 of code, it is clear that the object of exercising power under the section is to prevent abuse of process of law and to secure ends of justice. Sorry, my lord, 169.
Yes, got it.
Yes. Fourth line I was reading, my lord.
Yes.
Para 7 ali. In Rajiv Thapar versus Madan Lal Kapoor, this court has enumerated the steps required to be followed before invoking the inherent jurisdiction of the court under section 482. Based on the factors canvassed in the foregoing paragraph, we would delineate the following steps to determine the veracity of a prayer for quashment raised by an accused by invoking the power vested in the High Court under section 482. See, step 1. Whether the material relied upon by the accused is sound, reasonable, and indubitable. That is, material of sterling and impeccable quality. Step 2. Whether the material relied upon by the accused would rule out the assertion contained in the charges leveled against the accused. That is, material is sufficient to reject and overrule the factual assertions contained in the complaint. That is, the material is such as would persuade a reasonable person to dismiss and condemn the factual basis of the accusation parts. 3. Whether the material relied upon by the accused has not been refuted by the prosecution or complainant, and or the material is such that it cannot justifiably refuted by the prosecution. Therefore, my lord, these are, my lord, whether the proceedings with the trial would result in abuse of process of court and would not serve the ends of justice. If the answer to all the steps is in the affirmative, judicial conscience of the High Court should persuade to quash such criminal proceedings and exercise the power vested in it under section 482. Such exercise of power, besides doing justice to the accused, would save precious court time, which would otherwise be wasted in holding such a trial, as well as proceedings arising therefrom, especially when it is clear that the same would not conclude in the conviction of the accused. Therefore, my lord, board resolution, my lord, is a public document. We'll have to file, my lord, with the Registrar of Cooperative Societies.
Yes.
The tender invited, public document. Paper publication, public document. We, my lord, invited tenders. All this was, my lord, secretary, high-level secretary of, my lord, the government, director of, my lord, animal husbandry. All of them are.
Land is leased in favor of a private company.
Yes, my lord.
For development.
Correct.
They have constructed commercial.
Constructed a, my lord, it was, my lord, meant so that, my lord, we get rent. We get, my lord, every month.
Quarterly rent 40
lakhs. 40 lakhs of rupees, my lord, we get every quarter. If, my lord, the land was kept vacant, it would have been encroached. People would have, my lord, just gone ahead. And we invited tenders. Tenders, my lord, there were several participants. Theirs, my lord, was the best offer.
The feasibility test was paid. Feasibility test.
And the tender.
Technical evaluation.
Memo with, sorry.
Yes.
Not addition, not the memo with documents and hakidvi. Amatra. Last time, no, under full complete madilla yakandra madhyadalli bandbuttal nanige time beku andru. So I'll just point out that one.
Page 14 Page 14. ನಮ್ದು ಇಷ್ಟೇ ಬರ್ತಿದ್ದು ಪರ ನಮ್ಗೆ ಶೇರ್ ಬರ್ತಿದ್ರೆ ನಮ್ದು if you had developed by putting all this.
Lord, ಇದು feasibility study ಅಂತ ಹೇಳಿ annexure, Lord, page 4 annexure AM ಅಂತ, sorry, my lord got that. Page 4, my lord, of the memo, my lord. We appointed, my lord, a
Feasibility study.
Wilbur Smith, ಹೌದು. Page 4, feasibility.
Yes, got it.
Yes, my lord. Please come to, my lord, page 14. In fact, they gave, my lord, if you develop yourself and if you give it, page 14.
Yes.
Typical developers financials. Total area, my lord, is 124. Capital value so much. Value of the land so much. Rental yield so much.
Yes.
We would have got, my lord, construction is to. Ultimately, my lord, we would have got per year 60 lakhs, 65,000. Now we are getting 1 crore, my lord, 40 lakhs every quarter.
1 crore 60 lakhs.
1 crore 60 lakhs we are getting.
40 lakhs per quarter, per month.
Per quarter. So it will be 1 crore 60 lakhs per year. Here, my lord, we would have got only, my lord, per annum at the top baratte nodi.
Yes.
Absolute top, my lord.
Yes.
Our rentals, financial estimate, KMF
60
would
lakhs
expect
per
to make a floor price of at least 60 lakhs per annum. So, my lord, after all this study, they themselves, my lord, said it is better to invite people. And, my lord, page 19. Bidding process ಹೇಗೆ ಆಗಬೇಕು? What is to be done? Everything, my lord, was placed before the board, approved.
Yes.
I'll tomorrow or whenever your lordship want, my lord, I'll be here. ಯಾವಾಗ ತಾವು ಹೇಳಿ?
How much time in America?
About
ಆಯ್ತಲ್ಲ almost completed it.
ಇಲ್ಲ, ಇನ್ನು ನಾನು ಒಂದು ಸ್ವಲ್ಪ ಇದೆಲ್ಲ ಇದೆ. ನಾಳೆ ತಾವು ಮಧ್ಯಾಹ್ನ ಯಾವಾಗಲಾದ್ರು 2:30 ಅಥವಾ ತಮಗೆ ಯಾವ ಇಲ್ಲ, ನಾನು ಇನ್ನೊಂದು ದಿವಸ ಫ್ರೈಡೆ ಬರೋದ್ರೆ ಫ್ರೈಡೆ ಬರ್ತೀನಿ. ತಮ್ಮ ಚಿತ್ತ. I know your lordship will have fixed already timings.
See, the court officer is finding it difficult to accommodate. Her diary is full.
No, I understand. No. Lord, ನಮಗ್ ಒಂದಿರುತ್ತೆ, ನಿಮಗೆ 100 ಇರುತ್ತೆ. I understand. ನಾವ್ ಯಾವಾಗ ಹೇಳಿದ್ರೆ ಅವಾಗ ಬರ್ತೀನಿ. Friday, Monday, Tuesday, ಯಾವತ್ತಾದ್ರು.
Seventeenth at 2:30. 17th at 2:30.
2:30, I'll be here. Grateful. Interim order to be explained.
Yes. ಆಯ್ತಾ?
Please.